Can you please look up this site?
See if we can figure out something.
Okay. I also had to rush because this judge, I don't think people are here yet, but you might just have to skip back a few seconds to see. This judge deletes things, so we need to move quick, fast. His magistrate says in the chat, Washington Legislature, Order of Alcohol or Substance Abuse Diagnostic Investigation and Evaluation Treatment Plan, and then details the whole treatment plan. So this is obviously about alcohol. Okay. Let's make quick. Because otherwise he ends his lives and we never know the outcome. Drives me insane. Jeez, look at that yawn.
Yeah, thank you.
I was waiting.
There, he's reconnected. Did you guys? Mr. Lewis, I know Mr. Cleary disconnected there. He's reconnected. Did you guys need a breakout room still? Mr. Hodge can put you back together.
Yes, Judge. I was waiting on him to return, but when he didn't return, that's how come I came back to the court.
Yeah, thank you. Limited functionality here today, so we'll get you guys back together.
Okay.
On to Mr. Chapman, and then Mr. Dean and Miss Manarino are here as well.
All right.
Feel the heart now.
Did you need to be in here for Mr. Nahat and the Jun Kai matter?
Yes.
Mr. Nahat, I'm ready to call that when you are. Mr. Hodge, can you put Mr. Cleary and Mr. Lewis back together in a breakout room?
Yes. Yes, I can.
Oh, okay. Thank you.
Okay. I'm going to talk with Mr. Chapman real quick. But
Okay.
I would like to be present when.
SM, People versus Audrey Jun Kai.
Andre Hodge on behalf of the people.
Your Honor, good morning. I'm Ed Nahat on behalf of Audrey Jun Kai, who is seated here in the same room with me. She consents to the Zoom hearing. This is a pretrial conference. Mr. Hodge and I had a spirited discussion in the breakout room, and we're prepared to talk to you now.
All right, Ms. Jun Kai, if you could just state your first and last name for the record.
Audrey Jun Kai.
All right, and how are we proceeding this morning?
Your Honor, if I may, today we're set for an adjourned pretrial hearing. At the last pretrial hearing, you granted my request for an extension because I was looking for further discovery. At that time, I requested, and the people agreed, that I was seeking discovery from a third party, from the telephone company. I then issued a subpoena to Metro PCS, and I haven't received a result yet. I issued the subpoena on June 28th, and I received no response. So I have been contacted on Metro PCS on 2 occasions since then. And then yesterday I sent an email to the contact emailed 4 subpoenas at Metro PCS, informing them that I was going to ask the court for an order to compel, because apparently my own subpoena didn't get their attention. I don't think the people object to the court issuing an order to compel on that particular record, because it's the last piece of discovery that I think my client is entitled to in order to fully flush out the evidence in the case. And we discussed in the breakout room how to proceed procedurally because of the age of the case. And I believe that we agreed that we would request the court to set one more pretrial date and also set a trial date so that we can keep the case on track.
That's correct, Judge.
All right. I don't have any issue with that plan, and I'm happy to sign a motion to compel, especially without that shouldn't be a problem. With regards to dates, so we're on the eve of our trial date here in July. Looking at the calendar, our August trial date is the 26th.
I'm in trial on that day in another court.
Okay.
I apologize, but this is a case that I want to handle personally, since Ms. Jun Kai is a longtime family friend, if you don't mind.
No, that's fine with me, counsel. I know our August date's pretty filled anyway, so that would push us into September, which is the 30th because of the holiday. The fourth working holiday Monday of the month is the 30th, so it'll be 9/30. And in terms of a pretrial, do you want to come back sometime in August?
Certainly.
So maybe set a pretrial 5 weeks out, and then we'll have our jury trial the end of September.
The pretrial date, Your Honor?
I'm going to let the clerks assign it, but in approximately five Fridays.
Oh, on a Friday.
Mhm.
Thank you, Your Honor.
And Judge, I'm just going to indicate at this time that the people's offer to allow the defendant to plead guilty under 769.48 treatment will not extend past the next pretrial date. Past that date, that offer will no longer be on the table.
Okay.
We'll submit the order to compel on Monday for your signature, and we'll have Mr. Hodge get a chance to look it over before we submit it to you, Judge.
All right. I appreciate that, Mr. Nahat. I'll look for that order.
Very good.
I'll sign it when it comes across my desk. Okay.
Thank you both. Thank you, Mr. Hodge.
Take care.
Thank you.
Bonds continued in the meantime. See you very soon.
Have a good day.
All right, Mr. Hodge. You too, Mr. Nahat.
Judge.
Okay.
Ms. Mosley is in the.
All right. Mr. Chapman, are you ready then with Ms. Mosley?
Yes, I believe my client, Ms. Mosley, is in the waiting room.
Yep, I'm bringing her in.
now. Ms. Mosley, can you unmute, please?
Yes.
This is 24-00615 SD, People versus Angela Mosley.
Andre Hodge on behalf of the people.
Good morning, Your Honor. Claude Chapman, P69850, on behalf of Ms. Mosley, who is present. We agree to proceed by Zoom.
Ms. Mosley, your first and last name, please.
Angela Mosley.
All right, this is the date and time set for a pretrial in this matter. How are we proceeding this morning, gentlemen?
Well, Judge, I can indicate that there is a offer from the people. The people would be asking the defendant to plead guilty as charged to count 1 OWI second offense. Count 2 would be reduced to, I think it's just easier if I use the PAC code, MCL 28.425K2B. That's carrying a weapon concealed with a BAC 0.02 to 0.08. I believe that's the terminology from the statute.
Is that a civil or is that a misdemeanor still?
It's still a misdemeanor.
That is correct, Your Honor.
And Ms. Mosley intends to take advantage of that offer, or Is she going to accept that offer?
I'm assuming.
Mr. Chapman is I'm sorry, Ms. Mosley, that was directed to Mr. Chapman. Mr. Chapman, is she going to take that offer today, or how are we going to proceed?
Please repeat, sir.
Is she going to accept that offer today?
Yes, she's going to accept the offer.
Okay. Ms. Mosley, then, if you'd raise your right hand. Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Ms. Mosley, can you read, write, and understand the English language?
Yes.
Can you hear and understand me today?
Yes.
Have you had a full chance to discuss this matter with your attorney, Mr. Chapman?
Yes.
And are you satisfied with the advice you received?
Yes.
You are pleading guilty to count 1, operating while intoxicated, second offense, and an added count of carrying a weapon with a BAC between .02 and .08. The operating while intoxicated second offense is a misdemeanor charge. It carries with it a maximum penalty of $1,000 plus costs and up to 1 year in jail, all of this court's discretion. The carrying a concealed weapon is a misdemeanor charge with the maximum penalty of, is it still a 93-day, Mr. Hodge?
It is a 93-day, and Judge, I'm sorry, I misstated the limit. It is 0.08, but less than 0.1.
Less than 0.1. All right. The maximum fine there is
I believe it's $100, Judge.
okay. All right, the maximum fine is $100, and a maximum amount of jail time on that offense is 93 days. All of that is at this court's discretion. Before you enter those pleas, Ms. Mosley, you should understand you do have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one would be assigned to you at public expense. You have the right to trial, either by myself or by a jury. At that trial, you have the right to confront, cross-examine, and question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, or to remain silent, and no one can say anything about you remaining silent. As you appear before the court today, you're presumed innocent of these charges. Your guilt has to be proven beyond a reasonable doubt. Do you understand, Ms. Mosley, that by pleading guilty, you give up all those trial rights that I just outlined?
Yes.
Once you plead guilty, there'll be no trial. You understand that?
Yes.
Has anyone made you any promises other than the reduction in count 2 or threatened you in any way to convince you to enter this plea?
No.
It's your own choice to do so. Is that correct?
Yes.
Directing your attention then to the date of March 10th, 2024, were you in the city of Royal Oak?
Yes.
Were you operating a motor vehicle on Main Street?
Yes.
Prior to operating that vehicle, had you consumed alcohol?
I didn't, I didn't consume alcohol, but that's what it says. Yes.
Was it another intoxicating substance that you consumed?
I was actually sick that night, and I had took some allergy medicine.
Okay.
I don't know if you want to do a no contest plea, Judge.
No.
Mr. Chapman, I'm just looking through here at a lab report with a blood alcohol content of a 0.11. I don't know if
Your Honor, if you could pass on this matter for a couple minutes and place me in a breakout room with Ms. Mosley.
Okay, Mr. Hodge, if you take care of that, put Mr. Chapman and Ms. Mosley into a breakout room. The court will pass the matter here briefly, and maybe meet with Mr. Dean or Ms. Manarino in the meantime. Okay.
Okay. All right, looks like Mr. Dean is first on my list. So he gets first bite at the apple.
Very good.
we're ready to continue the board there.
0615 SD, People versus Angela Mosley.
Claude Chapman, P69850 on behalf of Ms. Mosley. Your Honor, we're ready to continue the voir dire of Ms. Mosley.
All right. You know what? I think Mr. Hodge wanted to continue to be in here, so I apologize. We should probably wait for him to get back in from his breakout room. So I'm going to pass it again. As soon as he gets back in here, we'll call it and finish up. Okay? Thank you.
All right.
All right, ready to finish up here with Miss Mosley. So Miss Mosley, if you can unmute again, it's 2400615 SD. And appearances, please.
Andre Hodge on behalf of the people.
Ms. Mosley needs to unmute. Okay, thank you. Your Honor, Claude Chapman, P69850 on behalf of Ms. Mosley. We're ready to continue with the placing the plea on the record.
All right, Ms. Mosley, my last question to you was whether or not you had consumed alcohol before you were operating that motor vehicle on Main Street on March 10th of 2024.
Yes.
All right. And did you eventually come into contact with a member of the Royal Oak Police Department?
Yes.
And did they conduct an investigation into your ability to drive?
Yes.
After that investigation, were you placed under arrest
Yes.
and taken back to the police department?
Yes.
And once there, it looks like a blood draw eventually happened. Is that true?
Yes.
All right. And the party is stipulating to the accuracy of that result of 0.11 for the purposes of today's plea?
Yes, Judge.
Satisfied, Your Honor.
All right. And Miss Mosley, did you also have possession of a pistol at the time that your BAC was recorded at a 0.11?
Yes.
All right. Are you satisfied with the plea, Mr. Hodge
Yes, Judge.
and Mr. Chapman?
Satisfied, Your Honor.
Oh, you know what? I failed to ask one additional question. Miss Mosley, were you previously convicted of operating while intoxicated on or about June 20th, 2017 in Ohio's Fremont Municipal Court?
Yes.
All right. The court too is now satisfied. The plea is knowing, voluntary, and accurate. I'll accept the same. Mr. Chapman, I'm going to refer the case file to the court's probation department for alcohol screening and assessment. Given the nature of the charge here, I am going to ask the probation department to screen Miss Mosley for potential entrance into the court's sobriety court program. That's a discussion we can have at the time of sentencing, but I'd like her reviewed for that possibility. And we'll go from there. So Bonds continued, and I will see everybody back here at sentencing, and you'll meet with probation by Zoom in the meantime, Ms. Mosley, okay?
When will that be?
Miss Mosley's been under the supervision of pretrial services at probation department while this matter has been pending.
Okay, by statute, I'm required to have anyone who pleads to an OWI meet with probation and go through an alcohol screening and assessment. Our turnaround on sentencing is pretty good right now. I think it'll be in about a month, and this is something that the statute requires me to do, Ms. Mosley. I have to refer it to probation for the screening and assessment. There's no way around it. I can't do immediate sentencing today. It's got to be after an investigation.
What is the screening assessment?
It's an evaluation. So they'll go through some questions about your history and your relationship with drugs and alcohol, if there are any, learn about your family, your work life, things like that, and then make a recommendation to me on what the sentence should be.
Your Honor, Ms. Mosley will do everything to comply with the requirement.
Okay. We'll see everybody back here then. Thank you, Mr. Chapman. Take care.
Thank you, Your Honor.
Okay.
Is Mr. Dean ready? I'm sorry, you're muted, Mr. Dean.
I'm sorry, Your Honor. Yes, we are ready, Your Honor, for two matters. I have Cheek as well as Miller.
All right, and did you need to be in here on those, Mr. Haj?
On Miller, yes. So yeah, I'll just stay.
I believe Cheek is this wing tech. Mr. Miller, can you hear me okay?
Yes, sir.
All right, this is, if you can enable your video, please, sir. It's 2400997 SM, People versus Leonard Miller.
Andre Hodge on behalf of the people.
Good morning, Your Honor. Michael Dean, P32631 on behalf of Mr. Miller. We agreed to conduct this proceeding today by Zoom.
All right, this is the date and time set for a pre-trial. How are we proceeding today?
Thank you, Your Honor. I've had the opportunity to talk with the prosecutor and as well as my client. What we would like, Your Honor, is to set this matter on the trial docket, but with one more pre-trial. If I may be able to talk with my client, and hopefully we won't have to go to trial, but it looks like we might have to.
Okay. Our next trial date would be the end of August, which is the 26th. Or after that, it would be September 30th.
If I could go with the September 30th, Your Honor.
All right. And then I'll have the clerk set a final pretrial near the end of August, and we'll go from there. Okay?
Thank you.
All right. Bonds continued in the meantime. Take care.
All right, thank you.
We'll be talking this afternoon, Mr. Miller.
Okay, great. All right.
You can, yeah,
All right. And then up next is Mr. Cheek.
correct.
This is 2400807 SD, People versus Cleveland Cheek.
Andre Hodge on behalf of the people.
Michael Dean, P32631 on behalf of Mr. Cheek. Mr. Cheek, please state your name.
Mr. Cheek was here. I know. I can see his wing tech. Mr. Cheek, can you enable audio and video? Can you hear me, Mr. Cheek? I know he's here. Mr. Dean, what are we going to do?
Yeah, thank you. I could waive his presence, Your Honor. Mr. Hague has been very kind. Basically, I sent a letter, but I'm going to need to send a more descriptive deviation letter. And so I'm asking for a short adjournment. Thank you.
All right. I'm going to set this out 3 weeks. Notice will come out in the mail and bonds continued in the meantime. Okay.
Thank you, Your Honor. Thank you for your time.
All right.
Thank you,
Take care.
sir. All right.
You.
I think Miss Manarino's next. She's been here quite a bit, so if you can meet with
Yes,
her.
she is.
All right.
Okay. I'm gonna jump in.
Mr. Cheek, you're all set to go. Just reach out to your attorney. You'll get notice of the next court date in the mail. Mr. Lewis, again, good morning. I'll just need to wait for Mr. Hodge to get back in here after his meeting with someone, and then we'll call Mr. Cleary's case, unless you needed him again in the breakout room.
I'm gonna need to speak with Mr. Hodge for probably 1 minute, and then I'll see if we will proceed forward, Your Honor.
Okay. All right. Sounds good.
Okay.
Miss Kruger, good morning.
Good morning, Your Honor.
We're struggling here with our systems down with this Microsoft thing, and I don't have a listed attorney on Mr. Dinkins. Do you know who it is?
I don't. No one has contacted me, nor could I determine if there was one.
Okay. I think we may be able. Is that you, Miss Blakey? By any chance?
Yes, I was just going to ask, I don't have my glasses on, but can I speak with my client in a breakout
We
while I'm waiting
can.
on Mr. Hodge?
Unfortunately, I can't do it from my iPad. So as soon as Mr. Hodge gets back in here,
Oh,
I can put you
okay.
back together. That's why things are. It's real slow today.
I just read about that. Okay.
Yeah, it's frustrating. I'm sorry, but we're moving along.
Oh, no, that's okay.
Yep. Yeah, Brown. I don't have an attorney on that one.
It's Kathleen, so.
Ms. Manarino, are you ready?
Yes, Judge, thank you.
All right. Get Mr. Taylor in. All right. Mr. Taylor, can you hear me okay?
Yes, I can.
Can you turn your video on, sir? This is
Yes.
24-0-1166 FY, People versus Kevin Taylor.
Andre Hodge on behalf of the people.
And good morning, Maria Manarino, P39531 on behalf of Mr. Taylor, who's present via Zoom and consents to proceeding via Zoom. Mr. Taylor, go ahead and identify yourself for the record, please.
Kevin Taylor.
All right, Judge, totally my fault. I totally apologize to the court. I dropped the ball. I was waiting on the prosecutor. He was waiting on me to submit some information. So I apologize, but I'm going to have to ask the court to set this over for no more than 2 weeks.
And in fairness, I was also waiting for information from officers, so it's not Ms. Manarino's fault.
Oh, thank you. I appreciate that.
It's no worries at all. We'll adjourn it for 2 weeks, send out notice, bonds continued, and we'll see you back here then, hopefully for a much quicker docket call in 2 weeks.
Perfect. Thank you. Mr. Taylor, you can sign off and we'll be in touch.
Okay.
All right.
Mr. Hodge, I think Mr. Lewis needed you again, and then there's also Mr. Stammel, Mr. Cash, Ms. Blakeney, all ready for you.
All righty.
Do you have Joey Phillips' number?
Okay, I was not able to get in touch with Ms. Blakeney. So I guess I will go to.
Oh, I think she's here.
Oh, no.
Okay, never mind.
She's like, no, don't skip over me.
Hey, yeah, got a couple of things. Here, I'll come talk to you in a little bit. Okay. Oh, okay. All right. All right. Okay.
All right. Ms. Blakeney's ready then?
Well, I think she needs to talk to her clients.
I do.
Henderson.
Yeah, okay, I'm gonna go with Kyle's iPhone. That looks like a
Yeah.
likely candidate.
And I'm gonna have you meet with Mr. Phillips here right away because the jail's been waiting and they're gonna leave soon.
Okay. All right.
So have Mr. Phillips be next, please. So if you can get Miss Blakeney in with Kyle's iPhone. Mr. Phillips, you'll meet with Mr. Hodge next. Miss Solomon, good morning.
Good morning, Your Honors.
And we will work our way through the list here.
Good morning, Your Honor. Sorry, I had the wrong time on my calendar.
That's okay. We're gonna get you with Mr. Hodge right away because the jail's
All right, thank you.
gonna fill it up.
Your Honor,
Yes.
I don't need a breakout room, just so you know, with my
Okay.
client.
Do you need Mr. Hodge, though, the prosecutor?
We're gonna waive the exam, and I've already talked to my client about it.
Okay. Mr. Hodge, why don't we do that real quick then?
Okay, which one is this?
It's on
Brown?
Brown. I'm sorry.
Justina Brown?
Yes.
Yeah.
Okay, all right, that's fine.
That's your.
Is anyone in the courtroom Spanish speaking only? No? You are? Exactly.
Okay, Marcos, ready?
Yes, Judge. Ms. Tamez.
Tamez, come on up.
Need a translator or no?
Yeah.
Who is it?
Tamez, Tamez.
Come up, ma'am. Jacqueline TZ. Ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On October 6, 2023, officers were dispatched to a criminal mischief cell in Harris County, Texas. Officers made contact with a complaining witness who stated the defendant threw a brick at his residence's window, causing it to break. The damage to the window was approximately $300. Officers also spoke to the defendant's mother, who confirmed the defendant was present at the location during the time of the incident.
Okay. Marcos, who is this? You know,
I'm sorry?
the defendant,
Yes,
the
it
complaining
is.
witness, who is it?
Her mother owns a property and there's a mobile home on that property. And it's the person who lives in the mobile home.
Okay.
So
Do they
I've already
own the
spoken
mobile
with
home
her.
or what?
Do you guys,
Hang it
does your
out.
mother own the mobile home?
No.
No, so he owns a mobile home. Judge, this occurred back on October of last year, so that's why the cause number is a 248 cause number. I'm gonna talk to the states. My understanding in terms of the damage, that's been resolved. So we'll see what we can do to quickly resolve this case.
Oh, yeah, it's an old case. Okay.
Yes.
Ms. Thomas, I'm going to order you as a condition of your bond not to go back to this place and not to have contact with the complaining witness. You understand? Excuse me, also not to be in possession of any weapons. As long as you can abide by these conditions, you'll be fine. If I find that you violate this, start going over there or try to have contact with the complaining witness, I'll order your arrest, put you in jail. You will not get any more trial bonds. You have Marcos representing you. Listen to him. He will take care of you. I will waive your appearance momentarily while you guys try to work this thing out. But if you pick up a new case or start acting a fool in the free world, that's it. You understand, man? Okay. I'm gonna have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go, man.
Thank you, Judge. Have a excuse?
Yes, sir.
Thanks, Judge.
Right this way. Page 1, Robinson, Roderick, come on up.
October 6, 2023, officers were dispatched to a criminal mischief cell in Harris County, Texas, to confirm the defendant was
Owns a property and there's a, so that's why the cause number is a 248 cause number. I'm gonna talk to the states. My understanding in terms of the damage, that's been resolved. So we'll see what we can do to quickly resolve this case.
Oh, yeah, it's an old case. Okay.
Yes.
Ms. Thomas, I'm going to order you as a condition of your bond not to go back to this place and not to have contact with the complaining witness. You understand? Excuse me, also not to be in possession of any weapons. As long as you can abide by these conditions, you'll be fine. If I find that you violate this, start going over there or try to have contact with the complaining witness, I'll order your arrest, put you in jail. You will not get any more trial bonds. You have Marcos representing you. Listen to him. He will take care of you. I will waive your appearance momentarily while you guys try to work this thing out. But if you pick up a new case or start acting a fool in the free world, that's it. You understand, man? Okay. I'm gonna have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go, man.
Thank you, Judge. Have a excuse?
Yes, sir.
Thanks, Judge.
Right this way. Page 1, Robinson, Roderick, come on up.
So can you guys, no contact, no weapons, no going? Thanks. Victoria, who is this?
Page 1, Robinson.
Got it. So how many times has this dude evaded us?
There were 2 PR bonds posted. This is the second one.
Yeah, I'm not done with him getting multiple PR bonds like that.
Hold on.
Case is 351 days old. You get PR bond after PR bond. I don't think so, Mr. Robinson. No, I will appoint you a lawyer today. He goes with you. Can you please appoint him someone and then we'll talk? But ma'am, don't send him down. Yeah.
Page 1, Applegate.
Don't send him down though. Yeah, thanks. Good morning, Mr. Applegate. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 13th, 2024, officers conducting routine business checks due to burglaries because of lack of electricity because of Hurricane Beryl. Officers checked out on a suspicious male at a Goodwill that was closed at the time. The defendant was observed by the officers to be placing items in his vehicle. They made contact with the defendant and conducted a Terry frisk, which discovered 2.6 grams of marijuana. The defendant said he was picking up scrap metal from outside the location, and the defendant had a felony warrant for burglary of a building.
Okay, so this isn't, because I see that he's got an open burglary of a building. This is, don't say anything. I don't need your help.
It's unrelated. It's a separate transaction.
So I guess they didn't charge him with anything as far as their.
Correct.
is
The
concerned.
burglary of the building was April of last year, and he was on the warrant for that case at the time. He's posted bond.
So where was the weed in his pocket?
In his pocket.
Can you tell me about the burglary of a building, please?
Good, 2023, 7110 Barker Cypress Road. Responded to Rainforest Car Wash. Spoke with the manager. Said the defendant was a former employee, had broken into the business and stole vacuum and buffer. Victim said the defendant came back and asked for his job back. Manager showed business surveillance to the police of the defendant pulling up in his Lincoln Navigator, forcing his way into the business and taking the property.
Mr. Applegate, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or dope, I will put you in jail, and I'm going to make your bond extremely high. Do you understand? My sole purpose in life is to protect every single person and every single piece of property in Harris County. If I find that you act like a fool while you're out there in the free world, I will take it away from you in a heartbeat. Do you understand? I don't care what you're doing. I don't care where you're going. I don't care who you're with. You endanger my property. You endanger my public. I'm gonna light you up. Do you understand? What do you do for a living?
I'm unemployed right now. Right now, I'm doing clean up, like cutting the trees down and everything like that because of the storms.
Do you have a full-time job? It's time for you to get a full-time job. You have way too much time on your hands and you are becoming self-destructive. All you're doing is you're picking up more cases, doing stuff you shouldn't be doing. Do you understand? I will appoint you a lawyer today. I'm going to bring you back in 2 weeks and I want to see what you have done to get a full-time job. If you've done nothing, it's just not going to go well for you. Do you understand me? I don't know if there's an application on file or not. Deeps is not working again. For now, I'm gonna have you go to Victoria, sign a reset. After that, I'm gonna have you take a seat in the jury box while I find you a lawyer. After that, you're gonna meet with Tracy for your bond conditions. You are now on notice. I'm telling you, if you don't have anyone to pony up a $10,000 to $15,000 bond on you, you will be stuck like Chuck in jail until this case is over. Behave yourself. Do you understand? All right.
Judge, that was 2 weeks to get a job?
Yeah. Well, to see what he's done to get a job. Be back here in 2 weeks.
The state's bond conditions?
No, with Tracy. Make sure that he's not using.
All right, next judge is page 3. Frosto, come on up.
Tracy, I'd also like you to put on the bond conditions that he's not allowed back to where that Salvation Army was, or the Goodwill. Right. Well, no, not the felony one, just the one. Yeah. Is this Diaz Canales? No,
This is Frosto on page 3.
got it. Are you Raul Gabriel Frosto? Mr. Frosto, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 13th, 2024, officers were dispatched to Connie's Seafood Kitchen in regards to a disturbance between a man and woman. Reporting party said a diner in a blue shirt threw a plate of food at his female companion. The security guard pointed out the defendant and it matched the description given. After an investigation, the defendant was placed in custody for a Class C assault, but found 0.1 grams of
Alprazole. Xanax.
in a powdery form in the pocket of the defendant.
Powdery form. Mr. Frost, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? If you violate these conditions, I will put you in jail. You will not get any more PR bonds. So did he end up getting charged with a Class C assault or not? What do you do for a living, sir?
Actually, for the last 7 years, I worked for Sunbelt Rentals. So I gave material for the plant.
Are you still working full-time? Okay, we're gonna reset your case to give you time to hire a lawyer. So I'm gonna first have you go to Victoria, sign a reset. After that, you'll meet with Tracy for your bond conditions, and after that, you'll be free to go. Don't pick up any new cases. Don't violate conditions, and you know what happens. Okay.
Right this way. Next judge is page 4, Gonzalez Adam.
I asked the arresting cop to be here, and he wasn't here.
Okay, that's not now. That's later on after your lawyer and you've met and gotten all the evidence. Adam Lucas Gonzalez. Mr. Gonzalez, you're charged with driving while your license is suspended. Put your arms down by your side. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Okay.
On July 14th, 2024, officers conducted a traffic stop on a vehicle with an inoperative brake light. The defendant was ID'd as the driver. Additionally, the car's registration had lapsed in 2020. The defendant advised he did not have insurance and that his license was invalid, and officers confirmed that.
Got it. Mr. Gonzalez, you do not have a license, do you?
It's not valid. I have a license, but it's not valid.
Then you are not allowed to drive. I am making that now with bond conditions, and I will have you sign a promise with me today that you're not to drive. I don't care what your excuse is, that you cannot justify getting in a car for any reason. If you do, you will be doing a substantial amount of time in jail. You understand? If you want to drive, go get a license and insurance. And then if you can do that, I will take this restriction off of you. But I find that you drive, you'll be facing a very, very heavy penalty. I'm gonna have you come up here, swear to us that you're not gonna drive. After that, I will get you to Victoria. We're gonna have you sign a reset. We're gonna get you out of here to hire a lawyer. Come on up.
Next is page 5, Gonzalez Jennifer.
Jennifer Gonzalez. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On July 11th, 2024, officers were charged to Dollar General in Harris County, Texas, in reference to a theft. Upon arrival, the store manager advised that a female wearing a black tank top and blue shorts attempted to steal melatonin and then left in a green Dodge Ram truck towards Walgreens. The manager wanted her trespassed. Officers located the green Dodge, and upon arrival, officers observed the vehicle parked, stationary, on and running, and the vehicle's keys in the ignition. Officers observed the female described and approached the vehicle and advised the female to exit the vehicle. While the female was exiting, officers observed her to be very disoriented, unsteady on her feet, and unable to keep her balance, displaying heavy slurred speech, leading to officers to believe she was intoxicated. They noticed an unlabeled clear orange bottle with different sized pills in the middle console under the radio and a change holder within plain view. The defendant was detained and PC search was conducted. The unlabeled pill bottle contained a total of 15 pills. 2 of them were oxycodone, 11 were clonazepam.
Clonazepam?
Cool.
Clonazepam.
Thank you. Sorry, Your Honor. And
Clonazepam, something like that. Okay. What
and
else?
2 of them were unable to be identified, but were believed to be MDMA. The defendant was Mirandized, and she stated she would not answer questions, or she advised she will answer questions, and in that the pills were her friends. While speaking to the defendant, there was no odor of alcohol, but the officers observed heavy, droopy eyelids. The defendant appeared drowsy and drunk-like behavior and slow, sluggish reactions. Standard field sobriety test was conducted. 6 of 6 on the HGN. 1 leg stand was a 2 of 4, and the defendant was unable to do the walk and turn due to knee pain. DIC was read. She consented to blood, and blood was drawn.
Ms. Gonzalez, do you have a Texas driver license?
No, sir. May I say something?
You may not. The only thing I'm going to tell you now are 2 very valuable things. Number 1, you are not allowed to drive. I don't care what on earth you are doing. I don't care if aliens abduct you and tell you that you have to drive somewhere. If you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine because I will hold you in contempt, slap you with 180 days. And I'm going to tell you now, if you have a drug or alcohol problem, you better address it, because if you don't, I'm going to do it for you.
I don't, sir.
If I drug test you now, what's going to show up?
Whatever that is, because somebody, the friend I'm talking about,
I'm
drugged
not going
me.
to talk to you about the case.
Yeah, okay.
No one forces you to take anything. So if I drug test you right now, what's going to show up?
I have no idea what he gave me.
We're going to do it right now. Tracy, I'm sending you for a drug test right now. You must come back. If you do not, I will issue a warrant, and I'm going to make your bond $10,000. Do you understand? Before we leave here right now, I will have you sign this affidavit promising me you're not going to drive. I'm sending you for a drug test. You must come right back. I will appoint you a lawyer today, and we will speak about how to go further. As it stands now, no drugs, no alcohol. I'm going to test you like crazy, and I'm telling you, if I find that you're using, I will hold you in contempt, slap you with 180 days.
I wasn't doing anything. I haven't in years, since the last time I got in trouble with problems.
I want to make sure going forth here, you are not using any pills, any alcohol, any marijuana, any cocaine, any meth, and I'm going to test you 2 times a week to make sure that you're not using. As it stands now, I want to know what is in your body, so I'm sending you for a drug test. You were to come back right afterwards. All right, come up here, swear to me that you're not going to drive. And then after that, we'll send you for a drug test. Up here. Hold on a second, we gotta wait for the clerk, so just stay right here and we'll wait.
Page 12, Renee, come on up.
Good morning, Your Honor. May I approach?
Hi, Mr. Fleming. Good morning, happy Friday.
Happy Friday.
Oh, also, I forgot to tell you, because it's a second offense, I'm ordering you to put a scram device on your ankle to prove to me that you're not consuming alcohol. Okay, who do we have?
Eli Renee.
Page 12.
Good morning, Mr. Renee. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay.
On July 6, 2024, officers conducted a traffic stop on a vehicle going 51 in a 35-mile-per-hour zone. The driver was ID'd as a defendant by his Florida driver's license. Upon contact, officers observed a strong odor of alcohol on the breath, red, glossy eyes, and slow speech. The defendant tried to not speak and initially said he did not drink, then said he had a little, then he said he had a shot at 3 p.m., then he said he had 1 or 2, but then said he only had 1 drink. He stated it was his birthday and he was going to 2727 Lounge, which is a bar. Standard field sobriety tests were conducted, 6 of 6 on the HGN, 4 of 8 on the walk and turn, and 3 of 4 on the 1-leg stand. The defendant attempted to bribe the officer to let him go until the officer informed the defendant of the consequences. DIC was read.
What was the bribe? Does it say? We had one not too long ago. They charged him with felony bribery for the same thing. All right, go ahead.
DIC was read, breath was refused, and a warrant was executed and blood was drawn.
I zoned out. Why the stop? What was the stop?
It was 51
Oh, that's right. You said that. Okay, I remember. All right, one more thing. Can you see, does he have any prior DWIs?
The only thing we found was disorderly conduct from Florida.
Okay. Does he have a valid license? Can you see?
Not a Florida driver's license, so I don't think we can even run that, but I can ask.
Mr. Renee, I'm going to find that there's probable cause to go forward with the case. Where do you live now?
I live in Florida, Pompano Beach, Florida, Broward County.
So are you going back to Florida now?
Yes.
Yes, sir. He just got off the
I
plane.
just got off the plane. I had to go to,
He had a lot to deal with
I had a lot
yesterday,
to deal
canceled
with.
flights and different things. So it was a big mishap. I don't know if you heard about it, but he was able to make it here. He is going back to
Good
Florida.
job making me here.
yes, thank you.
Now, look, you have a lawyer. Good job. Because you have a lawyer, I will waive your appearance. Meaning you don't have to come to court every month to check in and stuff, but I am going to randomly test you. So if you're in Florida and you get called to take a drug test, you must go to a Quest Diagnostics, take a test and get it to Mr. Fleming and they will get it to us. You understand? I am ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're consuming alcohol or any kind of dope, I will revoke your bond, put you in jail. You understand?
Yes, Your Honor.
Okay. Do you have a valid Florida license?
Yes,
Do you have valid liability insurance in your name?
yes, sir.
Okay. We're going to reset your case to give you time to fight the case. So for now, I'm going to have you go to Victoria, sign and reset. After that, you'll get retraced for your bond conditions. And after that, you'll be free to go. Stay in contact with Mr. Fleming. If he tells me that you've gone AWOL and that you're playing games, not responding to phone calls or text messages, I will issue a warrant for your arrest. You will not get any more PR bonds from us. Do you understand, sir?
Yes, Your Honor.
Okay, guys. Good luck.
Thank you.
Thank you, sir.
Right this way. Right, Judge, page 6, Gutierrez. Gael, come on up.
Are you Gael Gutierrez? Mr. Gutierrez, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Sure.
On July 12, 2024, officers in plainclothes unmarked vehicle observed a vehicle and followed it. After they observed the vehicle failed to complete a complete stop at an intersection and drive 55 and a 45 and changed lanes from lane 3 to lane 1 suddenly. Officers conducted a traffic stop and there was an AR-15 style pistol in the
AR-15.
in the backseat floorboard in plain view. The driver said he purchased the weapon for a private sale and he is 19 years old.
Mr. Gutierrez, no, sir. You are not allowed to have weapons. If I find that you have any more weapons, I'm going to put you in jail. I'm going to make your bond so high you're going to flip. No reason. You understand? At 19 to have an AR-15.
I understand, sir.
Do you have a Texas driver license?
No, sir, not at the moment.
Things are not going well for you, Mr. Gutierrez. So help me, if I find that you become a public danger, I'm telling you now, I'm going to lose it. And if I lose it, you will be on the wrong end of that. Do not drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what is going on in your life. You drive, I will have a contempt hearing. You'll be facing up to 6 months in jail and a $500 fine. Every time you drive, it is an offense in and of itself. So if you drive 5 times, I will have 5 different contempt hearings. You understand?
Yes, Your Honor.
That also goes for weapons as well.
Sure. Sounds good.
What do you do for a living?
I currently work at Chick-fil-A, sir, and I go to school at University of Houston downtown.
What are you studying?
I'm studying petroleum engineering, Your Honor.
You know what? I want to make sure that you're not using anything. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, and I'm going to randomly test you. If I find that you're using any kind of alcohol or dope, likewise, I will put you in jail. Do you understand? If he's willing to do all this, something tells me that I'm now going to test you like crazy to make sure that you're not using. If you're going to school truly, because I don't know, you could be, peeing on my leg and tell me it's raining. I have no idea. Picking up criminal cases, it's not going to help you. You are digging a hole. The more criminal cases you pick up, the deeper hole you dig. And I'm going to tell you that employers don't like people with criminal convictions. They're not going to give them a job. You'll have a hard time getting an apartment. You want a school loan, FAFSA loan, not with a criminal conviction, you won't get it. So straighten up and fly right. Otherwise, you will be learning with me behind bars.
Yes, Your Honor, I understand.
All right, thank you, Ed.
Thank
Good
you.
luck.
Eric, do you have an arraignment?
Hey, so Tracy, you got that right on Mr. Gutierrez? No. Hi. Do you have an arraignment? Okay,
Last name is Moore.
okay, mind bringing them up?
What's the last name? Moore.
Judge, there was a co-defendant on this one, page 11.
Yes.
Robert Moore, come up. And Victoria, who is the co-defendant?
Jones, but it wound up in felony one.
I think the last name is Owen.
Kevin Owens. I saw Jones on the information. Sorry.
You're not going to be happy with me after this is over with, Mr. Moore. I'm going to tell you that. You're laughing and smiling now. You now picked up. You picked up a new case while you're on bond. You now are charged with possession of marijuana. And as I can see, this is your 1, 2, 3, 4, 5th marijuana case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On July 13th, 2024, officers conducted a traffic stop at approximately 1:49 a.m. on a blue Charger parked on the side of the road with multiple individuals hanging around the vehicle. And the vehicle also drove off and failed to signal while making a right turn. The driver was ID'd as Robert Moore. The passenger was ID'd as Kevin Owens. Officers observed a strong odor of marijuana from the vehicle. A large bag was in the back seat containing multiple prepackaged marijuana baggies. Neither defendants claimed ownership of the baggies, and the total weight was 22.1 grams.
So what were they doing?
They were on the side of the road, hanging outside of the vehicle, and then they drove off and failed to signal while making a right turn.
Okay, so that's what led the cops led them to pull them over. Mr. Moore.
Yes, sir.
I'm going to find that there's probable cause to go forward with your case. What is the one thing I asked you not to do?
Catch another case.
What did you do?
Catch a case.
Guess what happens now? He goes with you. Sorry, man.
Your Honor, isn't it, can we approach the court right now asking for a bond?
Yeah, I mean, of course, I'm going to send him a bond.
And even in regards to, I know it's a couple of cross hearings, but I know they're saying that he made a right turn. We're still waiting for dash cam, but the biggest issue that they were saying was that the gas station he was at is a high crime area.
I don't care about that.
Thing was just him having people around the vehicle.
I mean, ultimately, they pull him over. He's slinging, you know what I mean? So I'm not happy. And it's his 5th weed case. It's over and over and over, and he's not getting it. So what do we do to get him to get it? You know, I don't know.
And I will say, I know that there's been a gap in time. Like, I think his last charge he had was from 2018, and then just had these recent 2. And I think the biggest thing is just the company that he's keeping. And we talked about that before. I just was recently returned.
I get it. And so what we'll do is that once he gets out, we will try to, well, not try to, I'll make it a condition that he's not to hang around with any of the co-defendants or anything like that. And we'll see. Hopefully he can abide.
And I told the court will provide I know it said the defendant didn't take ownership, but the other defendant Owens has. And so I'm just waiting to get that from the court so that he take ownership of the drugs that were in the vehicle.
Okay.
So I'll get that to the court.
So what did he get? What did the co-defendant get charged with?
Possession of marijuana, 4 ounces to 5 pounds. It's in the 182nd.
Okay. All right. Well, I guess so what's going to happen is he'll pop back up on Monday's docket. I'm assuming he's gonna bond out because I'm not making it super high. If he is still if he hasn't bonded out, he'll be here Monday morning. If not, he'll be here in a week and we'll probably see him next Friday. Yeah, thanks. 5,001. Yeah.
5,001.
One, yeah, on the UCW, please.
Oh, on the UCW.
Just on the UCW, correct. I will leave the first bond for the week kids. I'll leave it alone. Okay, thanks. Sorry.
No problem, I understand. You can do your job.
Judge, page 6. Henderson, come on up.
You Kenneth Henderson. Mr. Henderson, you're charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 11, 2024, officers were dispatched to an assault in progress call at a park. When they arrived, the two parties matching the description were already walking away. Officers approached the defendant, who provided his name, Kenan Henderson, 6206, date of birth. Officers were unable to get a hit and asked him to re-verify. The defendant stated.
Again, what's he doing wrong at the park?
There was an assault, Your Honor.
Oh, there was an assault.
There was an assault call in progress, and the defendant
Oh.
and the other party matched the description.
Got it. Okay.
Officers were unable to get a hit and asked him to re-verify. The defendant stated it was correct and that he was 18 and never had a TCID and a Texas ID and did not know his social security number. He got upset and stated he wasn't lying. The defendant gave his mother's phone number to verify, and she gave the true information. The defendant gave a false date of birth and concealed that he was 21 years old, dating a 16-year-old.
So the information he gave was just the wrong date of birth? What happened with the assault investigation? Was there an actual assault?
That's what they were dispatched to, Judge. I'll have to do some follow-up, but we didn't charge them with an assault or anybody else. From what I see.
And so you're saying that in the call for the assault, he matched the description?
That's correct, Judge. That's what's being alleged that it is.
All right. Mr. Henderson, I'm going to find that there's probable cause to go forward with your case. So you're 18, correct? Or how, are you 19? How old are you?
21.
What do you do for a living? Nothing?
NRZ, with Andy Fern.
Did you graduate from high school? Why not? What grade did you make it to?
12.
I mean, you're almost there. Why didn't you follow through, man? You just dropped out on the last year. Why? It's time for you to go back. And I want to see you go back. And I am now making that a condition of your bond that you and I together are going to try to get your GED. You cannot roll around life with, at the very minimum, a high school diploma. You will go nowhere. You will make pennies on the dollar for the rest of your life. This life is a journey, and it can be a great journey, or it could be an absolute miserable, rotten toilet of an existence. And I'm going to tell you, if you have no money, it's going to be a rotten life, because you need money for everything in life. And if you don't have money, you'll never get a car. You'll never go on a vacation. You want to get a wife one day? You want to keep that wife? If you ain't got no money, all you're going to do is fight. It's a miserable, rotten existence. And it starts with getting, at the minimum, your high school diploma. So I will give you a lawyer today. In 2 weeks, I want you back here to show me what you have done to start looking about getting into GED classes. I have the lawyer who has resources to also help you out so that we can give you money, we can give you computers, whatever you need. But it starts with you. You understand? I'm telling you, life sucks without money. It's really real. Everyone wants to see you fail. Everyone laughs when you fall down. Don't give them a reason. And it starts with your high school diploma. You understand? No smoking any dope. I'm going to test you. I will test you 31 days from today. If I see that you're smoking dope, then you will get your GED with me behind bars. You understand? Okay? I'm not asking for much. Make me proud. All right. Can you reach out to the MAC for him and then we'll see him back in 2 weeks, see what he's done? Okay. Mr. Henderson, I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we start on all the paperwork for you.
Sorry, go ahead and sign. All right, Judge, the next one, there are 3 co-defendants. First one is page 8, Jackson. Real. And then page 11, Odom, come on up. And then page 17, Thomas, come on up.
Gonzalez Jennifer.
Okay.
All right, Judge, page 8, Jackson, page 11, Odom, page 17, Thomas.
All of you are charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 11th, 2024, officers conducted a traffic stop on a vehicle for failing to come to a complete stop at a 4-way intersection with all the traffic lights off. The driver quickly exited the vehicle and was detained and ID'd as defendant Alexis. Defendant Odom exited the passenger side and started walking away and was detained. The defendant Thomas got out of the back driver's side door and defendant Jackson was in the back passenger side door. There was a Glock in the driver's side floorboard, unholstered, round in the chamber within arm span of defendant Alexis, who is 20. And defendant Odom had a backpack on and it was open and a baggie of marijuana was visible. 51 grams of marijuana was recovered, an electric scale and a Glock was in Odom's backpack. Defendant Thomas had 7.23 grams of marijuana tucked in her bra. Defendant Jackson's purse smelled of marijuana and 4.88 grams of marijuana was in the purse.
Who's the driver?
It says defendant Alexis, but
Defendant Alexis is in court at 3, Your Honor. For whatever reason.
So there's a 4th.
there's a 4.
What's the cause number, please?
251-936-4. 7.
That's the earliest cause number.
So they may all know.
You can do that now?
I can, I'll take a seat after the justice.
Okay. Here's the deal. You guys are all getting transferred to court 3 because they've got the lowest cause number. We're going to do the transfer order here momentarily. I'm going to sign it and then we're going to send you all to court 3. So if you just mind just taking a seat over there, we'll be back with you momentarily. Do not leave, guys.
All right, Judge, page 9, Johnson. There's a co-defendant on this one, last name Williams. That one landed in court 3, but should come.
What page was it?
Page 9.
Okay. Are you Patricia Johnson? Ms. Johnson, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, ma'am.
On July 13th, 2024, officers received credible information from a concerned citizen that the co-defendant, a currently wanted person in Harris County, Texas for felony family assault, was inside a residence located at 710 West Bluff Drive in the garage portion of the residence. After opening the garage of the residence, officers observed the defendant lying in bed next to the co-defendant. As officers began to call the defendant and co-defendant out of the garage, officers observed several items of drug paraphernalia, such as used glass pipes and a white powdery substance wrapped in a clear plastic bag. Through further investigation, deputies observed 1.5 grams of marijuana located underneath the white powdery substance. And at the time of the incident, it was unclear what the substance was, but neither the defendant or co-defendant claimed ownership of the substance that had an approximate weight of 2 grams.
So how do you know it's hers? She's just at the house, right?
Right, Your Honor.
Is it her house?
It's unclear whose house it was. It's
Patricia Johnson. Ms. Johnson, just take a seat for me in the jury box. I'll be back with you here momentarily. I need to do a deeper dive on your case. You can get your stuff. So Williams is upstairs though, right? Ma'am, take a seat for me at the jury box.
It's in court 3.
Oh, he got a weak case too.
You got, yes. Yeah.
Okay.
And we had the lowest.
Ma'am, don't say anything, please. Next. Yeah.
All right, page 13, Reyes, come on up.
So we're going to test him 31 days from today. We're going to bring him back, make sure that he's going to get his GED, right? So no drugs, no alcohol. Yeah. Are you David Reyes? Yes or no?
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated. You're charged with possession of a controlled substance. On the possession case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Okay.
Officers on July 12th, 2024 were notified of a group of younger age males discharging firearms within city limits. The reportee gave officers a detailed description of the people of interest and the vehicle of interest. The primary officer observed the vehicle driving, and the vehicle had an expired registration and conducted a traffic stop. Officers detained the defendant and noticed slurred speech, red eyes, and swaying. Officers noticed a white pill in plain view on the driver's seat identified as alpha-solium. I'm sorry, Your Honor.
Been good?
Weighing 0.12 grams. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was a 6 of 8. One leg stand was a 3 of 4. DIC was read and breath was consented to, but was a 0.00, 0.00 on both samples. DRE exam was conducted and was found that the defendant was under the influence of depressants and should not be operating a motor vehicle. Blood warrant was obtained and blood was drawn.
So to start the DWI investigation, what did the officer notice? Like droopiness?
It was slurred speech, red eyes, and swaying.
Got it. Okay. Mr. Reyes, I'm going to find that there's probable cause to go forward with your case. Tell me, do you have a valid Texas driver license? Do you have valid liability insurance in your name? Then you are not allowed to drive. I'm making that a condition of your bond. I don't care what's going on in your life. Until you have liability insurance that we can see that's in your name, you are not allowed to drive. Do you understand?
Sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any kind of dope whatsoever, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Sir.
How old are you? What do you do for a living?
Okay, so we're from like 8 to 2.
And then what?
I take care of my kid after that.
You have a kid. Did you graduate from high school?
Sir.
That's where we are now going to start. I will provide you a lawyer today. Mr. Reyes, it's time for you to start working on your GED. You heard what I told the other gentleman?
Sir.
It all applies to you too. You understand?
Sir.
So, same thing, 2 weeks, bring him back. I want to see what you've done to start working on getting your GED. 2 weeks, you will come back to me and show me. If you've not done anything, life is not going to go well for you. Do you understand? I don't know if you have a pill problem, but if you do, you better address it. Because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Sir.
Deputy, do you mind giving me an application, please? Thanks. First, I'm going to have you come up here, swear to me that you're not going to drive. After that, deputy's going to give you an application. I will have you go to Victoria, sign a receipt, and then I'm going to have you take your seat in the jury box while you fill that out and find your lawyer, sir.
Next judge is page 14, Sanchez, come on up.
Henderson.
Okay, are you Harry Sanchez?
Sir.
Mr. Sanchez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 14th, 2024, officers were dispatched to a minor accident in Harris County, Texas. Upon arrival, officers observed the defendant to be standing in front of the vehicle, urinating, and observed there to be damage to that vehicle. The defendant appeared to be incoherent and could not stand unassisted. The officer asked the defendant for his driver's license, and the defendant attempted to give a credit card. The defendant could not answer what time of day it was or give an estimated time. He stated that he had 2 shots of liquor, and officers asked if he was driving, and he stated yes, and stated that he had hit the curb. Officers removed the vehicle keys from the defendant's pocket, and standard field sobriety tests were refused, and he was asked twice more and refused. Officers had the defendant sit on the curb due to him not being able to stand on his own, and the defendant began vomiting. Officers determined the defendant had temporary loss of his mental and physical faculties by reason of the injection of alcohol, which caused him to be a danger to others while operating a motor vehicle on the public roadway, and was placed in custody. PIC was read, breath was requested, and the defendant did not consent. A blood warrant was acquired and blood was drawn.
All right, Mr. Sanchez, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Sorry?
I do.
Do you have valid liability insurance in your name? Can you run his license, please? And also see if he has any prior DWIs, please.
Yes, sir.
Do you have any prior DWIs, Mr. Sanchez? We are going to reset your case to give you time to hire a lawyer. I am, as a condition of your bond, ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using any kind of dope or alcohol, I will put you in jail. You will not get any more PR bonds. Do you understand? I would get on it quick. There's a lot of timing requirements with your license. So if you don't have a lawyer quick, you may very well lose that license. So I'm going to have you go to Victoria, sign a reset. After that, you'll meet with Tracy for your bond conditions. And after that, you'll be free to go. Do not pick up any new cases. Do not drive unless you have a valid license. Do you understand? Okay, please.
Your Honor, there is no prior DWIs.
Reyes. Reyes.
Page 18. Hello, come on up. Are you ready? Judge, he says he asked you.
Do you understand English?
Judge, we need to translate this.
Any way we can get one today, you think? From Mass? Any way we can get a translator for today? Okay, take a seat, do not leave. We will try to get a translator, okay? Don't leave. Wonderful.
Oh.
Are we done?
No, this
Don't.
one. Can you say this?
Thank you.
Hi.
Good morning, Judge.
Good morning.
Mr. Robinson.
Okay. Okay.
Cautiously. Mr. Robinson is in the holdover, not yet. Judge, he has provided me the last contact he had with this lawyer. He did not have an easy time. He left the court with this reset in hand that told him he did not need to appear on December 5th and went home to his house, which was completely boarded up and eviction notices posted. He was completely unable to get in his home, and then picked up the new case because he called the police and made the report trying to get into his home. So he has had quite a bout of bad luck. I've spoken with the state about the offer. He never obtained that offer from his previous counsel because
That's so not true, because we spoke about it with him, you know, and we spoke to him on December 5th. Discovery was complete, admonished him that he had a 2-hour class or 2 hours of community service and a class to do for dismissal.
Oh, so he was admonished in court. He did not
We,
explain that to
like,
me.
we do that with every single person,
Okay.
ever, because we let them know, hey,
Sure.
oh, your case is getting old. It's time for you to get it done.
Well, he did leave court to a locked up, boarded up house, and he has since been able to get on his feet. He has obtained a job. He has a very limited financial situation because he has 7 children he's supporting. The state graciously upped the offer a little bit. They would reinstate that, and we would take that PTI offer today if the court would consider it. He understands this case is old and that you would be making a special exception, Your Honor. Not to reward him for not showing up, but
I mean, that's exactly what that's.
I know there was a very crazy
Deputy,
situation.
do you mind bringing up Mr. Robinson, please? Yeah.
I can let Mr. Robinson tell you that. He really would like to do the PTI.
I would like to win the lottery.
Y'all want.
I would like more hair. I really want more hair. You know, it's not gonna happen. So.
And Judge, I have discussed with him, and more than likely we'll get him this offer, so.
Well, we've done that before.
Yes,
We've had other
I
people
know.
try to scare him too. It doesn't work.
We're not on Zoom, right?
We're always on Zoom.
Oh, I had a message from Peter Delete, but I won't deliver it on Zoom. I'm sure he can
I'll
imagine.
delete for that. We love him. What's Peter doing today? Where's he at?
You know what? I thought he was gonna be up here, but I haven't seen him. He's doing his usual thing. Making messes.
Why on earth, after your case being 350 days old, you've taken off on us multiple times, and in December, we spoke about the offer that you had 2 hours of community service and a class for dismissal. Yet, reset after reset, and then you just blow us off. So why would we reward you with letting you go to try to get this thing dismissed, Mr. Robinson?
You can answer the judge, yes, sir.
Your Honor, when I never came, I got a letter that says do not appear to court on December 5th. So I never spoke to anyone after being here in August. I never spoke to anyone, but I do have a job. I am a working member of this society.
You think that just because you don't have to appear for one setting, that the thing goes away? Poof, like a fart in the wind?
No one called me or contacted me, Your Honor, and I was unaware.
And it is your responsibility to contact the lawyer. You are not Mr. King Robinson, where people are going to throw down a red carpet for you, sir. This is your case. It is your responsibility. They're not going to sit there and try to catch you. Oh, come on, Mr. Robinson, can you please come to court? No, it doesn't work like that. And you have had enough cases in the past to know how the justice system works. So why would we let you go? To me, you know, you get one PR bond to make things right. I'm not down with giving you multiple PR bonds. I'm not. What do you do for a living?
Actual account manager.
How much money do you make a month?
I only retain 2,000 out of it.
You're telling me you make $50,000?
Sir.
How much do you make a month?
He brings in $2,000 a month, Your
2,000,
Honor,
yes.
before his expenses. His child support is approximately $495 a month plus $100 in back child support. So
7 kids, it's $500 a month? That can't be possible. Does the court know about your 7 kids or do they only know about 1 kid? Because typically child support for 1 kid is around $400 a month, not 7 kids.
Sir, Your Honor, I took a Zoom call with the Attorney General and my wife was online and that's what he ordered, sir.
What is the offer on this case now?
the prosecutor has offered a PTI of 90 days. It was originally a 45-day PTI offer.
I'm not resetting this case for 90 days.
Or he has offered a time served, Your Honor.
So to get this thing dismissed, what did he have to do?
Originally, it was 45 days community service and
I have here.
and the state increased the, I'm sorry, it's now a 90-day PTI offer. Hold up on mine.
What do you want?
10 hours of community service and an effective decision-making class.
That's what it is. 10 hours of community service and an effective decision-making class?
Yeah, I increased the hours and skip on.
Mr. Robinson, you have 1 week to get this thing done. And I'm gonna tell you now, you ever take off on me, I will make your bond $50,000.
Yes, sir.
Do you understand?
Yes, sir.
And if you don't have this done in a week, against my better judgment, I'm giving you the opportunity to get this thing
Yes, sir.
dismissed. You have 1 week. I don't care what your excuse is. I don't care if Jesus comes down and tells you to do something differently. If you're not back here in a week with everything done, you will get an immediate trial setting. And all offers off the table because I will not accept anything else.
Sir.
Do you understand?
Yes, Your Honor.
1 week. Okay.
Thank you, Judge.
Okay, Eric. Hey.
Yesterday.
Well, I don't remember anything. What happened? Oh, Koopa. Right. Okay. Is he back there?
He's back.
Okay,
Sounds like they're already on set.
correct. No, is he gonna bond out or no?
Mom called the office yesterday. It sounded like she was going to, but he's still here, so I don't know.
Okay, so why don't we just set it for early next week? Maybe Monday, Tuesday? And see where it goes. If he doesn't bond out, then we can talk about, yeah, about releasing. Okay, yeah, for sure. Thanks, Eric. Hi.
Hi, Judge, may I approach?
Yes, ma'am.
Thank you so much. I'm here for Sam Foreman on Albert Gomez.
Jacqueline?
Okay, what are we doing? I don't remember.
I believe he's bonded out, so I think if we need to review bond conditions, I know that he already has some in place.
Come up, Mr. Gomez. Does he have the GPS monitor on him at this point? Do you know?
I think he does have his monitor.
Translator,
No, I speak English.
is your GPS monitor operational?
Yes, it is now. I had no power up until today. My power's been off in the room I've been staying,
My only concern,
but that was, yeah, it's up, it's operational.
my only concern are two things. Number one, that GPS remains operational. And number two, you do not have contact with the complaining witness. Do you understand? If I find that you have contact with this person, I'm going to triple, if not quadruple your bond. I will deem that you refuse to comply with bond conditions, and I'm well within my right to make your bond $50,000, and I will. This is the third to fourth time that you've persisted in trying to have contact with this person. I don't care if she comes to you. I don't care if she texts you. I don't care if your daughter comes and says, hey, Dad, come on, let's have contact with Mom. I don't care. Do you understand? Mm-hmm is not an answer.
Yes, sir.
Yes or no?
So it's not been the third, fourth time. But I understand.
You have a felony assault. You have a violation of protective order. You have another assault, and then you have another contact, which is why I put you in jail. That's 4. Don't have contact with this person. As long as you can do that, you and I will be best friends. Do you understand? I'm not asking for much. Just don't have contact and no weapons. Do you understand?
Yes, sir.
That's it.
I just
Nothing else matters. I mean, excuses don't matter. These are not mistakes. These are choices. You can either make a good choice or you can make a bad choice. There's no mistakes in life. A mistake is I left my wallet at home, not, oops, I met with the complaining witness at a motel. That's not a mistake. It's a choice. So we'll just reset the case now. We'll do the felony case is set for August 22nd. We can set it for the day after.
Okay, perfect.
I just want to make sure with pretrial that no drugs, no alcohol, and that the device is operational, and then that's it. And then after that, you'll be free to go.
Thank you, Judge. May we be excused for now? Thank you so much.
Okay.
Oh, Judge, we have one Spanish arraignment.
Yeah.
Hey, Rodriguez.
Mr. Rodriguez, you were charged with evading arrest or detention. Your case is so old, it's time to do something with it now. Your case is 420 days old. I'm going to tell you that if you ever take off on me again, I'm going to make your bond so high, you'll be stuck. Do you understand? You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
May 28th, 2023, officers were dispatched to a major crash. The defendant, who was standing outside of the wrecked vehicle, The officer instructed the defendant to stay where he was and not to leave. The defendant then started walking away from the crash, then started to run down the freeway. The defendant ran about 400 yards while he was repelling his stall. And the defendant made a statement that he knew police told him to stay where he was, but left anyway.
So he's in a car driving, basically.
He was in, they responded to a major crash, and so he was outside of the crash. On the freeway.
Do we know if he was driving or was he a passenger?
It says. Yeah.
Mr. Rodriguez, are you a United States citizen? Are you in this country with or without permission?
No.
What happens if you go to jail? I want you to think about it. Are you in this country with or without permission? You speak English, don't you? You don't need a translator, do you?
English, but not very well.
If you go to jail, what happens?
Not sure, maybe the department, I don't know.
That's right. If you go to jail and you are not in this country with permission, immigration will put a detainer on you. You will remain in custody until immigration is done with whatever they're going to do, whether they let you stay, whether they let you go, whether they deport you. Unfortunately, the process is so long that you will sit in custody for 6 months, 9 months, perhaps even 10 months, waiting just for something to happen. Do not violate the conditions I put on you now. Do not miss court again. Otherwise, I will put you in jail. And if you are unlucky enough, you're going to be there for an extremely long time. This is the only warning that you're going to get from me.
Judge in the OR, I just wanted to make a note to the board. I did admit that he was involved in the accident. I said he was trying to evade his crash. So.
Do you have a Texas driver license? Then you are not allowed to drive, and you will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. If you don't have a Texas driver license and liability insurance in your name, you are not allowed to drive. What do you do for a living? How much money do you make a month?
700 a week. About.
We are going to reset your case to give you time to hire a lawyer. It would behoove you to have one quick, because the next setting you come back here, it will be a trial setting. Your case is 420 days old, and it's time to put this baby to bed. Do you understand? Good. I'm gonna have you come up here, swear to us that you're not gonna drive. We're gonna reset your case for 30 days. I'm telling you, the next time we come back here in 30 days, you must either accept an agreement or I'm gonna set your case for trial because it's as old as it is. Please. Hey, so Victoria, next.
Okay, so we are going to watch these. There are a few and there might be some repetition, but I need to just go through them in case some say things that others don't. Where is this logo? Am I covering it? I think I'm covering it. Yes, I am.
At a hearing today, Tyler Daisy was found not competent to stand trial.
The Dubuque man is facing a first-degree murder charge for the stabbing death of his mother, Jennifer, as well as an animal abuse charge for killing the family dog. And KCRG TV9's Abigail Curtin is joining us live from Dubuque with now what happens with this case. Abigail?
Well, what was supposed to be a smooth hearing quickly devolved after Daisy was found not competent enough to stand for trial. It came as a surprise to his lawyers, too, who had previously stated they expected him to be found competent. But according to his doctor's evaluation, he believes that Daisy is well enough to understand the legal process, but he's not competent enough to act in his own self-interest or to assist his counsel. Daisy was attending the hearing through closed-circuit television from the Dubuque County Jail, and after hearing that he's not considered competent, he started laughing and smiling before responding with, quote, "That's BS." But his smile quickly faded once the judge ordered him to be transported to a psychiatric hospital and prison in Coralville.
I'd like to say this is not one flew over the cuckoo's nest, and I will not be going to a mental institution, and I will not be taking drugs. I am who I am, and I am who I choose to be, not what you say I am. Do you understand, sirs and ma'ams? Okay. Mr. Hoover, my preference would be...
Daisy's biggest concern was being forced to take medication, to the point where he shouted at the judge and his lawyers, stating his constitutional rights were being violated. Previously, Daisy's sister told TV9 that he has been diagnosed with a number of mental illnesses, including schizophrenia. At the Forensic Psychiatric Hospital, Daisy will undergo another competency evaluation. If he's found to be not competent there, he will have to undergo restoration treatment. And with another judge's order, that could mean he has to take medication for his mental illness. Live in Dubuque, Abigail Curtin.
Okay, so the same channel, but let's see. Wait.
Appeared virtually in Dubuque County Court today to hear the results of his competency evaluation. KCRG TV9's Rebecca Vaughn joins us live in Dubuque. Rebecca, what happened in court today?
Today's competency hearing for Tyler Daisy didn't last long at all. The court barely was in session for 5 minutes, and that's because the court didn't hear results or official results of the evaluation at all. Prosecutors charged Tyler Daisy with first-degree murder after his mother was found dead in her home with multiple lacerations on her head, face, and neck. The family dog was also found dead with a significant head injury. Daisy had told police that his mother had been practicing witchcraft. Today's hearing was meant to review the report of a competency evaluation. That evaluation has been completed, but an official report has not been made.
We had our expert evaluate Mr. Daisy. We believe he will be found competent by our expert. We don't have a report yet, so we would ask for a 1-week continuance to get that report.
A second review hearing for the competency evaluation is now set for February 29th. That's when the court will also review a request Daisy made for new attorneys. I'll have details on that.
Okay, then this is 1 month ago.
At midday, a judge says a Dubuque man accused of murdering his mother is now fit for trial. Tyler Daisy was initially found unfit for trial following a competency hearing in February. But the judge says Daisy is now ready for trial after reviewing reports from separate doctors. Daisy is charged with first-degree murder. Prosecutors say he killed his mother, Jennifer Daisy, and her dog at her home in January. Daisy's trial is set to begin July 9th.
Okay, then we go to 1 day ago.
Opening statements could begin as soon as today in the trial for a Dubuque man charged with murdering his mother. Jury selection for Tyler Daisy's case began Tuesday. Daisy is charged with first-degree murder. He is accused of killing his mother, Jennifer Daisy, at her home in January. Daisy is also accused of killing his mother's dog. New court documents show Daisy filed motions on Friday to dismiss his attorney and the case against him. Daisy was found incompetent to stand trial in February, but that decision was reversed in May. He faces life in prison if he's convicted.
Okay, then we're going to go here. This was 5 months ago, and it is Sheriff demands change to how Iowa treats people with mental illness. And this came up when I searched for Tyler Daisy. So
He spent a day in jail at the invitation of the Dubuque County Sheriff. On January 18th, I was observing the 161 men and women living at the Dubuque County Jail. That was also the day a familiar face returned, Tyler Daisy. He's the man accused of killing his mom and her dog in the home they shared. Now, the jail staff's frustration was palpable when he walked in, that Daisy couldn't get the help he needed before, and now he was back on first-degree murder charges. Well, they say he's one of a growing number of people who need treatment as patients, not inmates. But Iowa has few options, so they stay locked up with nowhere to go. Behind this door is Tyler Daisy. Dubuque investigators say he killed his mom and her dog with a hatchet. They found Daisy nude in their house, explaining to police his mom had been practicing witchcraft on him for years. His criminal past reveals a man who thought he was Jesus Christ and the devil. Family members tried to get a restraining order against him.
How many times have you seen Tyler Daisy come through?
Ooh, I don't actually have a number of count, but he is familiar to me. And it's going to be a mental health situation, I'm sure. 'Cause that's the only way I've known him is through mental health.
The Dubuque County Jail has 187 beds, but its census numbers are 30% higher than about a year ago. Sheriff Joe Kennedy says the increase is because people who are seriously mentally ill aren't getting the care they need and ending up in jail getting sicker.
Until you have a physical building or physical buildings to put these people in that can't function in society, all your policy means nothing, because all you're doing is contributing to the inmate population in this state, and that is not where these people belong.
Tawny Wilkinson has been in the Dubuque County Jail for 1,100 days out of the last 1,600. When she's not here, she's typically homeless. Criminal complaints detail her multiple arrests for disrupting truckers at the Q Casino with screams about aliens, or assaulting a stranger standing in line buying potatoes.
okay, I'm sorry that I have to end that halfway, but I don't know where that is going, and I can't take the chance. So I feel like that didn't answer many of our questions. Psychosaurus, maybe you can help us out. I'm very, 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 very confused. Oh, look at Phoebe. She looks so cute. So I also looked for his Tyler Daisy jury selection. Tried to find it and I couldn't, unless it's in the part 1 that we're going to watch tomorrow. Oh, one sec. Oopsie, I forgot the mic was muted. Holy moly, the rain is coming down now. Phoebe's just like, oh, Friday. The question was, did that clear anything up? Because I don't feel like it did. And I'm very confused on what has happened. So my understanding, he had a competency evaluation, was deemed not competent. Further down the line, he had another evaluation by a bunch of other doctors and deemed competent. That's what I'm understanding, but I don't know if that is right. And I can't find, we might have to just wait and see what that, wait a minute. Tyler murder trial. One sec. Claim self-defense. Nope, that's the wrong Tyler. Oh, another trial I was just reminded of that I actually wanted to watch at the time and didn't was a Trooper bathtub murder trial. That's one. And then eye drops. I wanted to watch eye drops. Can add those to the list. Ooh, what is this? Boyfriend hitman murder trial. Darren Ruben Lopez. There's so much we can watch. Psychosaurus says, it sounds like they had one opinion of competency and wanted a second. That's pretty normal. I'm testifying next week in a competency hearing because defense doesn't like my opinion. Okay, got you. So one found them competent. The others didn't. So potentially one person saying not and multiple saying is. All right, let's watch this for a little while.
The 14th District Court, Washington County, State of Michigan.
We can always go back to Judge Fleischer. I just feel like for the mental change, we need to switch. Insanity is an interesting question here, though, and I need a ton more information, but I have certainly opined plenty of people as mentally ill but still responsible, thus not legally insane. And I don't think we will get those answers. We might in day one get a brief overview, but I imagine that would be part of his medical documents.
Michigan is now in session. All those setting business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning, everyone. Before I begin calling cases, I'll just take a moment of personal privilege. And to everybody that has to deal with her every day, they can wish my wonderful coordinator, the one that gets me going each morning, Ann Weidling, wish her a happy birthday. She's once again 29 and proudly so. So happy birthday, Ann. Court does call the case of Six Trails versus Charlene Case.
Good morning, Your Honor, and happy birthday, Ann. I'm Carol Luckoff on behalf of the plaintiff, and I don't usually call you Ann.
She says thank you. All right. Ms. Luckoff, I don't know if this is going to be a problem on all of these or not.
Don't tell me you don't have proof of service.
I have no proofs of service. I think let me just check here. Well, that's so on Six Trails versus Case, I don't have a proof of service. And also on Six Trails versus Myers, I have no proof of service. On make sure that they just didn't forget to mark it.
I see Ms. Pace, Your Honor, and I see Sabo. I don't know if that.
Yes, Sabo. I don't. It's my sheet is not marked. What do you have to say about?
I just want to see if the echo gets better. Otherwise, we're going to have to bounce.
Sorry, I'm trying to get it turned on.
All right. Well, Ms. Luckoff, what is the plaintiff's claim?
Your Honor, plaintiff claims, including court costs, a total balance of $2,177.
Okay. And Ms. Case, what do you have to say about that, and how are you going to get that paid?
Oh, no, I agree that I owe that money. I have $500 I can pay today. I can pay at least another $100 within the next week, and then I get paid 2 weeks from today, which I can probably pay another $600 to $700 and then go from there.
Well, I don't know that that's going to work. Have you talked to your about a payment plan or anything? Because
not yet. I haven't had an opportunity to get to the office, just because I work during their hours. So I was gonna stop in today after this proceeding and chat with them.
Okay, what's your monthly rent?
It's $850 plus like water and parking and whatnot, so it's $923 a month.
Okay, so here's the problem. What you're intending upon giving to the landlord, the 500 plus the 100, the issue is going to be that you're not even going to pay August by the time you're going to make another payment in August.
Okay.
Follow me?
Yes, sir.
All right. Have you reached out to see if there's anything available for you to assist you in paying the rent?
No, I have not.
All right. What I'm going to do is I'm going to adjourn this out to the 26th. That's right. July 26, 2024 at 12 p.m. You either need to arrange something with your landlord, or need to figure out how you're going to get this paid. All right, ma'am?
Okay.
Because you're headed into August.
Yes, sir.
And that's how it's going to work.
I understand.
Okay? All right.
Yes,
Thank
sir.
you.
Your Honor, if I could
Thank
have
you.
just 30 seconds as Ms. Case, if she was
Yeah.
actually served, before I start getting mad at other people, were you served by, nothing was posted, nothing was handed to you?
No, nothing was posted on my door. I got 2 notices via mail. That's all I got.
Okay, all right. So Your Honor, I'm assuming that's okay since she's here and she's submitting herself to the jurisdiction of the court.
Yes.
I just wanted to know. Okay, thank you.
Right. Yeah, no,
Yep.
I understood. Understood. All right, court calls the case of Six Trails versus Lisa Sabo.
For the record, Cheryl Luckoff on behalf of the plaintiff.
She was here, wasn't she?
She's here. I think she's muted, Your Honor.
I'm not. I have 2 screens, so that's a problem for me. Ms. Sabo? Oh, I see her now. Hello? Okay, your mic's not working. You may need to turn up your mic.
If you turn off your video and turn on your audio, it might work best.
I think her audio is on. It's just
Okay, she's muted though. You see how she's muted?
right, but now she's not, and
Oh,
she
okay.
can't.
Yep.
She
Yeah.
can't talk to us. Miss Sabo?
Does she want to call in?
I don't know. Miss Sabo, can you? Now she's off. Miss Sabo, do me a favor. Turn on your video. If you can hear me, wave your hand in the air. Okay, you can hear me. There's something wrong with your microphone. So let's do this. What's the claim in this case?
Your Honor, the claim total amount due $2,647.
Okay. I'd like to ask you how you're going to pay it. Miss Sabo, did you get instructions on how to call in? Oh, did she just drop? No, she's
Still here.
Okay. Miss Sabo, try to do this. I'll pass. Keep disappearing on me. I'm going to pass the matter. Try using the phone number to call in. Okay? All right. I see her nodding, so I think she's understanding what I'm saying. All right. Thank you. I'll pass it. On Six Trails versus Myers, that's the one I don't have service. They're not here.
Can you adjourn it then, Your Honor, until I can figure this out?
I'll adjourn it to July 26, 2024, 12 noon.
Thank you. Thank you very much. And I'll wait for Ms. Sabo.
All right, Arbor One West versus Smith, that matter's dismissed on plaintiff's motion without prejudice. And if you guys can let me know when.
Your Honor, can you pull that Smith file back for a moment?
Sure.
Do you show that as a non-payment case or a termination?
I have it as a termination.
I just want to make sure that that's correct because there were a lot of issues with this one. Can you set that one aside too, Your Honor? I mean, I believe it. And this is a great Friday morning. Okay, thank you.
Yes. No, I'll set that one aside. That's fine.
All right, thank you.
All right. And you guys are going to let me know when there's a.
Yes.
All right. Barnes and Barnes versus Amaya Payton.
Ellis Friedman for the plaintiff.
Amaya Payton here.
All right. Very good. What's plaintiff's claim in this case?
$2,011.40.
All right. Miss Payton, how are you intending on getting that paid?
So I have already gave them a money order. Wait, what's the total amount?
$20,1140. $20,1140 including costs.
I already gave them a thing for $655 on the 27th. I get paid. I can put 1,000, and then on the 19th, on August 9th, I get paid again. I can put another 1,000. I know that's going to lead me into August, but on August 23rd, I get paid again, and I can pay the rest of my rent, and that would be August 19th.
Okay, I see. At least you got a plan here. So when.
And I have been
You said-
Ubering and DoorDashing to pay it off earlier.
Hold on, ma'am. When did you, how much can you pay before next week?
Before next week,
Yeah.
I don't get paid again until the 26th.
Okay, that's next week.
Yes. Now, I do Uber and DoorDash. I am going out this
Okay.
weekend. I don't know how much I'm going to make this weekend.
I gotcha. So you get paid on the 26th. How much are you going to give on the 26th?
1,000.
1,000.
Mhm.
All right. So what I'm going to put here is you're going to pay 1,000 by the 26th. You got to get that in before the hearing time. I'll adjourn this out for you to do that and to seek assistance. July 26, 2024 at 12 p.m. So that needs to get into the landlord. The $1,000 needs to get into the landlord before noon.
Okay.
Okay. If you can
Okay.
pay it the day before so that council knows, that's even better.
Okay. I usually do get paid on that Thursday, but I just wanted to say the 26th just to give me enough time to put it in.
I got it. But right now you're in a circumstance that you got to get that in.
Okay.
Okay. How much is your monthly rent?
Everyone wants to go back to Felicia.
Next setting is clear trial.
Go ahead, come right here.
Hey, John. Good morning. Yeah, come on up.
She has a plea, Judge.
John has a plea? Oh, yeah.
Hey, can we just have an off-docket
Not all.
plea? It's on, Judge, we have an off-docket plea on Mr. Colbert.
Are you ready?
He's off-docket, yeah. Can I bring him up, Judge? Mr. Colbert, come on up.
Can you give me the call number?
Yeah.
What's, John, what's the cause number, if you don't mind?
I'm sorry, Judge. What's your, oh, did you catch that? Okay, I'll get it for you. 249-3894 is one of the cases, but we're going on the DWI and the rest is getting dismissed.
Okay, what are we doing?
We are proceeding with the time served on the DWI and all the other cases are being dismissed. And then after today, Mr. Colbert is moving back home to Memphis, start over, leave all this madness behind him.
9-3.
9-3. No, Mr. Colbert, that is a screaming deal that you're now getting. They're dismissing 3 of your cases. You're pleading to only 1 case, and you're not getting any jail time. It's a heck of a sweet deal that you've got there. But what you must understand that this DWI is going on your record. It will be there for the rest of your life. If you are in a car driving and you get pulled over and they smell weed and they look you up and they see a prior DWI, what do you think the cops are going to do to you?
The time.
Right. No, they're not going to just detain you. They're going to arrest you. They will charge you with a second offense. And from now on, you'll be facing a minimum of 30 days in jail. You understand?
Yes, sir.
What we're doing today, it will not happen again because there will be a minimum of 30 days in jail. So if you want to get lit, don't get into a car. I don't care how much you've had to drink, even a sip of alcohol. All they have to do is smell a faint odor. They're going to take you down. Do you understand?
Sir.
You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this or undo this. Is this what you want to do?
Sir.
How do you plead to the offense? Guilty or not guilty? I will find you guilty. I will sentence you to 9 days in jail. I'll give you credit for the 3 days that you've done. I'm going to suspend your license for 180 days. Do not drive until you get a license. Good luck to you, sir. Thanks, Sean. Please see the clerk.
Okay.
The Flores in the back.
Page 22, Judge.
Hold on, I just lost everything.
Judge, what happened?
Yes.
Okay. He moved to a new stream.
You and my sister.
Okay. Right, last push. Let's go. Can you hear the rain? I haven't found it yet. He's chatting on the chat. Look at his little smile. All right,
Okay, sorry, Council, come on.
Judge, before you do, they just need a bond on that original case, for the bond, yeah, a bond map. Sorry.
It's Manuel, right?
Flores.
Oh,
Flores is that.
wow. This new one is at no bond, so I'm gonna have to set it.
Right.
So the old one, it'll be at 5,001.
Okay.
The new one will be, I don't know, what do you think, John? What do you want? State, what do you think, Jason?
For the second theft case?
The new case doesn't have any, I'm showing no bond. Yes,
2520159.
okay, but I'm looking at 2520465. That one's at no bond. Jason, what do you think, bond amount?
For the second theft case?
Uh-huh. I don't know, I guess we'll do 1,000. Okay, and then, yeah. Okay, I'm sorry to keep you waiting. Thanks for being
No,
patient.
definitely. You back up and running?
Yeah.
All right. Poaching on the off docket matter.
People want to see you. They do.
I
Yeah,
appreciate
really?
that.
Okay,
Appreciate that.
so who do you have?
Sterling Wiggins, Judge. I have the
Wiggins,
cause number.
that's right.
Yes.
So where is Mr. Wiggins?
He is in the piece, sir. with his
Come on,
mother.
Mr. Wiggins.
And just for some context, defendant missed an arraignment on 4/19. Transportation initially was the issue.
Council, hang on.
Sorry, I just need the cause number.
505-146.
That's it. Okay, tell me.
Yes, Judge. So initially, transportation was the issue for the missed court appearance on the arraignment date. However, between April 19th up until we were retained, which was last month, the family has undergone significant financial hardship. So much so that they are currently ongoing on the process for finding a new home to make a permanent residence. So for that reason, Judge, we are simply trying to reinstate the initial PR bond that he was given, or in the alternative, a bond amount not to exceed 2,000.
Yeah, so just.
For Wiggins,
Yes.
when did we initially see him?
So his first appearance here.
I'm gonna make his bond contingent on one thing.
Yes,
Because
Your Honor.
I told him, and I told you, I did not want you to smoke weed. And I told you that I was going to test you in 30 days. And what did you do? You took off on me. That's what you did. I'm sending you now for a drug test. I want to see what, if anything, is in your system. And we'll go from there. Because that's what concerns me the most. Are you using? Because you know, since day one, the first day you got here, I told you, don't smoke weed, right?
Those notes
'Cause-
are for different.
Yeah, I didn't.
This is Wiggins, right? I'm having here that we spoke to him and told him not to smoke weed.
Yes, Judge, this is Wiggins, but I put the notes on a different. Wiggins had a PR bond back in April and didn't show up on that court date.
It was his first arrangement.
That was his first arraignment.
How many PR bonds has he gotten?
One, because his other cases were closed out. So this is his first arraignment on April, but he tried to appear, so one time. I'm gonna go and update this.
Mr. Wiggins, have you ever played Monopoly? In Monopoly, you get what? A get out of jail free card, don't you? This is the only one that you're going to get from me. You ever flake on me again, I will put you over my head like a little child. And guess what's going to happen? I'm going to test you 31 days from today. You were on notice. Don't smoke weed. Do you understand? I'm bringing you back here 31 days. If I have found that you continue to smoke, and I don't care what your excuse is, I don't care if you're in a car with 15 people and they're all toking you, if you're fall down and there is a bong in your mouth because you fall down on it. You test positive in 31 days. You know what's going to happen, right? What's going to happen? Very good. That's right. Today, I will reinstate your bond. It's the only time I'm going to do it. From now on, I don't care what your excuses. I don't care who you have next to you. You ever flake out on me again, I will make your bond really, really high. And if you are so financially destitute as they say you are, you'll be stuck like Chuck in jail until this case is over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 call. And you will sit there until all that happens. Do you understand? How old are you? You're 18. What do you do in life? Where? So you graduated from high school? Since January, this is your 4th case. If you truly want to go to school, what you're doing now is all wrong. Because when employers look you up, they're going to see all your criminal history. It don't matter if it's dismissed or not. They're still going to see it. Do you think they're going to want to give you a job? With your assault case now, the entire world is on notice that you have a trigger temper. What employer in their right mind is going to give a job to someone who has a hair trigger temper? Because they know they push your buttons, you're going to let loose on them. No employer wants that. The more criminal cases you pick up, the bigger hole you're digging. This is already 4 this year, and we're only 7 months in. What's going to happen next? So you best be on your best behavior. Otherwise, you'll stay with me. Do you understand? Who's with you? Mom? Is that Mom? Come on up. Who is the assault? Who's the complaining witness?
A prior significant other, no longer in the picture.
It was a dating relationship, Judge.
Are you Mom? Thank you so much for coming. I really appreciate you coming. It tells me a lot. This is his 4th case this year. And now he's facing a year in jail. He missed the first court date, so I issued a warrant and I put his bond at $2,500 because he missed court. He tells me he's going to start Lone Star, he's going to start college in the fall. I don't know if that's true or not. All I know is that the more cases he picks up, the harder his life's going to be. Your life is hard enough as it is now. All you're doing is repeatedly shooting yourself in the foot as it is. Does he live with you?
Yes, sir. We're in transition right now, so we stay in extended stay until I can.
Okay. We have services through the MAC that we can help you out with it, whatever you need. We have social services, if you'd mind looking into try to helping them
Absolutely,
with
Judge.
any kind of housing. We have services that will help you with whatever you need. All you have to do is ask and we can help you out. And I'm happy to do it with whatever you need. The only thing I want to do is make sure that he behaves himself while he's out on bond. So if you ever have any problems with him, if he mistreats you, doesn't follow your rules, just come back to me and tell me and I'll straighten him out for you. You know, but I'm at wit's end with Mr. Wiggins. I'm up to here, like my own kids, and I'm not going to stand for it anymore. You step off the line one more time, I will put you on my knee and I'm going to spank you with a ton of jail time, just like a little child. Do you understand, Mr. Wiggins? So, Mom, you need anything, just all you need to do is holler, and I'm here for you.
Yes. Thank you, sir.
So the complaining witness is a significant other that they no longer have
No longer.
contact with.
Yeah.
Okay. So he's charged with assault of a family member, $4,000 fine. not only that, this is the kind of case that can have severe ramifications where, if he were to pick up another one, unless this thing were to be dismissed, if he picked up another one, he's looking at 2 to 10 in the penitentiary on a 3rd-degree felony. And you could potentially never own a gun or ammunition as a result as well. So there are really, really big consequences with this type of case. Do you understand? You are not to have any contact with the complaining witness in this case whatsoever for any reason. I also told him that I'm going to test him 31 days from today and that he better not smoke weed, because if he smokes weed and I test him, I'm going to put him in jail. I will revoke his bond. He's not allowed to smoke weed while he's on bond. No weapons as well. You are now on notice of everything that is expected of you. Do you understand? Are you working? So what are you doing to pass the time? You need to find something to occupy your time, because when you have too much time on your hands, you become self-destructive. That is what is happening. Have you had a job since January? Do you have a driver's license? Do you have insurance? Is that right? Does he have? Okay, as long as you have both, then you can drive. When you have too much time, you become self-destructive. You need to find something to occupy your time. And I tell you, there's no better way that you can help your mom than getting a job, a full-time job, and helping her with money. I'm telling you, if you were to do that and help your mom, she would be over the moon with you. And you won't get in trouble because your time is occupied doing something productive. So that is now another condition. You must get a full-time job. Or if you have a part-time job, if you're in school. But I don't want you roaming around without nothing to do. Do you understand, Mr. Wiggins? So when you come back in 31 days, I want to see what you're doing with your life. You must have a job of some sort. No home health care. And they'll explain it to you if you don't know what I mean. Do you understand? Okay. So Tracy, you got all that? Okay. Mr. Wiggins, good luck to you. All I'm asking you to do is make me proud. I'm not asking you to do anything. I'm not asking you to split the atom here. All right? All right. Good luck.
Appreciate you, Judge.
Reinstate it now.
Yes.
Now knows what's expected.
Thank you, Judge. Maybe excuse you. Appreciate your conditions.
Thank you so much.
Okay, so Steve found a subset thing, the subset thing in Fleischer. This is from Court Vibes, and they are actually also a mod on Fleischer's channel. Just gonna drop their here is Court Vibes channel. I'm going to play this quick, and then I'm going to read what Psychosaurus says first regarding Daisy. Found some info on Daisy's insanity issue. He informed the court that he will not be asserting an insanity defense, so it's likely he wasn't even evaluated, but maybe he said he was and he won't use it. Also, his first competency evaluation. According to his evaluation, his doctor believes he understands the legal process, but he's unable to act in his own self-interest or assist his attorney in his defense. It looks like his attorney requested an insanity evaluation with the intention of asserting that defense. Now it makes sense why he wanted the attorney dismissed. Okay, so we're going to watch the, thanks, Psychosaurus Rex. That clears a bit up, but I have a feeling that I did hear them talk about that in the start of tomorrow. I just can't remember if that's where I heard it or if I was listening to something else. We're going to go watch the subset get tased from Court Vibes. And then I found a nice, short Judge Wolf trial. It is from February this year, but it's only 4 hours 28, most likely with breaks. So we can do it in one go, and then tomorrow start with the what do you call it? Witchcraft. I see they're still going. Oh, I must check my recording.
You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this, undo this, challenge this. It's done today and forever.
Judge, just for a moment of clarity before the court signs the final order, we were under the impression that this wasn't time served. I'm hearing he has 2 days and he's signing for 3. So what does that leave?
It's enough.
Okay, all right, there you go.
You have enough. You won't be doing any jail time, but like I said, any more cases you pick up, actually it's a minimum of 90 days in jail with your priors, all right? How do you plead to the offense? Guilty or not guilty? I will find you guilty. I will follow the agreement, and good luck to you guys. Thank you.
Thank you.
All right, please see the clip.
You can ask the clerk for one CD.
Here we go, guys. This is it. Pay attention.
Clock vibes.
I don't understand what's.
Sir, you're here for your first appearance. We're getting you in front of the judge. So I'm asking you to step up here so you can go through this process.
Stephen, this is about to go really poorly, really quick. Come up, sir. It's going to go bad for you regardless. Just wait. You now stand charged with your 3rd case, sir.
What?
You now stand charged with resisting arrest and failure to identify oneself as a fugitive from justice. You're now facing an additional year on each case. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
I don't understand. I don't understand.
Sir,
You do not have
Explain it to you right
I have
now.
the right to arrest me. I did nothing wrong.
Let's see.
I did nothing wrong. You do
You're
not have
in this
the,
courtroom.
I do not have, you do not have the right to arrest me. You do not. Are you acting under your constitutional oath today? Are you?
Yes.
You are? Okay, well, good. You are in agreement with the prosecutor, right? I make a motion that this case be dismissed.
I'm about to hold you in contempt if you.
For what? In order for there to be a crime, there has to be an injured person. The only person injured is me, and I have the scars from the policy officers beating me, pulling me out of my car without even telling me why.
Going to do.
I don't understand.
You have the right to remain
I do not
silent.
understand.
One more word and
I do not, you can't do that. In order for there to be a crime, you're not, this is against my constitutional rights.
Okay, you know.
Do I have a witness that they are committing treason? Do I have at least 2 witnesses? Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights. They are violating my rights.
Hey.
Look, see, that's what I'm talking about. Look.
Put your hands behind your back.
No, sir.
Put your hands behind
You're
your back.
violating my rights, and you all know it. The public prosecutor is there, a court reporter.
Put your hands behind your back.
I'm not doing anything wrong. Do I have 2 witnesses saying? Do I have 2 witnesses that say that they are committing treason? Please raise your hand. Do I have 2 witnesses that they are committing treason?
Sir,
Do I have 2 witnesses that they are committing treason? Raise your hand. Are you raising your hands? All right.
That would be the taser.
Do I have 2 witnesses? Do I have 2 witnesses that they are committing treason? Raise your hand, stand up. Stand up for America. They are committing treason. They are committing treason. Raise your hands. No one. They are violating the Constitution. They are violating the Constitution. Oh! Stop. I have no cartilage in my left arm. Stop resisting. As the medical report shows, when y'all last officers last beat me up, I had to go to the hospital. I'm trying to lift you up properly, but you will not stop resisting. Man. Hey, Karen. Silence. I can't believe none of y'all are there violating the Constitution. This is treason. Raise your hand. I need 2 witnesses. I need 2 witnesses. The officers, y'all are right. Y'all are going against y'all constitutional oath. You're going against
The first bond is revoked on the offense jail. Pardon. I'm sorry, the interference. Yeah.
Controversial opinion. Why do I believe him though? I'm not necessarily saying that the treason and the whatever, but my gut feeling is what he was saying about the arrest and all of that. I feel like that's true. And I don't know if I'm the only one. Like, my body felt like sad and anxious for him. Like his, I don't know, his voice and everything. Like, anyway, I'm glad we've seen that now because I've been wondering about that for the longest time. And I thought you saw the taser happen on camera, but apparently not. We're going to hop over here. This is criminal jury trial, State of Tennessee versus Dario Meeks, resisting a stop. I think we start with jury instructions, which of course I will skip.
Did you carefully consider all of them? The order in which the case beyond a reasonable doubt you're required to explain your verdict that's in the case and my instructions about the law. With about the rules of evidence, the question will be asked. Not base any decisions on the fact that it was testified to about the case on your cell phone, through email, Android, iPhone, text.
Dixon County, Tennessee.
Any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying for punishment. This completes my opening comments to you, and the next phase of the trial is the formal reading to you of the indictment in this case. Brooks?
Yes, Your Honor. In the Circuit Court for Dixon County, Tennessee, at Charlotte, March term, Grand Jury 2023, the grand jurors of Dixon County, Tennessee, duly and impaneled and sworn upon their oaths, do present that on or about May 31st of 2022 in Dixon County, Tennessee, and prior to the finding of this indictment, Dario Meeks, then and there, unlawfully and intentionally prevent or obstruct a law enforcement officer, to wit, Officer Jessica Choate, when the said Dario Meeks knew the said Officer Jessica Choate was a law enforcement officer, from effecting a stop, frisk, halt, arrest, or search of the said Dario Meeks by using force against the law enforcement officer in violation of TCA Code 39-16-602 and against the peace and dignity of the state of Tennessee, signed by William Ray Crouch, Jr., District Attorney General.
To that indictment, how does the defendant plead?
Not guilty, Your Honor.
Not guilty. Plea is entered. Mr. Brooks, do you wish to make an opening statement?
Yes, Your Honor. Good morning again, everyone. Thank y'all for being patient with us this morning. I promise you that this will go quickly. Me and Mr. Locker will be very efficient with your time. From the state's end, you're going to hear from two witnesses. 2 witnesses, and there's a 5-minute body cam footage. Okay. First witness will be Tina Vaughn. She is a neighbor in the neighborhood where this occurred. You will hear from her. She'll be a witness that has literally no dog in this fight. She will not be able to say one way or the other that Dario Meeks did anything or didn't do anything. She will be testifying to limited purposes that she called police because she heard somebody screaming. That's why police were responding to that residence. And then Officer Jessica Schote will testify. She is a field training at the time, and right now she's a field training officer with the Dixon Police Department. She'll testify to her experience as an officer, that she was responding to a domestic disturbance here in Dixon County. She will testify that one of her main objectives when responding to that house at 826 Blakemore Road was to make sure everybody was safe, number 1. Number 2, determine whether or not a crime had been committed. Okay, she arrives at the scene along with another officer. They approach the residence. They get consent from the person that answers the door to enter said residence, and she has a brief conversation with the first couple of occupants that meet them there at the door. And again, her first objective is to make contact with everybody and make sure that they're safe. And then to go on to see, did anything criminal happen? Is there any merit to what the call taker said? She eventually comes to Mr. Dario Meeks, sitting next to the defense counsel, and he's in the kitchen, and he's preparing something. He's going about his business in the kitchen. Officer Schote makes contact with him, identifies herself, and starts engaging Mr. Meeks. You will see from the very get-go, the attitude Mr. Meeks has to law enforcement. As soon as Officer Schote talks with Mr. Meeks, a phone comes out. And a phone coming out there's nothing illegal in videotaping an officer encounter. However, the state would submit that it will, once you see the rest of the proof, it'll kind of show the mentality of Mr. Meeks and how everything else results. That he knew right then and there that there was going to be a confrontation, that he was going to be difficult, that he was not going to comply with any order. Officer Schote speaks with him. She tries to identify him as she normally does on any on-scene investigation. He doesn't give up his name. He gives up his first name eventually, Dario, and that in of itself, there's nothing criminal in that nature, but at the time he's being aggressive. He is at the kitchen sink. Miss Officer Schote will testify that she's not able to see in said sink. At one point in time, she advises Mr. Meeks not to go towards his waistband. Officer Schote will educate you on officer safety and the dangers of being in a residence that she's not familiar with, and a residence that she's not at the time well aware of how many occupants are in the residence. She'll describe some of the officer safety issues in this particular call that she has to be aware of, and that Mr. Meeks in particular was being confrontational. He was being irate. He was being difficult. He had a pocket knife at his side that was visible to Officer Schote. So she had some concerns with him. She has concerns of continuing this investigation. 1, making sure everybody's okay, and 2, seeing if anything at all criminal even had occurred. But he was a roadblock in that. You will see by his actions that he was going to prevent that. He was looking for his day. From the very get-go, to his interaction with police, it will be extremely evident that this young man was looking for his day. That eventually, when he did not comply with instructions, Officer Schote attempted to take him in custody, not to arrest him at the time, but to simply detain him and to place him in cuffs so she can safely conduct her investigation. That, and to make sure he doesn't have any other weapons on him, because she'll testify that she's not going to continue on her investigation with some guy randomly in the kitchen with a knife on his person. At that point, he steps back. He says, "Don't touch me." He balls up his fist. He takes an aggressive stance. And Officer Schote immediately calls for her backup officer. It takes 2 officers to eventually bring him into custody and put handcuffs. And at the time, you will see the video. You will see an over-dramatization. You will see 2 officers try to calm him down and place him in custody. And you will see a young man say, "Don't hurt me. Don't assault me." And is this because he's actually being assaulted or is actually being hurted? No. It'll be very evident from the very beginning of this interaction to the end that all Mr. Meeks is doing is looking for his moment. He's looking for this type of interaction. He's eventually taken into custody, and the pocket knife is taken away from him, and they conduct the investigation. Officer Shutt will testify that if he had complied, there was no other reason to arrest him. That they completed the investigation, and there was nothing tying Mr. Meeks himself to any type of domestic assault or any type of assault or somebody screaming. There was nothing. There's no proof at the house to tie him to any other criminal activity. If he had just listened. At the end of the proof, at the end of this very brief proof, you'll have a video. You'll get to see this interaction. You'll get to see how unreasonable it is. You get to see how reasonable Officer Shutt was during this interaction. She gave clear commands, and he tried to thwart that at every turn, and tried to dramatize when things finally became physical. And at the end of the proof today, you'll find that he beyond a reasonable doubt. I will abbreviate this offense, resisting arrest, but it's resisting stop, frisk, halt, arrest, or search, because at the time when he was taken into custody, he was not under arrest. But just for the purposes of abbreviation, I will say resisting arrest. I don't want that to confuse you. I just think it's a lot simpler to do. But you'll find at the end of the day that the state's proven beyond a reasonable doubt that he's guilty of resisting arrest.
Mr. Lockhart?
Like the judge told you, opening statements is just an opportunity for us to try to give you an idea where we think the case is going. We believe the proof will show that my client was not even there when and if somebody screamed or hollered that the neighbor called about. It'll show he was not involved in anything. It'll show that he was in the kitchen preparing a meal and had no idea why police even walked into his kitchen. The proof will show fears of white officers abusing young black men's rights. And you will see those concerns come through. He had strong beliefs about his constitutional rights and his right not to be abused by law enforcement. At the end of the day, you will see proof. Yes, he had a knife hooked on his belt. A lot of men carry those clip-on pocket knives. He had knives in the kitchen. The proof will show he didn't try to grab a knife, take a butcher knife in the kitchen. He didn't try to assault this officer. He didn't threaten this officer. He announced his beliefs in his constitutional rights and needing more information as to what was going on. The officer didn't just try to calm things down and explain things to him. He didn't give her his last name. Didn't have to. Made the officer mad, and so she's going to cuff him and grab him and throw him down, and she had to call in help to do that. At the end of the day, proofs go show, as required, and as a jury charge tells you, my client did not intentionally try to prevent anything. He was just trying to look out for his own rights as a citizen and as someone in his home kitchen cooking a meal that had nothing to do with any crime. Thank you.
Right. Mr. Roshi McCoy, first witness.
State would call this Tina Vaughn.
Call it third round.
Seat right there.
Do you solemnly swear or affirm that the testimony you are to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Can you please state your name for the record?
Tina Vaughn
And Ms. Vaughn, where do you reside?
at 825 Blakemore Road in Dixon.
And that's located here in Dixon County?
Yes,
Okay. Were you living at that address on or about May 31st of 2022?
yes,
Did you have an occasion to call police that day?
yes, I did.
And why did you call police?
I was outside and I heard someone screaming, "Don't hit me," about 4 times. And that's when I called 911.
Did you see anything?
I did not see anything.
Do you know the defendant, Dario Meeks?
No, I do not. I've never seen him.
And you can't testify today that you saw or didn't see anything that he did or didn't do?
No, I didn't.
Now, are you sure you knew where this was coming from?
Yes, I knew it's right across the street.
Okay. And how are you sure the address it was coming from?
Well, I know it was a young boy who lived there, and he was the one hollering, "Don't hit me."
So you had previous knowledge of one of one of the residents there?
Yes, I knew him and he had been over to my home, played with my grandkids.
Right. And is that at the 826 Blakemore Road?
I believe that's the address, or 824, I'm not sure.
And that's located here in Dixon County as well?
Yes, yes.
That's all I have this winter, Your Honor.
Mr. Luxon, do you have questions?
No questions.
Thank you, ma'am. You may step down and have a seat in the courtroom if you'd like.
It might pause briefly.
Okay, we'll next call Officer Jessica Show.
Officer Show. Come around, please. And we're going to ask you to raise your right hand and be placed under oath.
Please solemnly swear or affirm the testimony you're to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Can you please state your name for the record?
Jessica Schote,
And Ms. Show, where are you currently employed?
the City of Dixon Police Department.
And what is your position?
I'm a field training officer.
Okay, so does that mean you're a police officer? Okay, and how long have you been a police officer here in Dixon County?
Almost 6 years.
6 years. And were you acting under that capacity on or about May 31st of 2022?
I was.
And did you have an occasion to respond to an 826 Blakemore Road?
I did.
Is that located here in Dixon County?
Yes, sir.
All right, now, how did you respond? I mean, what started you responding to that residence?
We got called to domestic.
Okay, so is that through dispatch?
Yes.
Okay, and so you get dispatched to this call, and all you know, what do you know at the time? What was the information you're operating with?
Central Dispatch just advised that a.
Officer Show, pull the base of that microphone towards you just
I'm
a little bit.
sorry.
You can pull the base. There you go.
Okay. Is that better?
That's better.
Central Dispatch advised that the complainant heard yelling from the residents. I believe they said a male and female. So we went to it.
Okay, so when you get a call like this, what is your first concern when you arrive on scene?
Securing the scene. Domestics are one of the biggest unknowns that we deal with. One of the number one things that officers get killed and hurt in are domestic calls. So when we get there, we want to secure the scene, make sure everybody's good, check safety, check welfare, and then investigate
And when you say investigate, what do you mean?
to see if there was a crime that occurred.
Right. When you talk about secure, like what are you referring to when you talk about secure the scene?
Like, I don't know what you've got in your house, but in my house, I have guns. A lot of people have guns and weapons and different things. I don't want a bunch of people, I know people walking around with weapons or anything like that, especially with that kind of call. You want to make sure that you find all the people and secure your scene. You've
Okay,
got contact with all the people.
So you mean all the people? Is that, is that for the purpose of knowing who's there?
Yes.
Okay. Is there anything inherently dangerous about entering a household?
What do you mean?
Like, is there anything particular to like, is it your preference to have everybody come outside, or is it like, or would you rather go into an unknown building?
I mean, if I had my preference, of course I'd want them outside where I can see everything, but my preference is not usually given. We usually enter houses.
You don't operate under perfect circumstances.
Exactly.
Okay. So you arrive on this scene. Is there anybody with you?
Mason Albright, he's another officer.
Okay. Was he riding with you at the time? No. Okay. So he's just a backup officer. Yes. Did you have anybody? Were you an FTO at the time?
I was.
Okay. Did you have anybody riding with you?
No.
Okay. So you didn't have a trainee at the time. So who meets you at the door?
Miss Nancy Tyler,
And how do you announce yourself?
Dixon Police Department. I know Miss Nancy Tyler from previous encounters.
Okay. So you announce yourself as Dixon Police Department. What are you wearing?
My uniform.
Okay. Could you describe that?
It's a navy blue. It wasn't this one. It was our old uniform, but it's a navy blue polyester uniform I had a silver badge, my name on it. It was actually a nameplate, and then my duty belt.
Do you have police patches that say police like you have on right now?
Yeah, you talking about the badge?
Or in your shoulders?
Yeah.
Your Honor,
shoulder badge.
I'd like to request an out of jury, please.
Ladies and gentlemen, if you'll please step across. The
Go into the room, remain in the room till I come.
Mr. Locker?
Yes, Your Honor, I'm gonna move for a mistrial. The officer unsolicited stated that she knew Miss Nancy Tyler from previous encounters, which would allow the jury to infer that she'd been called to this residence before, and they could infer it has something to do with my client. No reason for her to state that other than to bias the jury, so I'd request a mistrial.
Mr. Brooks, any response?
I think that's harmless, Your Honor. I don't think it'd do anything
The
to.
officer said only that she knew this lady from previous encounter. She didn't identify it as being an encounter response to domestic violence, or whether it was an encounter at Kroger or Aldi's or Walmart, or where the encounter occurred, or what type of encounter it was. So therefore, court does not find that there is any prejudice to the defendant in this case and respectfully denies the motion for mistrial.
Your Honor, could we have a little out of jury voir dire in that regard?
Meaning what?
Was it encounters at this house?
It doesn't matter what we found out because of the simple fact that this witness has testified she knew the woman that answered the door from a prior encounter. There's nothing in that that indicates that your client was involved in any kind of illegal activity or any kind of problem activity. I'm simply saying that there's no reason that I understand why you would need to voir dire this witness about anything further outside the presence of the jury. Why?
If she testifies that the previous encounters did not involve my client in any way, then that would clearly make it a case where there won't be any prejudice. Right now, it leaves it wide
That's the
open.
question whether or not she ever had any prior encounters with this individual.
Have you had any prior encounters with Dario Meeks?
No, sir.
And were those calls with Miss Tyler related to Dario Meeks? The previous encounters, were they related
Go ahead and
to?
answer the question. This is very informal, but
No, sir.
I think that will handle this problem. Certainly no need for a mistrial. So
well, I've already denied your motion for mistrial, but we'll reaffirm that by letting you ask those questions on the false examination. Or the state can ask the questions if they choose to. It's up to you.
In honor, I mean, if it simplifies things, if you want to instruct the witness not to, talk about prior experience with this house or its inhabitants.
We're trying this individual only on the charges he's here. So any other experience with things that happened at that house in the past is not going to be admissible. So just confine it to what, don't volunteer any information about anything else like that. Okay. All right. And we're ready for the jury. Folks, I didn't tell you, you can sit anywhere you want to in that box now because there's no more assigned seating once we have the jury sworn. So find your seat that you're most comfortable with and go with it. All right. Mr. Brooks, you may continue.
So when you approach the house, who meets you at the door?
Miss Nancy Tyler.
Okay. And does she eventually let you in the home?
She does.
Okay. When you're entering the home, how many individuals are you able to see at that time?
Miss Nancy Tyler, and then I see Mr. Dario Meeks walk from the left side of that, like from the living room where she was at into a room to the right.
Okay. So when you enter the home, all you know at this point in time is that you have two people?
Correct.
At least. Okay.
Miss-
It could be more.
Miss Tyler told me, I asked Miss Tyler who all was in the house.
Okay. You don't have to say what she said, but did you eventually lay eyes on other people?
Yes,
Okay. From your recollection, how many people ended up being in the home?
I believe there were 6.
Okay. So you make contact with Miss Tyler. She lets you in the home, and all you can see at the time is two people. So you have as far as you're concerned, you're dealing with 2+ people. And at that point in time, what are you trying to figure out?
I'm trying to secure the scene and figure out if a crime happened.
Okay. So you're still trying to figure everything out. You only know 2 people there. You make contact with Miss Tyler, and then what do you do after that?
I go into the room to the right, which turned out to be the kitchen, and I make contact with Mr. Meeks
All right. And what is the purpose of making contact with Mr. Meeks?
to secure the scene.
Okay. And what is the first thing you say to Mr. Meeks?
I identify myself, tell him why I'm there, and ask for his name. And he immediately pulls out a cell phone, tells me he's not identifying himself. I again ask, I again tell him why I'm there, and eventually, I don't remember if it was that time or on the third time, he does tell me his name is Dario, but says he's not giving his last name.
Okay. Are you making any observations about Mr. Meeks at that point in time?
Yes, sir. So his demeanor was aggressive. He had a pocket knife on his pants. I believe it was on the right side. And he was standing by the kitchen sink. He had to turn around and look at me, but his demeanor was just aggressive.
Is there anything significant about him standing by a kitchen sink?
Yes, there is actually, because I don't know what's in that kitchen sink. I'm short. I can't see that kitchen sink from where I was at. I don't know if there's knives in that kitchen sink. There's hand grenades. I don't know what's in that kitchen sink. I also, like I said, I observed the knife on his waistband. That's what we consider an officer safety issue, which means that could be a big safety issue for me, especially given his demeanor that he was already acting. I don't know what's going on. I've gotten called for people screaming. That's all I know. So it is an officer safety issue.
Is it safe for you to conduct your investigation and somebody walk around behind you with a deadly weapon?
No.
Okay. What do you do after that initial interaction with him? He eventually gives you his first name. What happens next?
I eventually, after I've already asked, already explained, he's not wanting to cooperate. I go to detain him. And when I say detain, I mean put handcuffs on him. At the point we enter, he's already detained essentially. Like he's not free to go. We're conducting the investigation. So when I go to put handcuffs on him, it is because he's either a fight risk or a flight risk. Either I feel like he's going to run or I feel like he's going to fight. And at this point, his aggressive behavior, I felt like he was a fight risk, and I went to detain him in handcuffs.
Right. And did you give him any direction when you're attempting to do this?
Yeah, I believe I told him to go ahead and turn around.
All right. And what did he do?
He balled up his fist, like drew back and said, "Don't touch me."
Right.
Like in a fight-like stance, "Don't touch me."
All right. So would you consider that was that an aggressive manner?
Yes.
Okay. Now, you said he was detained. Was he under arrest at that time?
No.
Okay. Had he done anything illegal at that time?
I didn't know.
Okay. So he balled up his fist and he said, "Don't touch me."
Yes.
Okay. And then what did you do?
I went to, like I said, detain him. I went to grab his arm, and he's saying, "Don't touch me, don't touch me," and going around the kitchen, which I yelled for my partner at this point, and I believe he's saying, "Don't hurt me, don't hurt me." I can't remember exactly word for word what he was saying, but we were not hurting him. I was just trying to get him in cuffs so that I could continue the investigation. We eventually were able to get him in cuffs and detained.
So let's assume that he complies. Okay. Let's assume he complies. You get him cuffed. What happens next?
I would have conducted the investigation, found out that he was not involved in the domestic or did anything, and he would have come out of the cuffs.
What force did he use to resist this stop?
He was jerking himself away, like he wasn't allowing his self to be placed in cuffs. He was using force. He was tensing up, jerking his arms back, wasn't letting the cuffs go on him. It took, you'll see on the body cam, but it took me and Mason, FTO Albright, we had to really try hard to get the cuffs on him.
Did you have to force his arms back?
I did. I had to grab his arms like with force and put cuffs on him.
And you said it took 2 officers to do this?
Yes, sir.
Okay. At the time, how tall were you?
Same height I am now, 5 foot.
5 foot? Okay. And how much did you weigh at the time?
I think I was about 128.
Okay. Do you think you could eventually take him into custody yourself without Officer Albright there?
I would have had to use a lot more force.
Okay. How long have you been a police officer at the time?
I believe this was like 2 years ago, so about 4 years.
Okay. And did you go to a police academy?
I did.
Where did you go to police academy?
Toledo.
Toledo. Okay. Did you go through any use of force training?
I did.
And are there different levels of use of force?
Yes, sir.
Okay. Did you have to go, in this particular case, did you have to go beyond, what would you call the level of force you had to use against him in that incident?
Hands-on.
Hands-on? Okay. Did you have to go beyond that?
We didn't go beyond that. We went hands-on with him and were able to get him detained.
And when I asked that question, did you have to use a taser?
No.
Did you have to use OC spray?
No.
Did you have to strike him?
No.
You know, if I can approach the witness.
You may.
Officer Show, what did I just hand you?
My body cam footage,
And how do you know that?
because you played it for me earlier and I signed off on it.
Your Honor, I'd ask for that to be made Exhibit 1
Market is Exhibit 1.
and permission to publish. And I can publish straight from my laptop.
Turn the lights down.
Now, is this the front door of the residence?
It is.
Hello? Yes. Hey, who else here? My daughter. All right, where they at? And then, what was it? Who else here? My daughter is whatever. Is it where? Hey, sir, come on over here with me, please. What's your name?
What's your name?
Officer Shaw, Division Police Department.
So at that point in time, he asked you what your name was, and then you respond with your your name and your position.
Yes, sir. Or I don't know position, department.
Okay.
Okay, what's your name, sir? What's your name, sir? Sir, I'm asking you one more time, what is your name? Stop digging your pockets, okay? It's an officer safety issue. We got called about two people arguing, okay?
Okay. So at that point in juncture, where does his hands go?
His pocket.
And you warn him at that point in time, don't put your hands in your pocket, and you even say at that point in time, it's an officer safety issue.
Mm.
And then you even tell him while you're there.
I need to figure out what's going on, okay? What's your name?
I'm Dario.
What do you do?
I don't have to give you my name.
You do, I'm doing an
No,
investigation.
you don't, but I will give it to you.
What's your
I
name?
respect the officer.
Okay, what's your
My
name?
name's Dario.
Thank you, sir.
D-A-R-O.
D-O-R-O?
I-O.
I-O. What's your last name?
I don't want to get that information. You got my first name.
All right, go ahead and turn around. Hey, Mason, go ahead and turn around. Mason, go ahead, sir. Go ahead and turn around.
At that point in time, what is your command?
Go ahead and turn around.
All right. And did he comply with that?
No.
I'm telling you. Please don't touch me. Put your hands on your back. Don't touch me. Do not touch me. Please don't touch me. Please don't touch me. I'm asking you. Hey,
Okay. When he says I'm working with you, what is he physically doing?
Resisting.
When you say resisting, like, you said he was tensing up earlier. Is that what he's doing at this point in time?
Yes. He was pulling his hand away, which is why I was struggling on, Mason was on the right, I was on the left. I'm struggling to get his hand back to get him in cuffs.
So at that point, so he's saying one thing, but he's doing another.
Correct.
You're not. Don't hurt me. Nobody's hurting you. I'm trying to. Yeah, they didn't know what we were. No, we don't talking about. Step outside, sir. I'm not gonna keep on asking you. Sorry. Hey, do you read them up? You come up one, please. What's your name? I told you my name now. You did. Hey, give me that. No. What are you doing? You can't. I'm checking you for weapons. That's a weapon. You need to stop. You can't do this. Yes, I can. What is your name, sir? I told you my name now. What is your last name? Bradley. Sir, we got called to domestic assault. I'm investigating. The homeowner told you there was nothing wrong. Okay, everybody told us there was nothing wrong. That's what we get told every day. Where's your wallet? No, don't touch my stuff. I'm checking you for weapons. You have no reason to be touching me. No, I do. Period. Right now, you're impeding investigation. No, there's
Yes,
no such
you
thing
are.
as that. There's no such thing. There is. There is no.
You're interfering with
Constitutional order. What's the name?
That's fine. What is your name?
My checks big balances. That's none of my business. It's a nonprofit organization.
What is your name?
My name is Dario Meeks. I'm gonna give it to you because I want you to let me go, please.
I'm not gonna let you go. What's your, date of birth?
No, I'm not giving you that information. I don't have to. Please let me go. Why am I being arrested?
Right now, you're being detained for investigation. So, like I've explained to you numerous times, and you're not cooperating.
Can I talk to the sergeant? What? Talk to the sergeant. Let me talk to the sergeant. No, I'm you talk to the sergeant. No, it's not.
Hold on.
I'm in handcuffs. Yeah, what are you doing? I'm trying to cook my dinner. Look, I got water running. I need.
From one of the neighbors at her screening. When I came and you committed a crime, we're just saying that we need to detain people here and figure out what's going on. Okay, now.
Is that an accurate depiction of your interaction with Mr. Meeks that day?
Sir,
Do you see Mr. Meeks here in the courtroom?
I do.
You describe where he's sitting and what he's wearing.
He's sitting right there and wearing a suit.
Right up the record could reflect that the witnesses identified the defendant.
The record will reflect.
Now, when you're searching and you walk into his car, walking into your patrol car, is he complying then? Is he walking with you or?
Yeah, he was walking.
Okay, so he didn't use force at all to turn around or anything of that nature while you're escorting to the vehicle?
Oh, not that I recall.
Okay. All right. That's all.
While I was patting him down though, and I removed the weapon, he did jerk away from me again.
Okay, so when you were searching him, he was still continuing to physically jerk
Yes.
away and, okay. That's all I have this one, Sean.
All right, Mr. Lockridge, you may cross-examine.
You testified Miss Tyler invited you to come in. Did she invite you to come in on that video?
What do you mean? She opened the door. We asked her
I
to
understand
use it. Yeah.
You testified that she allowed you to come in. Did you ask her to come in?
I don't recall asking. She opened the door.
So if someone opens the door, that means come on in,
Typically.
typically. All right. So all you gotta do is knock on the door, and if they open the door, you can go in and search and do whatever you want to do.
No, I didn't say that.
Did Mr. Meeks have a gun on his person?
No, sir.
He didn't have any drugs on his person, did he?
No, sir.
You didn't have an arrest warrant for him,
No, sir.
and he was told that he was just being detained.
He was being detained.
Right. But
Until
actually,
he resisted. And at that point, when he's resisting, then he was under arrest.
but outside, he is told that he's just being detained for the investigation.
I was trying to explain to him, yes,
And what does it mean to detain somebody for the investigation?
that they're not free to go.
Okay. Until the investigation is done.
Correct.
And when he's outside, he's told he's being detained. He doesn't try to run off.
I have a hold of him, so no,
Did he try to run off?
no.
He could have jerked away from you, couldn't he?
He did jerk away from me.
Could he have jerked away from you and run?
I mean, I guess he could.
And so he was detained in cuffs in the yard. And was the investigation then finished?
He was detained in cuffs in the house. And no, the investigation was not finished.
Was he taken out into the yard in cuffs?
Yes,
And was he told that he was being detained for the investigation?
yes,
Which would imply, once the investigation is finished, you'd uncuff him and he could go back and cook his food.
like I explained, normally that would be what would have occurred. However, when he resisted, that is no longer the option.
You said he resisted, but he's told you're being detained. He's told that out in the yard.
He resisted when I told him to go ahead and turn around. I was going to place him in cuffs in the kitchen. He resisted at that point. He balled up his fist pulled him back and said, "Don't touch me," and pulled his arm away, walked away from me in the kitchen.
I'm just trying to ascertain. Were you placed him under arrest in the kitchen?
I was detaining him in the kitchen to continue the investigation.
Okay. And then even outside, he was told he's being detained for the investigation.
Yes,
And how long before you finished the investigation?
I don't remember how long it was.
Ballpark, was it 2 days, 3 days?
No, it was maybe an hour or so.
Okay. So the implication is he's told he's detained inside for the investigation. He's told outside he's detained for the investigation. But that wasn't the truth, was it?
Yes,
Well, if he was detained for the investigation, then why wasn't he released at the end of the investigation?
because he resisted.
Was he told he was under arrest for resisting arrest?
Yes,
He was?
yes.
Inside the house?
No, he wasn't under arrest. I was attempting to detain him for the investigation. And then when he resisted is when he was essentially under arrest.
Okay. But even outside the yard, he was told he was just being detained.
Correct. I
Is
was
that
trying to
true?
explain to him, I was trying to explain to him that that's what it was. Like I had explained to him that he was being detained for the investigation.
So was that the truth when he's told that in the yard? He was being detained for the investigation? Was that true?
Yes,
Okay. And if someone's detained and you ascertain they haven't done anything wrong, then what do you do once that is determined?
if they're detained
Yes.
and they haven't done anything wrong, then like I've already explained, I take the cuffs off if they're in cuffs and they go on about their day, which would have happened.
I'm just trying to ascertain. When you told him he was detained in the house and also outside in the yard, the implication is we're just holding you in cuffs till we finish the investigation. Is that correct?
That was, yes, yes, I've explained to you, that's what, he was being detained for the investigation when I tried to place him in handcuffs. Yes, because he was a fight risk in the kitchen. So I'm trying to finish the investigation so we can get out of there. So yes, he was being put in cuffs for the investigation.
And the same is true when he's taken outside. He's told you're just being detained.
Yes,
Okay. So outside in the yard, whatever's happened in the house has already happened.
correct.
And even after that, he's told in the yard, you're just being detained for the investigation.
He's told that, yes.
Okay.
And then I send him out with my partner who is talking with him. And then later I come out and I explain to him that he is under arrest for resisting. If that's what, I believe that's what you're trying to imply.
I'm just trying to ascertain, if he's cuffed, he's outside, and he's told you're just being detained for the investigation, why then is he not released after the investigation is done?
Because he resisted.
What did he do out in the yard that caused you to want to arrest him?
He resisted again, outside. He resisted in the kitchen. He resisted outside. But sir, I believe I took him over there to my partner so that I could continue the investigation. His resisting, it was already done at that point. I let my partner deal with him and I went back to help my other partner that was in the house continue the investigation of the domestic because we still hadn't been able to deal with that issue.
The living room was full of people, is that correct?
I believe there were 6 people total in the house.
And how many of them were detained?
They're all detained.
Were they told they were being detained?
I'm not sure. They're detained. They're not free to go. If they would have tried to leave at that point before the investigation is continued, then yes, they would have been told, but nobody else gave such issues during the investigation.
And what did you do to secure the scene with that many people walking around in the living room? What actions did you take?
We did a protective sweep of the house,
Okay.
and there was actually another arrest made at that location right after we dealt with, right after we got done with the investigation.
Okay. But in regard to those people walking around, Were any of those people ordered to sit on the couch or don't stand up, don't walk around? What was?
Yeah,
what were though?
they were sitting on the couch, but I was outside with Mr. Meeks until I went back in. When I went back in, they were sitting, my other partner had already had them sitting on the couch.
When you did the protective sweep, did you find any other weapons in the kitchen?
I don't remember. I believe there were knives in the sink, but I can't say 100% sure.
Okay. And there wasn't any hand grenades in there?
Wasn't no hand grenades.
Okay. He didn't have to give you his last name, did he?
Essentially, no, I mean, anybody can refuse to give information. While we're doing a investigation, we do ask for that information, and we are allowed to ask for that information.
And when he wouldn't give you his last name, that's when you decided you were going to cuff him.
That's not true.
It's not true?
Nope.
That's all the questions I have.
Mr. Brooks, redirect.
Nothing more this officer on.
Right, thank you, officer. You may stand down. Brooks, you may call your next witness.
That is the state's proof, Your Honor.
State has rested their proof, Mr. Lockett. Ladies and gentlemen, if you'll step across the way for a moment, please. Mr. Lockhart, the state has rested their proof. Do you wish to consult with your client about testifying?
I do, Your Honor.
You want to step outside to do that?
If I could.
We think it'll take long enough that I should send the jury to lunch, or
As close as we are to lunch, I think so, Your Honor.
what?
As close as we are to lunch, I believe that would probably be the best idea.
Why don't we just break for lunch and come back at 1 o'clock?
Thank you.
Tell the jury that we're going to break for lunch and have them come back at 1 o'clock and gather in the jury. Well, let's see. Bring them back in because I need to make sure they follow the instructions.
Yes.
Helps if my mic isn't muted.
We've got one missing.
That's all right. Good. We're good. We got all 13.
Oh, we do?
Yes, sir.
I can't count apparently. So. Ladies and gentlemen, it's close to lunchtime and we're going to go ahead. There are a couple of things that are going to have to be taken up outside your presence. What I'd like to do is let you go ahead and go to lunch and just be back in the jury room at 1 o'clock. When you come back in, the officers will be assisting you to bring you directly back into the jury room. I would remind you that the instructions I've given you are that you should not try to do any research. You should not discuss this case with it among yourselves or let anybody talk to you about it. Just don't think about it while you're going to lunch. This is being live streamed on YouTube, as all of my cases are. And you just do not go to YouTube and do not try to watch any portion of this case. You're not being shown on YouTube. You don't need to look at anything regarding that until after this case is over. All right. You are free to go to lunch if you will follow Officer Howell. Let's take him out back in the hallway and out that other way. All right.
Just want to make sure they don't have any discussions. Oh, I lost this slide.
All right. We will stand in recess for lunch until 1 o'clock. Place you under oath. Let's have Mr. Meeks come around to the podium.
Wow, that's a very crispy camera.
Mr. Meeks, I've been handed a waiver of your right to testify. I just need to do this on the record. So if you'll raise your right hand, let's place you under oath.
Do you solemnly swear or affirm the testimony you're giving this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your full name for the record.
Dario Meeks.
You can put your hand down Mr. Meeks, I've been handed a waiver of your right to testify, which states that you've had explained to you that by your lawyer that you have a right not to testify, and if you don't choose to do so, you don't have to testify, and the jury will not draw an inference on the fact that you didn't testify. Do you understand that if you have a right to testify, nobody could prevent you from testifying? You understand that?
Yes, Your Honor.
All right. So do you understand, first of all, you have a right to testify if you want to, and nobody can stop you from that?
Yes, Your Honor.
You understand that if you choose not to testify, nobody can force you to testify, and no inference will rise with the jury that because you didn't testify.
Yes, Your Honor.
All right. Do you understand all of these advantages and disadvantages that you and your lawyer have talked about?
Yes.
All right. And your decision to not testify, is that a freely made decision? In other words, nobody's forcing you to do this?
Yes, Your Honor.
All right. I find that he has voluntarily waived his right to testify, and we'll go from there. Thank you. You can have a seat.
Thank you.
Mr. Lockhart, do you have any other proof?
No, Your Honor.
All right, then we'll show that the defendant has rested his proof as well. I have reviewed the draft of the final charge of the court, and I'm going to make one change to that. On the bottom of page 3, there was language including that I included in the defendant's plea of not guilty as a plea of self-defense. There's been no evidence presented to the court of any evidence that would justify self-defense as a defense, but I'm striking that paragraph at the bottom of page 3. But the remainder of that, the use of force against another is not justified to resist an arrest or halt unless the officer uses greater force than necessary to make an arrest. That will be included, which is essentially the language that Mr. Lockhart had requested in his proposed threat. So the language that you had requested, Mr. Lockhart, is included. It's just the self-defense portion of it. This is not a self-defense case that I can find. So, all right, and Mr. McKinney will then run the final draft of that by removing that one paragraph. Everything else will remain. We are ready for the jury and for you to make your closing arguments. When the jury comes back, I'll let you state on the record that you rest your case.
Yes, Your Honor.
All right, ladies and gentlemen, thank you for your patience and cooperation. At this point, the state has rested their proof. Does the defendant wish to offer any proof?
Your Honor, we offered no proof.
All right. Defense has rested as well. So you have now heard all of the evidence that you're going to hear in this case that upon which you'll make your decision. So now both lawyers have an opportunity to make a closing argument. So the state will go first and the defense will follow.
Pull it up whenever you're ready. I can speak for everybody in here. We genuinely appreciate y'all's time. You know, I know it means a big deal to us attorneys when we can get 13 people off the street and we're willing to give up their time for something like this. Okay. Ladies and gentlemen, it's very simple. Like, it's on video. It is very apparent when police make lawful contact with Mr. Meeks, that he's expecting this, that he's looking for his event. From the very get-go, as soon as Officer Shook begins talking with him, his phone is raised. He's looking for this incident. He knows exactly what he's going to do and what he's not going to do. And he's definitely not going to comply with any order given by Officer Shook. The video clearly shows that Officer Shook conducts herself professionally, that she answers all of his questions to the best of her ability. She identifies herself as an officer. The fact that she's a police officer is an element of this offense. She's wearing full duty uniform. It cannot be misconceived that it is a fully commissioned officer giving these demands to him, and he intentionally does not comply. He intentionally obstructs that stop, that frisk. Officer Shook testified a lot of the reasons why she was doing the things that she was doing. The fact that she's conducting an investigation, her first objective is to make sure, one, everybody's safe, and two, whether an actual crime has been committed. She's not in there, she's not in there with a thought of, oh, I can't wait to lock somebody up for resisting me.
She's not looking for that type of trouble. Mr. Meeks was looking for that type of trouble, but she was not. She was simply trying to make sure everybody was okay. But he was hindering that. There was, he had a pocket knife at his side. He was at a sink. He would not, he would not comply to come over here. When finally, when they placed him in cuffs with their safety, he balled up his fist. He said, "Don't touch me." He felt the need to do that to a 120 pound soaking wet female officer. He felt the need to ball up his fist and embrace and said, "Don't touch me." And then when she finally places him in cuffs, or her and the other officer, when they finally place him in cuffs, he's tensing up, he's pulling away, he's trying to turn into him. He still is not complying with the direction. And what does Officer testified to? She says if he had just complied, he would have eventually been let go, and there was no other reason to take him into custody. Like, this is solely created out of thin air on the defendant's attitude and actions. The one thing, and I'm about to replay the video for you so you can make up your mind for yourself. But the one thing that sticks out to me more than anything is the narrative that he is trying to paint from the get-go. As soon as the officers lay hands on him, he is being overly dramatic, saying, "Don't hurt me. You're hurting me. Don't assault me," with this 120 pound female. And you can see the video. Nobody's punching him. Nobody's striking him. They're trying to place his hands behind his back. Officer Show testified that they did not go beyond contact with him. They simply tried to place his hands behind his back. And he is dramatizing it from the get-go because he's trying to paint a narrative. It is very evident that he's trying to paint a narrative of what's going on because he's looking for this event. And you don't have to take my word for it. I think it's very evident on the video. I'm going to play it for you right now.
Hello? Yes. Hey, who is here? My daughter. All right, where they at? And then the front door. Who is here? My daughter is in where? In the room here. Hey, sir, come over here with me, please. What's your name?
What's your name?
Officer Shaw, Dixon Police Department.
Okay.
Hey, what's your name, sir? What's your name, sir? Sir, I'm asking you one more time, what is your name? Don't dig in your pockets, okay? It's an officer safety issue. We got called about two people arguing, okay?
Okay.
So I need to figure out what's going on, okay? What's your name?
I'm Dario.
What is it?
I don't have to give you a name.
You do, I'm doing an investigation.
You don't, but I will give it to you.
What's your name?
I respect the officer.
Okay, what's your
My
name?
name's Dario.
Thank you, sir.
D-A-R-O.
D-A-R-O?
I-O.
I-O. What's your last name?
I don't want to get that information. You got my first name, that's all.
All right, go ahead and turn around. Hey, Mason, go ahead and turn around. Mason, go ahead, sir. Go ahead and turn around.
Don't touch me.
I'm telling you.
Please don't touch
Put
me.
your hands behind your back.
Don't touch me. Do not touch me. Please don't touch me. Please don't touch me. I'm ready. I'm working with you. I know.
You're not.
Don't hurt me.
Nobody's hurting you.
Yeah, we're not talking about.
Step outside, sir. I'm not gonna keep on asking you.
Hey, Junior, we come on, Vaughn, please.
What's your name?
I told you my name now.
You did.
Hey, give me that back.
No.
What are you doing?
You can't. I'm checking you for weapons. That's a weapon. You need to stop.
You can't do this.
Yes, I can. What is your name,
I
sir?
told you my name now.
What is your last name? Sir, we got called to domestic assault. I'm investigating.
The homeowner told you there was nothing wrong.
Okay, everybody told us there's nothing wrong. That's what we get told every day. Where's your wallet?
No, don't touch my stuff.
I'm checking you
Stuff.
for weapons.
You have no reason to be touching me.
Sir, I do.
Period.
Right now, you're in pending investigation.
No, there's
Yes,
no such
you
thing
are.
as that. There's no such thing.
And there is.
There is no.
You're interfering
I'm a
with
constitutional order. Look at my name.
That's fine. What is your name?
No checks, big balances. That's none
Okay.
of my business.
What?
Nonprofit
Okay,
organization.
what is your name?
My name is Dario Meeks. I'm gonna give it to you because I want you to let me go, please.
I'm not gonna let you go. What's your, date of birth?
No, I'm not giving you that information. I don't have to. Please let me go. Why am I being arrested?
Right now, you're being detained for investigation. So, like I've explained to you numerous times, and you're not cooperating. Go, walk.
Can I talk to the sergeant?
What?
Talk to the sergeant. Let me talk to the sergeant. No, you can't talk to the sergeant. This is not disrespectful. No, it's not. Are you kidding me?
Well, hold on.
I'm in handcuffs. And don't throw you down. Don't be like, what are you doing? I'm trying to cook my dinner. I got water running. I need from one of the neighbors that heard screaming. When I say that you committed a crime, I know. This is saying that we need to detain you here and figure out what's going on. Okay, now.
One important thing to note that I think is extremely relevant to this case, it goes to his intent, is that the defense is going to argue that, you know, the officer never really explained anything to him. He didn't really know what was going on, but you can see clearly officer showed many attempts to explain what's going on, but he's not hearing it. He's not really engaging. He's not really listening. Okay. He's not trying to figure out what's happening. He's trying to be right. He's trying to, you know, assert himself. He is the last of his concerns is what's actually going on. And it's very apparent with his interactions with Officer Show. Now, it's very important to note when looking at the jury instructions you're about to get, things to consider, things that I think might confuse some people, is that force must be used to resist, okay? And you'll read plainly in the jury instructions that force is not necessarily assault, okay? The defendant is not charged with assaulting an officer, all right? So he did not use violence, okay? He did not assault Officer Show, but the force he used was, one, he pulled away when giving commands to turn around. He bladed his hips. He balled his fist. That's one use of force. Two, when officers placed hands on him, he tensed up. He pulled away. That is another example of his use of force to resist. And then outside the house, when she's conducting the search of his person to make sure he doesn't have any other weapons on, he's still turning away, pulling away. Okay. Another relevant element is intent. He must be acting intentional. And there's just no question that his actions are intended, okay? He didn't accidentally do these things. He may be trying to control the narrative by, you know, blurting out certain things while everything's going on, but it's very apparent that his body is acting intentionally, okay? And just from the get-go of his interaction with Officer Show, this is what he's expected to happen. He was looking for this type of encounter. He's going to paint this out to be some massive obstruction of justice. And it's very important. The one thing I just noticed watching the video with you is that, you know, you may not be able to clearly see, you know, body cams aren't, you know, cameras aren't perfect. Okay. Unfortunately, this isn't the NFL. All right. I don't get to pull up several different angles on the 50-yard line of why the referee missed the call. Okay. That's just not realistic. You know, it's funny, ring doorbells seem to be better than anything, but we just, you know, cameras aren't perfect, so they don't tell the whole picture, okay? But that's supplemented with Officer Schultz's testimony, okay? But one thing you can plainly see is the other officer, okay? Because who really is the other officer that can really lay down the force on this defendant? It's the large male officer that's assisting Officer Schultz, bring him into custody, and you can plainly see the male officer's actions. He literally is just holding him in escort position, and at that time he's like, "Don't hurt me! Don't hurt me! Don't assault me!" And nothing's happening to that effect. It's because he's trying to control this narrative. After carefully reviewing this evidence, I would submit to you that you will find beyond a reasonable doubt that Dario Meeks committed the offense of resisting arrest, stop, frisk, and hold. Thank you.
Mr. Locker.
I want to thank you for your time and attention. As the court has instructed, closing arguments is not evidence. So General Brooks saying that he's trying to control the narrative, that's his opinion. I can argue that a young black man in today's world has a right to be concerned about what white officers may do to him. I know that we don't see bad stuff like that happen all the time, but you see it on the news enough. If you're a young black man, you may have concerns. He's not on trial for having a bad attitude. He's not on trial for trying to assert his constitutional rights. The general told you in this case, he didn't have to give his last name. He wasn't violating the law by not giving his last name. But what's the first thing that happens when he refuses to give his last name? Y'all have watched it. This officer, as soon as he doesn't give the last name, she doesn't like that. And in her mind, she thinks, I'm taking you down. You won't give me your last name. I don't care if you're required to legally or not. You didn't give me your last name. I'm going to take you down. And that's immediately what she does, is tell him to turn around and attempts to place cuffs on him. There's all types of analogy to describe how quickly that officer was on him. One of the ones that I like in today's world is it pissed her off so much that she was on him like government funding for a bad idea in the federal government, or green on grass. You've heard those type things. But here's the bottom line. He did not have to give his last name. He didn't violate the law by not giving his last name. She could have continued to talk to him and try to get information. But as soon as he wouldn't give his last name, she's on him. And he's being placed in custody. And she calls in help to place him in custody. It's not unlawful for him to want to video what's taking place to protect himself. This is a fine young officer. She wasn't there to hurt him, nor was the other officer. But this young man doesn't know who they are or what's going to happen. He knows that he's not involved in anything. They've told you he wasn't involved in anything related to this call whatsoever. No arrest warrants for him. He wasn't violating any law. He was in his kitchen cooking a meal. He had a right to be there. And I submit to you, if you're in your kitchen cooking a meal and you don't want to give your last name to an officer, they shouldn't put you across the table and put handcuffs on you. So I submit he was not intentionally obstructing an investigation. He was detained. Even in the yard, he was told, you're just being detained. The investigation was complete. If the officers are telling the truth and he's just being detained when the investigation is finished, why didn't they turn him loose? Because this officer wanted a pint of blood. She wanted to charge him with something because he wouldn't give her his last name. So I submit to you, when you think of resisting, you think of people punching and kicking and running and doing things like that. You don't see that in this video. He's not throwing elbows or kicking or doing anything of that nature. He makes a mistake of not giving his last name. She didn't like that. And as soon as he didn't give a last name, she's going to take him in custody because she wants to. She's an officer and she wants to do that, so that's what she does. The judge will charge you in regard to the law, but one of the things that he'll tell you is if a defendant, being my client, was in a place where he had a right to be, in his kitchen, in his house, he had a right to be there, he would have a right to use force against the alleged victim, this officer, when and to the degree the defendant reasonably believed the force was immediately necessary to protect against the alleged victim's use of unlawful force. There again, he didn't give his last name. Was he allowed to use reasonable force to keep from being handcuffed and not giving his last name? I submit to you, you can find that was reasonable, that he didn't want to be handcuffed, that he tried to pull away. I submit that was reasonable. But I'll submit to you, when you think about your mind having to rest easy as to the guilt in this case, when you look at force, and the judge will tell you, force means compulsion by the use of physical power or violence. That's not what we have in this case. He's not hitting, throwing elbows, kicking, biting. He's not doing anything like that. Your mind shouldn't rest easy to putting a criminal conviction for resisting arrest on this young man's record. It's not there. This officer was young, a little apprehensive. She didn't know if there's an ice in the sink or hand grenades. I understand her being apprehensive. I submit to you, they both have learned a lesson. Next time, she may not throw somebody in cuffs or try to when they don't give the last name. She may talk more. This young man, hopefully, has learned something about his attitude and not giving his last name. Sometimes you have to learn the hard way. But I submit in this case, a jury can come back and find that there's not proof beyond a reasonable doubt. And what needs to be accomplished could have been accomplished in this case. Even after he's taken outside, he's told he's being detained until the investigation is over with. The officer testified, I think she said less than an hour, the investigation was over with. If he's detained for the investigation, why didn't they let him go? She wanted her pint of blood. She wasn't content just to take the cuffs off, say, go back and fix your dinner. Nope. She wanted her pint of blood, so she arrested him for resisting. And I submit your mind should not rest easy as to convicting this young man of the criminal offense of resisting arrest. Your mind should not rest easy based on what you've seen on this video. It's not about whether he had a good attitude. You probably, if you got kids, you probably kick him in the rear end and you tell him, just give him the last name. Hopefully he knows that now. But you don't convict somebody of a crime because they wouldn't give their last name when they're not required to. So I submit to you, go back, deliberate. You've seen the video, you've heard the testimony. I just submit to you that there's not evidence that he intentionally used compulsion or physical power or violence in this case to resist a stop, frisk, or halt. Thank you.
Mr. Brooks, you have the final say.
Defense can't have it both ways. They can't, in one sentence, say she was a fine young officer, and then 5 minutes later say she wanted her pint of blood, insinuating that Officer Shutt was just being vindictive. You know what? He pulled back on me. I'm gonna arrest him. It's not the case. He wants to make a big deal about the fact that she told him he was detained towards the car. And you saw the interaction. Like, he wasn't listening to any explanation. Like, if he actually talked with Officer Shutt, he may have got a further explanation of what was about to happen. But whatever she told her walking to the car does not change his acts in the house and right outside the house. He was being stopped and detained at that point. He was resisting. He was not complying, and he was using force to do so. The defense wants to belittle his actions and say, well, it wasn't violent. Well, it doesn't require violence. If violence is in play, he'd be charged with other charges, like assault on an officer. He wanted to make a big deal in his cross-examination about evading. Evading's not part of it. Okay? Evading is a whole separate charge. Okay? He can't have his cake and eat it too. He can't say, well, she was, she was a young, fine officer, but she was out for blood. He can't have both. And it's convenient to argue, well, they both learned their lesson, and you should just acquit them because they both learned their lesson. That's not fair to the state. It's not fair to these acts. It's very important, the situation this creates, the danger it puts not only the police officers in when you don't comply with direction, but the danger it places himself as a young man, as a young black man, according to the defense, the danger it places himself when he just doesn't listen. The attitude itself is not the crime, but it clearly shows his frame of mind when he's dealing with police. It clearly shows his intent that once directions are starting to be given, that he's not going to comply with said direction. It is very clear that he's looking for his moment, and it belittles every actual bad use of force, bad stop. It belittles all the people that actually go through that type of thing throughout the country. It belittles those acts. When we have someone like him trying to go, oh, don't hurt me, don't assault me, and it's a 120-pound female officer. It belittles those acts, the true acts. The defense would have you believe this is the face of police oppression right here, ladies and gentlemen. Right here. That's the face of police oppression. That's all I have.
Poll is up.
All right, ladies and gentlemen, if you'll read along with me. Ladies and gentlemen of the jury, the defendant Dario will deal with it. All right, you may now retire to the jury room and begin your deliberation. Court will be in recess pending the return of the jury.
Okay.
All rise.
Court is in recess pending notes from the jury. We have 8 votes and 21 people in chat. Whoa, these votes are varying so much. This is so interesting. And in the meantime, We have another quick trial that's Turner v. Destiny Church, wrongful death. Or we have the divorce thing that I was talking about. Or a DUI. Let me see what else. Maybe I must make that the next poll. Hopefully you're going to save us Destiny's Child. Okay, I'm going to skip to the jury coming in. And then...
Yes, sir. That'll be quicker than having a question.
And then I will say our verdict and then play the verdict music and then their verdict.
You have your copy of the final charge. What? Mr. Brooks, you have your copy of the final charge. Would you hand it up here, please?
Yes, sir.
That'll be quicker than having a question. All right, ladies and gentlemen, I've been handed a question. Do we have to see him guilty of all three? But I want you to, I'm not sure exactly what that refers to, but I want to explain two things. Number one, the defendant is charged with the offense of, of a resisting a stop or a frisk or halt or arrest or a search. Those are alternate. Those are things that all fall into the idea that an officer has the power to do that. But you do not have to find that to find the defendant guilty. You do not have to find all of those different things. But you do have to find all three of the elements that are set forth on page 3 of the judge's instructions. And those are that the defendant prevented or obstructed a stop or a frisk or a halt or arrest or a search by a person known to be a law enforcement officer, and that the defendant used force against the law enforcement officer, and that the defendant acted intentionally. Those are the three elements. But you do not have to find that there was a frisk, a halt, arrest, and a search, and a stop. None of those, all of those are alternates that you can find apply. One of those applies, then it all right. Does that answer the question? All right, then you may return to your deliberations. Thank you.
Holy moly.
We will again be in recess until the jury returns.
Your Honor, just to make sure we're covering all bases, when the court gives an instruction like that, does that not have to be reduced to writing?
It should be. I will reduce it to writing and make it a part of the court's charge.
And should the jury deliberate before they get that?
Well, I think they have gotten the initial charge, which has that three-part definition. My explanation of the elements of stop, risk, and so forth, in my opinion, are not required of a written charge, but we'll have them stop deliberating until I can get them.
Thank you. They do have to be in writing. Yeah. Can't give it to the jury. I've seen them reverse where that was not given. I think that's proper.
Not Mike.
Drag things out, but I like it to be done right the first time. Because I mean, if they convict Dario, I still don't know, no problem. I mean, seeing this convicted. Oh, I see how it is.
I believe in accountability. That's what I do believe in.
What does that mean? I believe in accountability.
Now's when it would be handy to have a now's when it would be handy to have a court reporter transcript.
There isn't one.
It's being recorded, but under the case law, when supplemental instructions are given, they have to be put in writing and given to the jury. And that's the case of reversed, where they
I'm not skipping because the hot mic is interesting. Except I think she turned it off.
And hand them that written instruction so they can deliver it. Bring the jury in, please.
Doctor, can we hear the
Pardon?
instruction? Can we hear the
You'll
instruction?
hear it when I read it.
At that point, can we request changes?
You can request changes, certainly. Hold on. The instruction I'm about to give them is this: ladies and gentlemen of the jury, in answer to your question, you, the jury, are not required to find that the defendant resisted a stop and a frisk and a halt and an arrest or search, only that the defendant resisted a law enforcement officer performing one of those tasks. You're required to find beyond a reasonable doubt all of the three elements as set forth in the final jury instructions. That's the instruction I'm giving them. All right, bring them in.
That's so confusing. I also don't like the wording, you're required to find him guilty. You're required to find him guilty. Even if the rest of the sentence is beyond a reasonable doubt, you don't want a person of authority saying those words. So I find this guy, no, I'm not going to say it.
Ladies and gentlemen, I'm sorry for the inconvenience running you back in, but your question necessitated me to give you a written instruction on the supplemental charge. So I'm going to give you this supplemental charge of the court. In answer to your question, you, the jury, are not required to find that the defendant resisted a stop and a frisk and a halt and an arrest or search, only that the defendant resisted a law enforcement officer performing one of those tasks. You are required to find beyond a reasonable doubt all of the three elements as are set forth in the final jury instructions. So that's the instruction I'm giving you. I'll hand this to the clerk. You may now retire and begin your deliberation. Let us know when you've reached your verdict. You will step back across the hallway.
Okay, timestamp 4:22:06, because till the end is very close for the verdict.
We will again stand in recess until they've reached the verdict.
Right, if you haven't done your verdict, now's your time.
The edges, but these are the Tennessee Code annotated statutes. This is what it says: individual detention for offense or obstructs anyone they know with law enforcement officer, someone acting in the officer's presence and at the officer's direction of effecting a stop, frisk, halt, or arrest. That's the statute.
Oh dear.
And that's where the jury instruction. That's where the jury instruction goes.
Gosh, I think according to the instructions, he's guilty.
Federal government over that. Well, it's two sovereign jurisdictions so far. It's been upheld in state and federal court.
Not according to this agreement.
All right.
I'm told the jury has reached a verdict, so we'll bring the jury up.
Okay. I'm going to play while they reach their verdict, and then I'm going to close the poll. And then music. I mean, while they walk in. Okay, closing the poll. The time is 4:25:33, so maths people got a maths. Our poll says verdict 64% not guilty, 35% guilty. Here we go.
Please stand. As to the indictment on the charge of resisting a stop or frisk or halt or arrest or search, how do you find the defendant? Guilty or not guilty?
Not guilty.
Not guilty. Is that the unanimous verdict of all 12? Thank you. Ladies and gentlemen, I know it's been a long afternoon, a long day, but thank you for your participation and your diligence in trying to resolve this case. I appreciate your putting in the work, and this will end your jury service for this term of court, and you will not have to be worried about jury service for 2 years. Thank you again, and as I said, if you have suggestions, be sure to give them to Officer Howell on how you can improve your service. They want a vending machine in the courthouse. We'll see you want to put that on your list. Thank you, ladies and gentlemen. We'll step back to the officer. Please, the jury's attention to the not guilty of the charge of court stands adjourned.
Thank you, Your Honor. Your Honor, where are we going to have our motions tomorrow? In here?
Okay. I am very glad that that was not guilty. I was very worried for a minute there. The statute said you may not obstruct an officer. And then when he went into it, I can't remember what word I heard, but something made me go, oh. Okay, now we're going to have to do a very quick poll. We have what next? We have wrongful death, child custody, and the last one I said was DUI or DWI. I can't remember. All right, you're going to have to vote like quick, fast, or we're going to have 0 to watch. Steve! That was a bad place for me to pause.
Okay.
Shame, let me actually just put Phoebe and I. Shame, she's so fast asleep. She doesn't even care that we just had that verdict music. Actually, I want to switch these over while we're not listening to anything. Okay. Listen. Can I still hear myself? Oh, thank goodness. I can hear myself in my earphones. Oh, that was so cute. Okay, let's see where the poll's going. 10 votes for wrongful death, 0 for any others. Okay. This is also from 2022. Close that, close that. Oh, I must check my recording. I think I can skip a lot here. Mm-hmm.
Thing that witness said. On the other hand, if you decide that the witness lied about some things, but told the truth about others, you may accept.
Gentlemen, opening statement is the
Suits.
Okay. Hello.
Civil lawsuit, the plaintiff always had the burden of proof, so they will always be able to go first. And at this point, Mr. Kennard, you or Ms. Morris are able to make your opening statement.
A great start.
You would not believe how often that happens. This sound system is not the best in the world. So. It makes you feel any better. I usually drop this microphone about twice a day.
All right, good morning, ladies and gentlemen. My name is Mary Ellen Morris, and we, Mr. Kennard and myself, we represent Jean Ann Turner, and through her, we represent Mackenzie Taylor Turner. Now, as Judge Wolf has already told you, the fault in this case has already been determined. The fault for the wreck that caused the death of Mackenzie Turner is with Bobby Sasser and Destiny Church of the Assemblies of God, Inc. But as Mr. Kennard mentioned in voir dire, in a civil lawsuit system, with a civil lawsuit, all that can be done is for the jury to give an award of monetary compensation. So it is going to be your job to put a dollar value on what has been lost in this case, the life of Mackenzie Taylor Turner. So to help you do that, I want to give you a little information about Mackenzie Turner. First of all, she was 14 years old when she died. She had just finished the 8th grade at Whitthorne Middle School in Columbia, Tennessee. And she was getting ready to start her freshman year in high school. And Mackenzie was an excellent student. She made A's in her classes. And in fact, she had done so well on the TCAT and other tests, including the ACT, that she had been designated for part of the gifted and talented program. She had been determined to be intellectually gifted. So she was in the gifted and talented program in the school system in Columbia, Tennessee. Mackenzie was also an artist. She drew, and she loved to draw and paint, and she was very good at it. She also loved to sing. She had a beautiful singing voice. She played the piano, and she had taught herself to play the guitar. Her interests were not limited to academic pursuits. She enjoyed doing things with her friends, and she played softball. She was on a softball team. And no one is going to tell you that she was going to earn a scholarship to play softball in college. She wasn't a gifted athlete, but it's probably more important that she participated, that she joined in something, worked at something that she wasn't naturally gifted at, and she got along with people, because those are very important qualities for ultimate success in the adult world. And Mackenzie Turner was Jean Ann Turner's only child. Miss Turner raised Mackenzie all by herself. Mackenzie's father was not in the picture, financially or otherwise. And to say that Mackenzie and her mother had a very close and loving relationship, it's true, and it's an understatement. They did things together. They traveled together. They watched movies together. They just talked about each other's day. They were friends, as well as being mother and daughter. Mackenzie Turner was her mother's whole world. And when Mackenzie died, Jean Ann was absolutely crushed. Ladies and gentlemen, at the end of the trial, we are going to ask you to take the law that Judge Wolf will give you and apply it and return a verdict that is fair and reasonable. Thank you, and thank you for your service as jurors.
Thank you, Judge. Thank you, Ms. Morris. Ladies and gentlemen, opening statement is the lawyer's opportunity to talk about what the proof evidence, we call it proof, will show today. So it's a brief outline of what today brings. Gives you an advance. It's not evidence itself. The evidence comes from the witnesses. But
Blinded by the light of the, we will take care of the aura surrounding Mr. Feeney will have to dissipate. So thank you for bringing that to our attention. That would be miserable to have to sit there through that. So we're just not used to bright sunny weather here in Tennessee right now. Is that taken care of it? All right, thank you. Anything else that interferes with your ability to pay attention, let us know and we'll fix it for you. Okay? Thank you. Thank you, Mr. Feeney.
thank you, thank you. So as I said earlier, I'm proud to represent Destiny Church. It's a small church in Columbia, Murray County, right downtown. And it was started by Pastor Morgan and his wife in 2007. And in 2011, Bobby Sasser was the youth minister. He was 24 years old. And they decided to have got invited to what's called a lock-in, where teenagers go to another church and spend the night and have fun, get up early the next morning, get in the van and drive back to Columbia. And that's when the accident happened. Everybody was asleep. Mr. Sasser fell asleep. The van went off the road, turned over, and Mackenzie was killed instantly. This is not a case of drunk driving, crossing the center lane, evading arrest. This is an automobile accident. To know that it was not, well, Pastor Morgan's son was actually sitting next to Mackenzie when the accident happened. This accident was devastating on the entire church community. And you'll hear this proof that the church has been there and reacted and responded and felt this just not like a mother, but just as a church would when one of its or a group of its members are in an accident. You'll hear the proof that Pastor Morgan presided over the funeral. She's been there throughout this, call it the recovery years, the reaction to a tragedy happening to a small community like that. And the years have gone by. Now we're 11 years later, and the case turns to a lawsuit for money. And so that's what today is about. Turner has now sued the church, seeking the monetary value of the life of her daughter, which is measured by a couple of things that you will answer the question to. You'll receive at the end of the day form, a verdict form. It look like this. We'll have two questions on it. The first question will be, what dollar value do you put on the mental and physical suffering actually endured by Ms. Turner between the injury and death? That's $1 value. In this case, ladies and gentlemen, the proof will show that there was no suffering between injury and death. This was an immediate death, immediately upon the van flipping. The second box or question is the pecuniary value of the life of Mackenzie Turner. How do you figure that out? Well, pecuniary is dollars, and under Tennessee law, it's a calculation that they will base on proof coming from a paid witness, an economist that they hired from Louisville, Kentucky, to come down and testify as to the wages that Mackenzie Turner would have earned had she graduated college, begun working at age 23, and worked, I believe their witness has it calculated out to how much annually all the way to age 89, asking, and then totaling it up and reducing it to present value and saying, we want the church to pay those dollars to Ms. Turner as though Mackenzie Turner was earning that money. That is the second line on the verdict form, pecuniary value. And they're asking the church to pay it, and that's why we're here. So to review briefly, the proof will show this was a church trip. There were no what we call aggravating circumstances. It was an accident. The pastor's son was sitting next to Mackenzie when it happened. The mother, of course, will testify, and it will be very sad, and everybody will be sad. The church feels the same pain as you can imagine. And you will hear perhaps friends and others testify as to what a nice young lady Mackenzie was. Certainly no dispute about that. And then you'll hear the economists testify about what the wages of Mackenzie would have been throughout her lifetime, and they will ask you to ask the church to pay Ms. Turner those. Thank you.
All right, Mr. Kennard, Ms. Marsh, you may call your first witness.
All right, before the first witness, I need maybe 2 more votes on the poll just to see. This sounds like it's a lot sadder than we anticipated. So there's the option of this trial, a DWI or DUI, and a custody trial. I'm told to stay here, not worried, but I don't want people to feel like they didn't sign up for something so sad. So just 1 or 2 more votes, and then I'll make a call. Okay, 1 more vote because we're on 9. But this is still the majority. I don't want to start the first witness if we're moving over, because then it's going to be... Okay, that's 10. Majority ruled this trial. So grab your tissues. Also, please let me know if I've made it too fast. I just bumped it up to 1.25.
The rule, if it's not already been.
The rule has been requested. What that means is that if there's anyone who is a witness, they must go outside of the courtroom and remain outside of the courtroom until they are called to testify. They are not to discuss the testimony of any other person with anyone until they themselves have been called to testify. Counsel, we're under continued duty to ensure that the rule is complied with. To come up here, please. You'll step up and raise your right hand.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Now, if you're going to come around here, we're going to have you sit in the seat. There's a microphone there that doesn't pick up very well unless you're very close to it. So if you would try to act like you're on American Idol or something and speak very clearly into that. Too. All right. Thank you, Ms. Williams.
Ms. Honecker, could you state your name for the jury, please?
My name is Summer Reed Honecker.
And where you live?
I live in Columbia, Tennessee.
Where you work? Where do you work, Ms. Honecker?
I work for Williamson County Schools with their before and after school program called SAC, and that stands for School Age Child Care. I work as a site leader at my own school, College Grove Elementary School.
And did you know Mackenzie Turner?
I did very well, actually.
How did you know Mackenzie?
So we weren't just teammates on the softball team or classmates in the classroom, but we were friends as well.
And how long had you known Mackenzie?
I had known her for about 4 years at that point.
Were you in the same grade in school?
I was. We were.
So, and what school was that?
Whitthorne Middle School.
And had you and Mackenzie just graduated from the 8th grade?
We did.
As a classmate of Mackenzie, did you know what kind of student she was?
She was a very all-around superior student. She was very talented in many ways. She had such a high intellect, but besides the high intellect, she was very funny. Jokes were always involved. She was a straight A student. I don't think she ever received a grade under 97 or 98 from what she would share with us. And she was very musical, artistic, and many other things.
Now, you mentioned teammate, I think. Did y'all play on a team together?
Yes, she was also an athlete. I left that out. She played softball with me, and we actually worked a lot hand in hand due to the fact that I was the pitcher and she was the catcher on the team.
Did you ever work the two of you, just the two of you together?
Oh yes, a lot on the sides where the outfielders and infielders would do their ground balls and pop flies. We would have to work on different pitching calls on the side.
How would you describe Mackenzie as a person?
She was very caring. She always let you know that she had your back. She would never fail to be a listening ear when you needed to talk to someone. So besides all of her many talents, she was just all around a great person and someone that a lot of peers looked up to and honestly wish to be someone like her.
As Mackenzie's friend and classmate, do you know what kind of relationship she had with her mother?
Her and her mom were very close, and I could see more than just a mother-daughter thing going on there. They had a good friendship because her mom knew too how much of a jokester she really was, and they kind of bonded just like that, where all the funny moments would mainly come out.
Now, do you know Miss Turner? True.
I do. We're actually coincidentally neighbors to this day.
Your neighbors, do you socialize?
So we're also social media friends. So she does see all my posts and keep up with me that way. And she has kept up with my growth after all these years and reacts to my posts that I post, whether it be like or love. And we just smile and wave sometimes across the way from one another.
Do you talk to Miss Turner on a regular basis or socialize with her in person?
No, not on a regular basis.
That's all I have.
Do you have a question?
No questions.
Thank you, ma'am. You may step down. You can have a seat in the audience if you like, or you may leave. You may call your next witness.
Our next witness will be Linda Jones.
You have someone that is retrieving your witnesses.
I think they got somebody getting their witness.
You may need the exercise and we'll let you step back. Step right up here, ma'am, please, and face my clerk and raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, whole truth, and nothing but the truth, so help you God. I do. Thank you.
And we have a four sound system. If you'll speak directly into that microphone, everybody should be able to do it.
Yes, sir. Ms. Jones, would you state your name for the record?
Linda L. Jones.
And what is your profession, Ms. Jones?
I'm a vocational economic analyst at Vocational Economics, Inc. I'm also a vocational counselor and vocational evaluator.
And Ms. Jones, do you have a, ask quickly, ask. Ms. Jones, can you identify what has just been handed to you?
Yes, that is my curriculum vitae, essentially a resume of my background in education, work experience.
And is this accurate and up to date?
This one looks like it was 2015, but I have a more current one from 2020 that I could provide instead.
Very good.
It's not a lot different, but there have been some changes.
Do you have a copy?
I think I can speak from memory.
Well, we'd like to make this an exhibit. And if we can, we'll just make the one that I handed to the witness exhibit 1 and this updated one exhibit 2.
Mark it as exhibit.
Here's the exhibit 1, 2015.
Okay, so that we're clear, this curriculum vitae that I've just been handed, is this the most current one or is it the updated February 2020? This is the most current.
Yeah.
This is the one you want to have maybe an exhibit.
Exhibit 2. We'll just make both.
Either one and exhibit 2.
Yes, just for clarity's sake.
Right. So exhibit 1 is the 2015 curriculum vitae and exhibit 2 is the 2020. Martin, you have to look at the back page to make sure which one's this. Thank you.
Now, there are a number of initials after your name on your curriculum vitae, or your CV. We call it a CV. Would you tell the jury, please, what they are, what they stand for?
I have a master's degree in rehabilitation counseling from the University of Kentucky that I completed in 2005. I have a master's degree in business administration from the University of Louisville that I completed in 2002. And then I have a master's degree in public administration where I studied labor management relations. And I completed that at the University of Louisville in 1999. I'm also what they call a certified rehabilitation counselor. That is through the Commission on Rehabilitation Counselor Certification. And I have been certified as an individual who can provide vocational counseling to people both with or without a disability. And I've maintained that every 5 years since 2005.
Does your job also involve making calculations about future lifetime earnings for someone who has either been injured or has been killed?
Yes, that's part of my job, and I work as a vocational expert with the Social Security Administration.
And as part of your profession, do you testify about lost future earnings in cases like this?
Yes.
And how long have you been providing this type of expert information?
I've worked for my company 24 years. I've been providing expert testimony, signing reports, and providing testimony since 2006.
Now, how many times since, I guess that would be 16 years, how many times have you been called upon to testify in court about the calculation of the loss of future earnings for someone who has died?
Multiple times, at least 5 to 10 times, for specifically a person who has died.
And how, during those 16 years, how many times have you performed calculations of the loss of future earning capacity for someone who has died?
Probably at least 200 times.
And of those 200, how many of those would have involved the death of a minor?
Fortunately, probably about only a quarter or a third.
In your profession as a vocational economic analyst, is there an accepted method for determining the loss of future earning ability for a deceased minor?
Yeah.
Now, did our firm, Ms. Turner's attorneys, did we ask you to calculate the present value of what Mackenzie Turner would likely have been able to earn over the course of her work lifetime?
Yes.
And did you perform that calculation?
Yes.
Yeah. You said earlier that there is in your profession an accepted method for doing this. Did you follow that methodology in making your calculation?
Yes.
And did you prepare a report setting out your conclusions and how they were reached?
Yes, I prepared one with my colleague, Dr. Anthony Gamboa.
We introduced that, Ms. Marshall, you offering this witness as an expert.
Yes.
Did you have any word hour about the expertise or qualifications? And this court will find that she is an expert in the field that she has testified to, which is, and so that the record is clear, Ms. Marshall, you'll state the level of, or the area of expertise so that we can have that in the record.
Your Honor, she is a vocational economic analyst, and she is offering testimony regarding the likely loss, the present value of the loss of future earning capacity of Mackenzie Turner.
Right. And she will be qualified as an expert. Ladies and gentlemen, in the conclusion of this case, you'll probably be given some instructions on how to weigh expert testimony and so forth. But this lady is considered to be an expert, and I'm qualifying her as an expert in this field. Thank you.
Yeah, I have a copy of.
You heard me refer to this, or is this for her to testify?
That is a copy for the exhibit.
You want it more like an exhibit?
Yes, please.
Okay, exhibit,
Yes.
You have your own copy of this one.
Thank you.
Now, before we just get into the bottom line of the report, would you just briefly explain to the jury what we mean by present value?
Present value is what you need today to provide a certain stream of income in the future. And when you're calculating present value in a manner like this, you have to think that I'm stating this in terms of 2016 dollars. You would have to expect that Mackenzie would have experienced growth in her earnings based on wage inflation. We hear about that all the time. I think the latest was 2.8% for 2021, the growth in wages. You also have to consider that should an award be given, a lump sum of money today, well, that could be invested somewhere and you would gain interest on that amount. In calculating present value, I'm assuming that any growth in earnings Mackenzie would have earned, experienced in the future would be balanced out or canceled out by any income or interest on any lump sum award to her heirs.
Now, and in making the calculations, did you include a calculation or an estimation of her work-life expectancy?
Yes.
And how long does your calculation expect that she would have worked? What age?
Well, we don't look at work life as continuous. We look at it as sporadic over a period of time. A female with a bachelor's degree at age 23, based on statistics from the U.S. Census Bureau, could be expected to work 33.6 years. So that's what I used at the bottom end. I also used bachelor's degree for a male at age 23 because many women have work patterns more like that of a male. They continue to work even during childbearing years. That would be 39.5 years at age 23, a male work life. And then a bachelor's plus, I looked at, should she complete something in addition to a bachelor's? I looked at bachelor's plus, those would be all people with a bachelor's degree or higher. A female with bachelor's degree plus is expected to work 33.2 years beginning at age 25. And a bachelor's plus, a male at age 25 would be expected to work 38.8 years. So I'm looking at anywhere from 33.6 to 39.5 years as a work life, depending on what her pattern would be, more like a male or female.
Starting at age 23.
Right, or 23 or 25 would be higher levels of education.
Now, obviously Mackenzie Turner had not attained a bachelor's degree. Is there a reason in your profession that you base the calculation on assuming that she would ultimately have done it?
Yes, I reviewed school records, and her scores on standardized achievement tests, her abilities indicated she was in the top 10 percentile, ranging from 85 to 95th percentile in most of her scores. So she was probably one of the top students, the brightest students. She was recommended for the Gifted and Talented program in 2009, when she was about 12 and a half years old. And those scores came from a school psychology report. She had an IQ of 123, which is about the 94th percentile. So she had more than the requisite ability to achieve a bachelor's degree or higher.
Ms. Jones, would you tell the jury, well, did you reach a conclusion about the value of Mackenzie Turner's loss of future lifetime earnings?
Yes.
What was that conclusion that you reached?
Well, on the low end, with a shorter work life and a bachelor's degree earnings, you're looking at $1,267,121. On the high end, when you're looking at a work life of a male with a bachelor's plus, that would and a bachelor's plus earning, people with bachelor's degree or higher, 1.7 million, 1,726,919. And then there's two estimates in between those two, if you'd like me to share those.
Are those numbers that you just gave the jury, the low end of 1.2 million and the high end of 1.7 million, have those been reduced to present value?
Yes, I calculated those. Assuming the growth in earnings would be similar to what you could invest in a safe investment of a lump sum award, as I talked about. There's also 62.5% taken off the total to achieve these numbers. Considering Mackenzie would have consumed some of these things, or she would have personal expenses associated with living and working in a lifetime. So that's already been taken off the top.
So are you saying that you've taken out, or that these numbers reflect that you have taken out what she would have required spend on herself in order to work?
Yes, that's already been taken out. Those numbers I've given you are the loss net of any personal expenses she would have expended over a lifetime.
And you referred to males, to male workers. Mackenzie was not a male. Why look at income from males?
Well, I didn't look at income from males. Actually, the income I used was a combination of males and females. We call it all person earnings, in recognition that women over time very slowly are gaining parity with men in earnings. And since I'm looking at several years into the future, I am looking at the all persons earnings for people with bachelors and the all persons earnings for people with a bachelor's plus, combined with those work life expectancies and combined with fringe benefits of 27%, which is those things that you don't get paid for on your paycheck but have value, like health insurance, retirement, what your employer puts in Social Security, those types of things.
Now, Ms. Jones, have you been paid for your time in preparing the calculations and in coming here today to testify?
Yes, or I will be billing for that.
And One other thing, a number of the information that you have talked about work-life expectancy and statistics, where does that information come from?
It comes from data from a large-scale survey of the Census Bureau. It's called the American Community Survey. It's a survey of about 3 million households or 3.5 million people per year. And I'm looking at a 5-year average on the work life or the employment rates and as of 2016. And then I'm looking at earnings from the year of 2015. I did my report at the end of 2015. So I guess the data would be from 2010 through 2014, actually, because there's kind of a lag on getting that data. But it comes from surveys conducted by the Census Bureau.
So that's government information?
Yes, and the fringe benefit rate comes from Bureau of Labor Statistics surveys. It's called Employer Cost for Employee Compensation. And they give us an idea every year in September what fringe benefits an employer paid in addition to earnings.
Thank you, Your Honor. Thank you, Ms. Morris. Ms. Jones, you are a paid witness to be here today, is that right?
Yes.
You live in Louisville, Kentucky?
Yes.
You, I take it, drove down last night?
Yes.
You drive back as soon as you leave here, I take it?
Yeah.
Your company is based, you're an employee of a company called Vocational Economics, correct?
That's correct.
That company is based in Miami?
Actually, it's based in Louisville. That's where our headquarters is, our main headquarters is. We actually have a branch office in Nashville that I use periodically out on West End.
And when I see the Miami address, what am I looking at? Florida address that you have?
Dr. Anthony Gamboa was originally retained to do this evaluation. I worked with him entirely on it. He has since retired. He was working out of Florida at that point in time, and he is full retired now.
The college degree that I see you have, your bachelor's degree was in journalism, is that right?
Journalism, public relations.
And you joined this company and you testified to your company having followed these methods to come up with what your prediction of McKinsey's income at age 23, 24, 25,
Correct.
all the way up to age 89.
Yes. And the probabilities of employment at 89, even beyond age 65, is extremely low.
You've calculated, and you've included that money in your total of $1.2 million, the money that she would have earned in April 2086.
That's correct.
And that's the money that you're asking the jury to award, is the income that McKinsey would have received.
Jackie, Your Honor, she's not asking the jury to award anything.
Sustain that. I don't believe that's a mischaracterization of her testimony. Sustain.
The calculation that you've come up with is based on income that McKinsey would have received through 2089.
Yes, if she had worked periodically or sporadically through her working life, if she worked continuously, it would have been more like in her 60s, late 60s.
Now you're of course hired by counsel. You're not hired by the court or the state of Tennessee to come in here and provide this information, are you?
No, plaintiff's counsel hired me. They typically have that burden of proving there is a law and defining that law.
And you've come up with this report, provided it to us. There's been no review of your conclusions by a university or some peer group before you publish them to your client.
No, and I've never really seen that done by any experts in my field.
Bottom line is you are hired by them. You come up with a report, you mail it to them, you get paid for the time you took to do the report, and you come testify, you get paid to come testify.
That's correct.
There's no outside university.
Entities involved, no.
And to get your $1.2 million conclusion, you came up with you had to start with some assumptions.
Right.
And one of the assumptions is that McKinsey would have attained a bachelor's degree.
Yes.
You did not include in your calculations an assumption that perhaps McKinsey would have stopped her education after high school and not got a bachelor's degree.
No, I didn't, because I thought it was most likely based on her ability and her achievement that she would go and complete a bachelor's degree.
Okay, so you took out all the potential of what her earnings would have been had she not gotten a bachelor's degree.
That's correct.
And you start as though she's graduated from college.
Yes.
And you start as though she graduated from college and got a really good job right after college.
Well, actually, you're looking at entry-level salary ranging from around $35,000. And then what we're looking at is the age earnings progression over time.
Right.
So you would start out relatively low and then increase.
$35,000 is not relatively low. Are you
Well,
saying that it's,
people are working at warehouses for $15 an hour now. That's not a lot of money when you're looking at that.
your assumptions that I see on your chart is that she would have worked, I take it, when you say 33.6 years, that's from age 23 to age 64.
23 to, that would be about age 66, actually. No, I'm sorry, 56, 57.
And you've got her earning within a few years, $70,000 a year.
Yes,
You've estimated that after the first few years of work, she would have gotten raises to put her at $70,000 a year. Is that correct?
yes, that's up around, after about 12 years working, 13 years working,
Well, age 33 would be 10 years working, correct?
10 years working. Okay, yes,
Age 43, you've got her earning $86,000 a year.
that's correct.
Age,
Because we're looking at the actual earnings of a group of individuals with a bachelor's degree at every age. The American Community Survey has a large enough sample that you're able to analyze it and provide that information by year.
and you agree that this, your calculation here that goes up to age 89, has her earning over $90,000 a year at age 53?
Yes,
Now, you didn't tie that to anything specific to Mackenzie Turner's vocational interest, did you, ma'am?
actually, her vocational interest, I read in the file, she's interested in being a nurse. And it's not uncommon to complete a bachelor's degree to be a nurse. In fact, that's becoming the most common route to that field. But she was only, she was very young when she died. She probably didn't have a real sense of what she was going to do occupationally.
Well, in your report, you call that you had a name for it, I've forgotten what it is. It's so,
They call it the fantasy
the
stage.
fantasy stage.
Sometimes when you're young, you think you want to be a fireman or a policeman.
or quarterback or.
Yeah. A garbage man, I don't know.
All right, but you didn't tie these numbers to a particular profession.
No, because education's a broad educational earnings average is better for an individual who's that young and we really don't know what she would have done.
And you don't know that you would have done college.
I don't know that for sure, but I think it's the most likely outcome, and that's what I have to testify to. What's most likely for her?
Well, everything here is in probabilities.
Correct.
You didn't provide us with the probability of her high school based income, did you?
No, I didn't, because she, based on her achievement and her abilities demonstrated, college is a very reasonable, bachelor's is a very reasonable estimate.
You did not include a percentage chance. Let me one more time, make sure. You did not include in your numbers the percentage chance that she would not obtain a college degree.
No.
You did not include in your calculations the chance that she perhaps wouldn't pursue a high paying occupation.
Well, actually, I'm looking at averages for bachelor's degrees. So the higher paying earnings would be above that. The lower paying jobs would be less than that. So I'm looking at the average.
So if she had gone to work for the Board of Education in Murray County, she never would have earned these dollars, which
I haven't examined their salary scale, so I'm not sure.
you haven't examined the salaries of young people that graduated and came out of Columbia, Murray County specifically.
No, I'm
For
looking
high
at
school.
bachelor's degree average on national.
National. You didn't calculate as though maybe she had chosen to go into the military.
No,
You didn't calculate as though she had gone into any government service.
no. Well, I'm looking at earnings across the board from a wide range of careers. So some of those could be government service.
If she was a talented artist, you didn't include the fact that very talented artists can not earn a lot of money, correct?
Or they can earn a whole lot of money, but that's not as guaranteed as a 9-to-5 type job in the future.
There are numerous jobs that people perform through their entire work life that don't earn this kind of money that you put in these numbers, correct?
Right. And I'm looking at the average. Some people earn more than that. Some earn less.
Right.
So I'm not considering she might have earned beyond the average.
You also told us, I think very quickly, I thought I heard you say 62.5% or 0.7%.
62.5%.
And so what you've decided is that if she earns $100, $62.50 is what's going to be spent getting there, and $37.50 is what's going to be left over at the end of the day.
Right.
And so if you take it, what you did, and say, okay, I take it over her whole work life. She's going to earn all these paychecks, and she's going to keep 37.5% of those dollars are going to be left over at the heavier side of.
Determined if she would marry him.
For a lunch break, you have a witness we can call for that period. Ladies and gentlemen, the next witnesses are apparently going to be more lengthy, so we're going to go ahead and break for lunch. Let's go ahead and return here and gather back here a little before 1.
All right. Back in session. We see.
All right, are we ready for the jury before we go to? All right, bring the jury in. Keep in mind, y'all can sit anywhere you want. So, play musical chairs if you'd like. All right. Maybe you need to come up here. I don't care what.
If I stop it, I can't turn it back on.
Plaintiff ready to call your next witness.
Probably call Gina and Turner.
Turner, will come forward, please.
You solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth to help you God. Thank you.
It really shouldn't matter whether you raise your right or your left hand, but that is the old English tradition that we've had handed down for centuries. So. Can I argue, man?
Tell the jury your name, please.
Jean Ann Turner.
And you were the mother of Mackenzie Turner, correct? And what was her date of birth?
April 1st, 1997.
When she passed away on July 28, 2011, she was 14.
Yes, sir.
And what's your date of birth?
April 7th, 1960.
Making you today 62 years old.
Yes, sir.
It's your birthday today.
Yes, sir.
And when Mackenzie died, were you 51?
Yes, sir.
Are you a registered nurse?
Yes, sir.
What type of work as a registered nurse did you do when you were working, or come to why you're not working at the minute?
I was an ICU nurse.
I'm sorry?
ICU, intensive care, critical care, yes, sir.
And what kind of degree did you have?
Only an associate's degree.
Okay. But you're not working now because you can't, is that right?
That's correct.
And you had a lot of surgeries?
Yes, sir.
Rods in your back, in your neck,
And my knee,
and your neck.
got a metal knee.
That was Mr. Bain. Gave his opening statement. Just listen to this. I know you don't know what I'm going to ask you, but when he gave his opening statement, he said something about pecuniary value, related it to wages. I want to talk about the other part of pecuniary value that no one has heard about yet, okay?
Okay.
Did you raise this child on your own?
Yes, sir.
Did you provide financial support for her?
Oh, yes, sir.
Father of Mackenzie, did he disappear, get out of the picture?
Yes, sir.
Where'd you go to school?
In Nashville, we resided in Nashville. And then when we moved back to Columbia, after I became disabled, Columbia, Tennessee.
Columbia.
Mhm.
Okay. And where'd you go to school down there?
Whitthorne.
And how far had she gotten in school in July of 2011?
She graduated 8th grade.
Down there in that school, would you take her to school in the morning?
Yes, sir.
Pick her up in the afternoon?
Yes, sir.
Tell the jury something about Mackenzie. What kind of talents did she have? What sort of person was she?
She was a very humble person to be as gifted and talented as she was. She would do anything. We gave her piano lessons and she played classical piano, but then she picked up the guitar, I guess, so she could read music and play the guitar. She didn't play the piano no more after the guitar. She was an excellent artist, which to my surprise, because I can't draw two things together, stick people.
Mr. Bernard, let me interrupt you. Someone just came in to make sure. I just want to both sides to make sure we don't have any witnesses who like we under the rule coming in.
No, sir, we're good. Thank you. Okay, so she surprised you with her artistic skills because you don't have it.
Right.
Okay. And was she a leader?
Yes, yes, she was, I think. You know, she very seldom ever got upset or angry, you know, and she's just had a very level head about her. Just an all around good person, you know, just sweet as she could be, though. Sweet as she is.
I have a photo of her. Ms. McKenzie?
Yes.
Okay, Your Honor, we have a copy of this. Instead of making this, Your Honor, Commission, I'd like to make a copy.
Objection, Mr. King.
Yes, sir.
All right, we'll make a copy of that photograph as an exhibit. That would be exhibit
Number 4.
4. You want that published to the jury?
Yes, sir. Thank you. And may I pass this photograph of the jury? Roughly. Okay. And
Number 5.
is that Mackenzie? This-
Yes, that's her still picture.
Now this one here, we're going to pass up to you.
Oh,
Okay. It's confusing when we're handing things around.
okay.
Bear with me.
Okay. Now in this photograph, where is Mackenzie?
She's either in Washington DC or Maryland. She was going on a trip that she was nominated for the National Junior Leadership grade.
Good. You told us the location.
Oh.
Now, where is she in the photo?
Oh, I'm sorry.
All right.
Oh,
That's
really?
English language.
That's her. She was tall like me, but that was everybody in her little group up there.
Okay.
I'm so sorry.
Oh. Yes, thank you.
Yeah.
Oh, gosh.
This is exhibit.
Number 6.
I'll pass up to you something now and ask you if Mackenzie wrote this document right here.
Yes, that's her handwriting. Yes.
Now, I would like to mark this as the next exhibit. Leadership letter.
Let me hand that back to the witness. Give that back to.
Okay. Okay, hang on to that.
You want to hand it to the jury?
Yes, sir, that'd be fine.
Oh, okay.
Did she attend a national junior leadership function?
That was that picture. Yes, sir.
Okay.
That was that picture.
Okay.
Yes.
And what about sports? Did you play in sports?
Yes, she, her later years, right before she died, she played softball, and earlier she played city basketball.
How was her health?
She was in excellent health.
She acted.
Oh, yes, very much.
And what sorts of things did you two do together as mother and daughter?
Well, if I did it, she pretty much did it, but she was in school or at practice, you know, which I didn't do a lot. The early years, I worked all the time, and then after I became disabled, we went everything. We traveled a lot together. In fact, right before she died, she'd gone to Florida for 2 weeks. We watched, The Twilight Saga was our favorite movie. I don't know if y'all remember that or not. You know, and she was always going to practice for something, you know, or school. She was very involved.
Were you friends with your daughter in addition to being a mother?
Oh, yes. It was just she and I. So, yeah. She was a mini-me. Except I'm not that smart. I'm sorry.
Were you close?
Yes, yes.
Let's go to Wednesday, July 27, 2011. Did you take her to church in Columbia?
Yes, I did.
And what were they going to do?
I went inside with her to speak with Mr. Sasser and to sign a permission slip, you know, giving her permission to go and asking questions, you know, like you do, when I should pick her back up and that sort of thing.
And did you go back home after that?
Yes, sir.
The next day, Thursday, July 28th, did you go back to the church
Yes, sir.
expecting to pick her up?
Yes, sir.
And what was going on there?
Well, I sat there and nobody was there except a TV camera crew. You know, they were taking pictures of the church. And I thought, well, what is going on here? You know? And I got out and I went up to that cameraman and I didn't say who I was or anything. I said, why are you taking pictures of the church? He said, there's been an accident. And I knew then that he was dead. I just knew. I don't know, asked me how. I don't have a ESP or any of that. And I hit the floor. I don't know what else to say. I didn't get to be with her. I didn't get to go. And me being a nurse, that was the worst thing that could have happened. It's been not me not trying to save her, but he tried to save her.
Are you on depression medicine?
Yes, sir.
You miss her every day.
Yes, sir.
Thank you. That's all I have. Very briefly. You were on depression medicine before the accident.
I was on a mild dose. I'm on 2 different antidepressants now.
And the career of Mackenzie was nothing you have ever expected would be paid to you, her income over the years.
No.
And you expected her to, I'm sure you'll tell us that you expected her to go to college and get a job after college, correct?
Well, that's correct, but that's what she wanted to do.
Right.
Yes,
And you also expected that she would get married and have a family.
if that's what she wanted to do.
She didn't say she didn't want to.
No, she didn't say she did either.
So you would be guessing,
Yes, yes, sir.
and you would be guessing at whatever career she chose to.
Oh, she had voiced that she wanted to be a nurse, but I do understand she was just 14.
She was an artist.
Yes, she was.
Could have pursued a career in the arts.
I can't predict that.
It can't be predicted, can it?
No, it can't.
Thank you.
Redirect.
Nothing further.
Thank you, ma'am. You must step down. Have a seat. Goodbye. Well, I'm going to call your next witness.
Thank you.
Step right up here, please, sir. Raise your right hand and face our clerk.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
And sit around here, speak directly into the microphone if you will, please.
Good afternoon, sir.
Good afternoon.
Could you tell the jury your name, please?
Good afternoon. My name is Ray.
What's your profession?
I am a United Methodist Christian.
I want to go to, thank you for coming, by the way. Where'd you come from?
Paducah, Kentucky.
Let's go to July 28, 2011. You remember that day? What were you doing that day, Reverend?
I was taking, I was the minister at Melissa's United Methodist Church in Jackson, Tennessee. And we were taking a trip on our bus to go see the Lynchburg, to eat at the Miss Bobo's, and then tour the Jack Daniels.
Okay, what happened?
I was, we all needed a potty break, and I don't know what time it was, but we were on our way. And getting off at exit 143 to use the restroom. And as I was getting off that exit, you know, it could have been a second or two, but as I was coming off, a church van had flipped over and had hit this big pole. And there was smoke and everything. I mean, it could have been seconds or a second between me pulling off and the accident happened. I got our bus, I pulled our bus over to the side, and my wife got the first aid kit from the bus, and we both ran out to the van. My mother, who was also on that trip, and the reason for the potty break, was a nurse, retired nurse, so she came along too. Went straight to the van, and trying to remember all my Boy Scout first aid skills, you know, get everyone away from, because I saw smoke, so I was trying to get everyone away from the van, and Catherine and my mom were checking them, and then I went in the van. You know, it was turned over, so I went in the van to check on to see who was still there. And then the first danger I arrived to was Mackenzie Turner. She looked in very bad shape, and so I reached out and grabbed her hand, and it's hard to explain it. You know, it wasn't, when she grabbed back, it wasn't like, you know, a touch, but you knew someone was gripping your hand. And I told her, said, it's okay. Help is here. I'll stay right here until, you know, someone gets here. And then maybe 5 seconds. The little grip was no more, and the life go out of that hand. I did check the pulse. I was trying to remember where the pulse was, and I couldn't find anything. The only thing I could remember at that moment was to think of a line from our non-Methodist funeral service that says, Father, on communion, Turner, in your spirit.
Thank you, Reverend.
Stevie?
This was a head injury case, correct? What you could see.
From what I could see, yeah,
You were
I took it to such I was just more concerned. I can remember there was someone asked me, was there all for face tore up and that sort of thing. I said no. But I would say, yeah, I look like a head injury. Yes, sir. Yes, sir. I'm sorry to say, yeah.
Thank you. That's all. Nothing further.
Thank you, sir. You may sit down, you may have a seat, or you may leave.
Okay. So no need to, maybe stop there.
You can sit down.
Okay, thank you.
And you may call your next witness.
I would like to read from the life expectancy tables.
All right.
This is the table 3 of the United States life table out of Tennessee Code annotated. Life expectancy of a 14-year-old female is an additional 55.79 years. Life expectancy of a 62-year-old woman is an additional 19.22 years. And I'll find out just a moment, please. Oh, that's all our proof, thank you.
Plaintiff is resting.
Yes,
Correct. Plaintiff is resting, Mr. Feeney. You have to offer any proof or anything you need to take up?
Something to pick up.
Ladies and gentlemen, if you'll step back here in the jury room and let me take something up and I'll come back.
Okay, since you can't see the link, I'm going to read the article. I will open a picture of her in another tab because the link has pictures of the accident and I don't want to put that on the screen just in case. So they say a church van returning from a youth outing overturned in a Tennessee highway accident, killing one teen girl and injuring 11 others. This was in 2011. The youths from the Destiny Church in Columbia were returning from a sleepover event at another church in Memphis Thursday morning. Sergeant Chad Smith of the Tennessee Highway Patrol said 12 people, 6 boys, 5 girls, and the driver were in the van when it crashed. The vehicle overturned on an off-ramp of Interstate 40 and was partially crushed by the impact. Children and teens typically stay up all night to participate in lock-in activities, and troopers say they are investigating the possibility that 24-year-old driver Bobby Joe Sasser fell asleep at the wheel. The trooper said the teen was not wearing a seatbelt in the wreck. It was Trooper Gildersleeve who went to the church at about noon to tell the girl's mother that her daughter had died. When she learned of the crash, the mother reportedly collapsed and had to be helped inside the church. Brad Kimms, a Destiny Church board member, told the Columbia Daily Herald newspaper that the children were a special group of kids. He said, "We just ask that you pray for us and pray for these parents who are dealing with this." A spokesperson for the Children's Hospital says 3 children taken there are now in a stable condition. The church suffered another loss just last month when a teen member and another youth were killed in a car crash in nearby Mount Pleasant. This is victim. I can't make it much bigger than that. It's a 2011 article. So basically, the crash took the life of the child. The child's mother is suing the church for damages in a civil suit. There is a jury, and the jury will decide how much is awarded. That's basically what we're watching.
Unreliable and should be excluded from jury consideration. I will move generally as to observe the objection, the case going to the jury. And then when it comes to my proof, as long as I'm here and the jury's out, when it comes to my proof, I do have an offer of proof as to the Chrysler lawsuit, the Chrysler experts that had testified, and that had provided reports, the opinions, the district court complaint that was filed. Each of those items in this court are already in the court file record. And as offers of proof go, I believe it's sufficient for me to refer to those just by reference instead of actually retendering them as exhibits and marking them. If you'd like, I can tender those. I've got another copy of them, or however you prefer.
Doesn't matter to me. I don't know if either of you ever practiced in front of my predecessor, Judge Robert Birch, of when a lawyer, he made a ruling on a matter, and the lawyer said, I'm not going to say I never did this, and it was sometimes me, sometimes it wasn't. But if he said, well, I'd like to make an offer of proof, he said, fine. He'd stand up and walk off the bench. He said, let me know when you're finished making your offer of proof. And his logic for that was simply because of the fact that if he had ruled it wasn't admissible, then he was going to sit and listen to it, and have it somehow subconsciously affect his decision, I think. He had a lot of good qualities, and that one was one, I guess, we learned. I recall the information that you're referring to, Ms. Sweeney, and my ruling from January of last year on all of those issues, I think was pretty much resolved that. But what I would suggest is that we just need to know on the record that all of that information, and if you want to submit as a part of an offer of proof in a subsequent to this, so that it's preserved in the record, individual copies of everything you're asking for, but it has to do with the Chrysler lawsuit. And my ruling in January said that would not be admissible. And but I would nonetheless let you introduce those as a late filed exhibit for offer of proof, if that would be sufficient.
I think that should be fine for what's required. And thank you.
And as to your ruling, let's see if the plaintiff wants to respond to as to your motion, rather. So.
One more point, obviously, I wasn't sure if the court reporter was here when we made sure punitive damages was out of the case.
Punitive damages was, I don't know if you were in here at the time. I think you were. You've been here from the very beginning. So we have established that punitive damages were not an issue in this case, so that was not going to be a problem. Mr. Kennard, you wish to respond to his motion?
Thank you, Your Honor. On the conscious pain and suffering, we all know a dead person cannot squeeze a hand. It may have been a head. What this young man said, but even with a head injury, still think she ripped his hand. I'm sure it was. So that's up to the jury. In the economic situation, that's a solid testimony. Qualified expert, he did offer expert testimony himself. That was very solid economic proof. So that motion should be denied as well.
As to the motion regarding the present pain and suffering, the testimony of this last witness could present and does present a question from the jury in this court's opinion as to whether or not this young lady was conscious and aware and suffering pain at the time. There may have been a head injury, may not have. It was not really clear that came out, but it was a situation where that witness testified that in his interaction with the young lady that she did somehow respond to his gripping her hand, and which indicates to an extent that she may have been aware. Under those circumstances, I think that presents a question for the jury to determine how much, if any, pain was suffered by the young lady and what the pecuniary value is of that. As to the economic testimony regarding the economic value, present value of the life of this young lady, is this court's opinion that, again, the testimony before has been very efficiently cross-examined by Mr. Feeney, but that becomes, again, a question for the jury, and the instructions of the final charge that I will give them gives them that very information about an expert witness is to be considered like any other witness, and we'll give them the statutory or the Tennessee pattern instructions on the expert witness. That will give them the ability to weigh and judge how much weight to be given to that particular witness. So, in respect to both of your motions in that regard, Mr. Feeney, I will deny the motion. Are there any other questions or any other issues before we begin? Do you intend to call any witnesses?
I do not, Your Honor.
So we're going to, at this point, have concluded the proof for the case, and the next step will be to charge to do it. We have drafted an initial charge. I'm not sure if Mr. King, you give them a copy of the two things. One of them is the county mayor was wanting to, we'll take care of that, and then I'll talk to the other and publicize that. Final charge, let me go ahead. In our final charge we have right now, there was no testimony presented by a deposition. That was one of the things. We had included that in the event there was some testimony about that. There were no stipulations, if I recall correctly, that were entered into by the parties. Is that correct? So we're going to omit the instructions regarding stipulations. And there is testimony by expert witnesses, which will include that. What I'm going to ask Mr. Kennedy to do is to go ahead and run a copy of this with those two changes, let you have it, and let you want to run it as is, since I told him what I'm taking out. I need a few more moments to review it to make sure, but I'd like for you both to have, or all three of you to have a copy of this final charge before you do your closing argument. So with your permission, without objection, I'm going to bring the jury back and explain to them where we are, let you rest your proof as well, and then tell them I'm going to take a short recess while I prepare the final paperwork. Anything other than that? All right, let's bring the jury back.
I only heard the plaintiff rest.
Not that. We find out who it was. Have a medical report. Really can't. We'll let you get real comfortable, and then we'll tell you that you're going to go right back out there. What we, in just a moment, I took something up, and the plaintiff was rested their proof, so let me find some of the defendants. You have any proof in your office?
We'll rest our proof as well here.
Right, and what that means is that the proof is now being concluded. The next stage of the process is for me to finalize the last charge instructions that I'm going to give you to help you decide this case. And it's a document that we've been working on, but I need to make a few changes to it.
So guess what? Because all of us hate jury instructions, we can skip. Wait, why does another person pop up? Oh, it's the lady. Okay, now they're back. No. Okay. No. Any sound gonna come through, Judge? No? Gone again?
You have received. That reference.
All right, thank you, ladies and gentlemen. We have got everything squared away, got our budget problems spread for. We are ready to commence now with the closing arguments of the attorney. So I believe the plaintiff is always ready to go first. So Mr. Kennard, you and Ms. Morris are ready to go. Thank you.
Thank you for your patience. We put on a pretty fast trial, and you had to wait, but now you're going to get the case in just a little bit. We could go to a 500-year-old healthy person, 500-year-old healthy person, a good man, say to that person with all that life experience, what is the answer in this case? We don't have a 500-year-old person. However, we tried to average up your ages, and we estimate the combined ages averages up totals about 500 years. So you are the 500-year-old person. All the experience you have together, your life experience, things to discuss, and that's why you determine the facts. Lawyers don't, and his honor doesn't. It's up to you. I remember Mr. Beatty saying in opening statement that Mackenzie died instantly. That's not true. You now know from evidence she did not die instantly. She squeezed that reverend's hand. Here's a blow up of the verdict form you're going to get. First item, penalty and physical suffering actually endures by Mackenzie or injury and death. I want you to do me a favor. Put 0, please, on the phone. Because I don't want Ms. Turner thinking her daughter suffering. Okay? And it's kind of speculative anyway. Did she? Didn't she? But I would request a 0. As a message to her, she can live the rest of her life thinking she did not suffer. Those 500-year-old folks don't worry about that. Now, the pecuniary value of a life. This is a different matter. I don't know if Mr. Finney was excited. Get hold of what? When he said to you an open statement, pecuniary value means lost wages. The good news for you is that the judge is the judge of the law. And he will tell you what the law is and what pecuniary value means. It does not mean what was said in open statement. Not mean that. The judge will give you a detailed instruction on it. And this is the most important part. The guidance the judge is going to give you on the law. Pecuniary value here is right here. Number 1, the age of the deceased, only 14. For health, excellent. Life expectancy, for how long the average person. Strength and capacity for work and for earning money. She hadn't achieved a big job yet, but she had strength and capacity. Perhaps she was a remarkable. Also had to do it at the point. Here's a really big one. This is the thing you didn't tell you about. The reasonable value of the loss of consortium suffered by the mother of the deceased in the income. What was that loss of consortium? Now, I will tell you, we'll have the jury instruction herself. Consortium, affection and love, attention, education, guidance, care, protection, training, companionship, cooperation, that the mother would reasonably be certain to have received during the life of her daughter. All these things, it's a huge loss. The love between a mother and her daughter. This is especially close. She raised that child, her only child. She gave this child, and they gave each other attention, care, and protection, companionship. It's a big loss. You all know it's a big loss. And now it's time for restitution. The Bible talks about restitution. Micah 6:8. Do justice. If he was not an art object, human being, I ask you to put $9.5 million plus or minus the judgment up to you. And I suggest that that's the number that's supported by the evidence. With her loss, she suffered. Okay, Judge, thank you, Mr. Carter. Sometimes, ladies and gentlemen, trials last for many days, and this closing argument is a chance for the lawyer to remind you back what happened 6 days ago when that witness testified, and you said, "Oh, remember that guy? He was the fellow with the beard. He told you about this." Lawyers run through all the witnesses for the last several days. Well, obviously, a short trial, not a whole lot of forgetting going on between this morning when the schoolmate testified, as expected, good friend, social friend, junior high school friend, who now works at the Board of Education. I think she said she was running the after-school program at a school there in Murray County. The next witness was the hired witness, the economic damages expert, testified of pecuniary value. And she testified, you'll remember, that she's paid for her report, hired by the lawyers from Louisville to come down and testify favorably. Obviously, for the plaintiffs, they wouldn't hire her to do that if she wasn't going to testify favorably to them. And she made assumptions throughout her testimony and her opinions that the judge will instruct you when he tells you, gives you your jury instructions. He'll read to you and you'll get a copy of them. That you don't have to accept everything she said. The witness, you don't have to accept that. And disregard it is what I think the instruction said. But no, when considering her testimony, that she assumed that she's paid for her report, that she assumes the high paying job, she assumes a college degree, she assumed the 40-hour work week for life. She assumed McKinsey would work until 66, age 66. She assumed, and she included in her calculation wages until age 89. Do you remember hearing that? 89. Okay, McKinsey's going to earn money until she's 89. Let's calculate all that. And then she also assumed a 37.5% portion of the income would be not spent. That's the leftover money at the end of the week that she used to add up all those years of work, all those years of saving 37.5% to get to the $1.2 million figure. The proof, or the proof, the common sense that a jury is expected to apply in a case would show that 37.5% is an unrealistic figure. That the witness assumed the most optimistic numbers she could assume. And when it comes to the deliberations that you go into, you'll go in with these instructions in mind. You'll see in these instructions, and you'll hear from the judge in a few minutes, that you are to consider both the most optimistic, what you heard from the witness, and the most pessimistic. As though McKinsey didn't go to college, didn't get a job, didn't earn money, didn't live a long time, became disabled. Who knows? You consider everything, most optimistic and most pessimistic. The judge will tell you, and this is a very difficult thing for juries to do, that sympathy, one of the very first paragraphs in the jury charge is that although everybody in the room is hugely sympathetic for what's happened here, that sympathy is actually not a part of your considerations. The judge will instruct you that sympathy is not a part of it. It's hard to do to rule out sympathy, but that's the case. The judge will say no sympathy solely on the evidence presented today from the witness stand. The judge will tell you specifically, ladies and gentlemen, you are not required to accept the opinion of an expert. Don't go back in the jury room and think, oh, well, we have to accept what she told us. No, you do not have to accept that. Mr. Kennard has already put a 0 in the first position on the verdict form because that is what the evidence was. That's what lawyers, judges call conscious pain and suffering. And it's a good thing that McKinsey did not have conscious pain and suffering. And that's why there's a 0 in that spot. The second part, the judge will instruct you, is the pecuniary value of the life. And that's where you get to what I just told you, is where the judge will say, consider not only the most optimistic expectations of the future, but also the most pessimistic and all uncertainties in between. Because we don't. They'll also instruct you to deduct the future living expenses from the witness deducted 62.5% and left with 37.5% not living expenses, what I call savings. You're to deduct that from your number. In reality, the world that we live in and the common sense of this 500-year-old group of minds is that people are lucky or particularly careful if they're able to even save 10% of their income every week, put 10% aside. And it's we're asking you to believe that 37.5% is the number to rely on. Ladies and gentlemen, the judge will instruct you that you should come up with those numbers on your own. He will instruct you that you are to use, and it will be his words, calm and reasonable deliberations. Meaning, don't be inflamed by the tragedy that we're dealing with today. The jury is instructed to calm and reasonable thoughts in your deliberation. And most importantly, that everybody deliberate. You want a jury of 12 to decide this case, not one particular strong personality that comes in. This is what it's got to be. Everybody jump in. This is your time. This is your day to do that. And everybody here asks you to do that because we want the community. We want Humphreys County to decide this, and you are the representatives. May not work for the government, or you may, but this is, other than probably active military service, this may be your biggest role with the government, or a person's biggest role with the government, sitting on jury duty. Very important that you follow these instructions. Everybody's counting on you to do that. Ladies and gentlemen, your verdict needs to be unanimous. Everybody has to agree. You can't agree to just everybody throw out a number, divide it up, and just use that number. You have to come to the verdict that's true, but everybody has to agree to it. And even if you're, well, I should just say it should be unanimous. Make sure it's your own verdict, not something that you don't agree with. This is all part of the judge's instructions to you. Now, Mr. Kennard has come up with a number here. I don't even want to say it. He wants Mr. Sasser and the church to pay his client $9.5 million. Out of nowhere. This is huge. Impossible number. I think I would simply ask you to listen to the proof, what you heard today, and most importantly, the jury instructions about calm and reasonable deliberations. What you see here and what you return under Tennessee law will be the appropriate verdict. I need to sit down, and I'm not allowed to say anything more, which is a good thing. Lawyers that keep their mouth shut. Mr. Kennard gets to get up and talk, and I'm not allowed to respond to that. So I don't know what he'll say, but I do know that this is a very delicate case for me because I don't want to make you angry at my client by asking harsh questions of a parent or doing that sort of thing. So if I have offended any of you or turned you against my client by the way I behaved with the witnesses, that's on me. Please don't take it out on my client. I say client singular. I've got two clients, Mr. Sasser and the church. I noticed that each of you were very focused today. In my chair as a defense attorney, I sometimes get to see the jury a little bit more than other people. Quite often there are sleeping jurors that the judge will see and wake them up a little bit. But didn't have that problem today. Everybody stayed focused the whole time. I will thank you for that attention. I will apologize if I've offended anyone. I'll ask you for calm and reasonable deliberation that would be appropriate for a case of this nature. Once again, I ask you to base your testimony on the evidence, not on the pleas and the sympathy. Okay. Thank you.
Basically.
I didn't want you to focus on the evidence and the law. Again, Mr. Feeney discussed pecuniary value, but he left out number 6, the love and affection between a mother and a daughter, that relationship, that loss. Again, he didn't mention it. You know why he didn't? That's a number That's just that law. And he doesn't even want you to think about it, because he's never said it. Ever.
Any of the witnesses with your fellow jurors. Sasser. And maybe that's it. Wow. How do
If you escape.
well, I'm in mute. So.
I felt like we needed a little bit of dopamine to just make it easier.
Sorry about that. I've been handed a paper that the jurors have two questions. First question is one person or entity being sued, or are there two persons being sued? And two is, when was the original case filed? My intention is to bring the jurors back in and to remind them that in the instructions, both the initial charge and the final charge, I identified for them the fact that the plaintiff was Miss Turner, and that the defendants were the Destiny Church of the Assemblies of God and Bobby Sasser. And I even gave them an explanation as to the liability aspect of that, and that those were the two defendants that were being sued. So the second question, I'm going to bring them in and tell them it is irrelevant. When it was filed, what is relevant is that it was timely filed under our laws. Anybody have any question about how I intend to handle that?
Yes, sir.
All right.
My clients are not.
You want to round them up? We'll wait on them. That's fine. They have every right to be here, so.
Do you want me to print off another copy of the,
It appears we have time to cut one off, so yeah.
so that's the initial and the final?
Just the initial, just the final is fine. Hey, I've got the Mr. Doc, or rather, yeah, I threw it away, so I have a copy on each front. All right, let's bring the jury up.
You see it?
Ladies and gentlemen, I've been handed a piece of paper that indicates that there are two questions that have been asked, and I want to address those, and I've gone over this on the record with the lawyers to the parties. First question is one person or entity being sued, or are there two persons being sued? And what I would refer you to is my explanation in the initial charge, which begins on the bottom of page 1 and continues to page 10, in which I instructed you as follows. In this case, suit has been brought for damages alleging the death of Mackenzie Taylor Turner was caused by the fault of the defendants. The court has found as a matter of law that the death of Mackenzie Taylor was caused by the negligence of Bobby Sasser and was the sole cause of the single vehicle wreck that caused the death of Mackenzie Turner. The court also found as a matter of law that Bobby Sasser was acting within the course and scope of his employment with Destiny Church when he negligently caused the wreck. As Bobby Sasser's employer, Destiny Church is responsible for Bobby Sasser's negligence in causing the single vehicle wreck. I repeated that same instruction in the final charge on page 5 with almost identical language. So in answer to that question, there are two defendants that are being sued, but this court has found them both to be liable in a prior hearing on legal issues that you shouldn't concern yourself with, but those are the defendants. And I have found them both to be liable in a prior hearing. The second question that you have is, when was the original case filed? And that I have determined and advised the lawyers it's not something that I find to be relevant to your inquiry.
We just go straight to the verdict. I'm not doing verdict music for this one because it feels a bit off. We're going to need a little bit of Judge Flesh after this to just not go to bed on such a thing.
All right, and Ms. Green is the foreman or forelady, is that correct? All right, I'm going to hand you back your verdict form, and then I'm going to go over it with you, if you will. All right, the verdict form that I've been handed says, we, the jury, unanimously answer the question submitted by the court regarding the amount of damages in the following categories, if any, proven by the preponderance of the evidence. Class 1, mental and physical suffering actually endured by Mackenzie Turner between her death and injury, and you have indicated that that would be $0, correct?
Yes.
Second is Class 2, the pecuniary value of the life of Mackenzie Turner, and you have indicated that the jury has unanimously found that to be $400,000. Is that correct? Is that the unanimous verdict of all 12 of you? If you will raise your hand and signify that you are in agreement with that verdict.
How much?
All right, thank you. Let the record reflect that all 12 have submitted that they are in agreement with this verdict. Ladies and gentlemen, we appreciate your service. I wish I could tell you that this will conclude your service for the entire month of April, but we have trials set for the rest of the month as well.
400,000. How much did they ask for? Probably should have listened to that better. Listen properly. I think that was fair. I think it's a fair verdict. You want to watch an empty chair? Can't get any cats. They asked for 9 million. They got 400,000.
I will affirm that verdict and we'll go from there. And we are now adjourned.
All right.
So we will need you to check your recording and by the court regarding the amount of damages in the following categories, if any, proven by the preponderance of the evidence. Class 1, mental and physical suffering actually endured by Mackenzie Turner between her death and injury, and you have indicated that that would be $0, correct?
Yes.
Second is Class 2, the pecuniary value of the life of
Whoa, 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 whoa. Listen to this again. So hard to go back on these long streams. The suffering. Listen to the suffering one.
All right, and Ms. Green is the foreman or forelady, is that correct? All right, I'm going to hand you back your verdict form, and then I'm going to go over it with you, if you will. All right, the verdict form that I've been handed says, we, the jury, unanimously answer the question submitted by the court regarding the amount of damages in the following categories, if any, proven by the preponderance of the evidence. Class 1, mental and physical suffering actually endured by Mackenzie Turner between her death and injury, and you have indicated that that would be $0, correct?
Yes.
Second is Class 2, the pecuniary value of the life of Mackenzie Turner, and you have indicated that the jury has unanimously found that to be $400,000. Is that correct? Is that the unanimous verdict of all 12 of you? If you will raise your hand and signify that you are in agreement with that verdict. All right, thank you. Let the record reflect that all 12 have submitted that they are in agreement with this verdict. Ladies and gentlemen, we appreciate your service. I wish I could.
Interesting. Very, very, very interesting. Well, that was a quick one, and it wasn't as bad as I thought. Looks like Recovery Addicts got a panel going. I'm going to put on Fleischer for a bit though, because I think we need a little bit of chill. Just a little bit of like, where is it? Why does he keep disappearing on the things? Okay, we finished one of them, but we didn't finish the second one. It thinks we did. Now we have to remember where we were.
You and my sister.
Y que tenía que. He takes a test today and gets a scram today's work. Is that it? I think we're done, right? I don't see any.
Oh,
dang.
Hey, what's that?
I will find there is probable cause. And John, yeah. Here.
2 out of 3 ain't bad.
Here, you want a
Oh
lollipop?
my
too?
gosh.
Hey, wait, John, you want a lollipop?
No, man. I'm gonna give
Come on. You guys want a lollipop? Anyone? Want some candy?
I'm not sure if I want to be going
I caught 2 out of 3. Oh, he wants, she wants.
Here.
Miss Tracy.
Or here, you pass these out too.
I appreciate it.
I think people like them.
Yeah.
Same, Tria.
Yeah, for sure.
I have to skip the packet noises. It's like my biggest thing with sensory processing, like the packet noise, it makes me rage. Just trying to see if anybody else comes in, because otherwise, are we also done for the day? It's still like 45 minutes till bedtime, and we need a little bit of a pick-me-up. Nobody? Nobody?
Put 2 right here.
I'll find an older one.
Ah.
I know.
Judge. Is that a 7?
We're not gonna meet the it doesn't mean guilty. So, you're guilty or not, that's something you get all the evidence, video, lab reports back, we get all the evidence, and we'll go over that together. Okay. But today the judge just wants to give a big.
2. It's supposed to be a 2. Sorry. I know. It kind of looks like 7. It's a 2 though because it's the second.
2.
Yeah. We got to go. People keep coming. Edna.
Yes, Your Honor, I'm sorry. I know it's been a very long day for you.
Okay.
I was in court this morning with this young kid named Gael Gutierrez.
Yes.
And he was the one with the AR-15 semi-automatic, weapon. I didn't know he had sent me a text saying that I was fired because I was late. That's what he said. And I filed a motion to withdraw, Your Honor. And
okay. I'm not going to do that now. Tell him to come back on Monday and we can discuss it on Monday. But I'm not going to just grant a withdrawal. But you know what? Tell him to come back Monday and then we can talk about it on Monday.
Your Honor, I will not be in until sometime next week. Can I just have him come in on a day that I'm going to be there? Or do you need me to be there when you speak?
I'd like you to be there as well so I can talk to him about it,
I'll I'll see if Thursday is okay. I told Victoria immediately that he had decided he no longer needed my services.
Okay, well, yeah, it's whatever. I mean, I'm happy to take you off, but I want him here first, right?
Oh, yeah, I
So-
totally understand. So I'll ask him if he can come in.
Tell Victoria we did whatever day you want next week, and I'm happy to do it. And he's got to be here. So set it for Vaughn forfeiture, right?
Thank you. I'll communicate with Victoria via email. Thank you.
Wait, you want Thursday or no?
Yes, Thursday will be good.
Okay,
August 1st?
that's August 1st?
Oh,
What?
uh,
No,
July 25th?
I thought she said she couldn't. 25th is fine.
you want the 25th?
That's the day I will be in. I won't be in on Monday, but I will be in on Thursday.
Sure, whatever day. I'm cool with that.
Thank you so much, Your Honor. Thank
Please
you.
let him know he's got to be here, okay?
Thank you.
Thanks.
We'll talk about the DWI move.
Okay. I have an older one. I'm not going to join the panel because I don't really have much personality left for the day. And I need to be getting ready for bed and whatever. And I don't know about the documents. So I need to be careful what you guys see on the right-hand side because there was a verdict in the witchcraft trial. Also, I think tomorrow, should we start at about the same time? Maybe a little bit, no. Should we start about the same time as today? I can't remember if we've watched this one. So if we have, just ping me. Because I obviously was in some of his as the mod, and I was in some of his as a general person. So I've forgotten like what I've watched on stream and not.
Okay, what is your name, sir?
Bruno?
Mr. Bruno, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 5th, 2024, officers conducted a traffic stop on a motor vehicle for failure to signal lane changes 2 times and an expired registration from February 2019. The defendant was a driver and sole occupant and was ID'd by his Texas identification card. Officers observed the smell of marijuana, and a probable cause search turned up 2.6 grams of marijuana in the front passenger seat and 6.4 grams and 6.5 grams in 2 separate bags in his hand Louis Vuitton fanny pack.
Mr. Bruno, I'm going to find that there's probable cause. Do you have a valid Texas driver license?
Suspended at the time.
Okay, you're not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. I don't care what you have to do, where you got to go. If you don't have a license and insurance, do not drive. Otherwise, you'll be facing 6 months in jail every time you drive. If you want to drive, go get a license, liability insurance, and then we can talk. But until that point, you drive. You're mine. You understand? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria. I'm not putting any conditions on you, Mr. Bruno. The only thing I'm asking you to do is don't drive and don't get in trouble. If you pick up a new case, or I really, really hope you don't drive, because if you do, I'm really going to lose it. So don't drive. I hope you heed this warning. Do you understand? A lot of people don't think it's a big deal, but I do. And I put a lot of people in jail because of it. So heed this warning. You won't get another one. I have you come up here, swear to us you're not going to drive. I'll get you to Victoria and we'll get you out of here. Can you come back to have a lawyer?
Page 4, Shannon.
Brent, do you have an arraignment? Victoria, Brent has an arraignment. Brent. Oh, Spanish speaker? Okay, come on.
Page 7.
And next time, just come up so you don't have to wait. Come on. What's the last name?
Gardunio, G-A-R-D-U-N-O.
Page 7.
All right, yes. Good morning, sir. Sir, you're charged of driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 5th, 2024, Metro Police responded to a traffic collision between a bus and a car. The officer met with the bus driver who said she was out of service driving on I-45 when she heard the screeching of tires and felt as if something hit the bus and noticed a vehicle spinning out of control. Officers went to search for the car on I-45 with no results. However, HPD was talking with 3 drivers on Houston Avenue involved in the traffic collision. HPD advised that they detained the defendant and that he was the driver of the car that struck the bus. Wheel witness said he observed the defendant pass him at a high rate of speed, switch lanes to go around the bus, and lose control. The wheel witness swerved out of the way, causing another accident. The defendant was observed to have a strong odor of alcohol on the breath, red bloodshot eyes, and slurred speech. Standard field sobriety test was conducted. HGN was a 6 of 6, walk and turn was a 5 of 8, and one leg stand was a 3 of 4. The IC was red and breath was a 0.168 and a 0.170.
Okay. Any prior DWIs?
No, Your Honor.
Okay. Mr. Gardunio, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
Are you sure?
Yes, sir.
I asked him that earlier, Judge.
Because there's a lot of accidents that happen here. They're going to come after who? Right. So I hope you did have insurance. Now, I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or drugs, you will go to one place. Do you understand?
Yes, sir.
Where would you go?
Yeah.
Right. Don't drink. Don't use any illegal substances. You understand?
Yes.
You must also stay in touch with Mr. Washington. He will tell you if and when you have to come back to court. If he tells me that you're playing games, that you're not responding or phone calls or text messages, I will issue a warrant for your arrest. You understand what's expected of you? Yes. Don't pick up any new cases. And if your license gets suspended, do not drive. I'll have you go to Victoria, sign a reset. After that, you'll get trace bond conditions, and then you're free to go, sir. All right.
Thank you, Judge. Appreciate it.
Good morning, young members. I'm here on Mr. Padilla Pearl, Your Honor. I have your clerk print out an informative notice.
Let me just finish with the arraignments real quick.
Okay, oh, I'm sorry. I thought you were done, Your Honor. I stepped out for a second. My mistake. May I excuse Judge? Everybody in the middle.
We still have a good amount.
Yeah, that's fine.
Today, so.
No, that's okay, Judge. Thank you.
Cameron is our next one.
Page
Okay.
4, Cannon, come on up.
Scored again, Miss Cannon. What do you think is going to happen? Right. This time, you will have a very hefty and large bond amount that you will be required to foot because you will not get any more PR bonds. Do you understand, ma'am? Okay. What are you doing about a lawyer? What are you doing about a lawyer, ma'am? What are you doing about a lawyer? What do you do for a living?
I'm a security.
Okay, how much money do you make a month? You have to qualify for an appointed lawyer. We don't just give them out like it's candy, right? You have to qualify. You told us something differently on a different affidavit, man.
No,
Okay, man, just go ahead and take a seat for me in the jury box. You talk to the man.
judge is page 5, Davis, come on up.
Good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Policemen of the defendant were on their way back when the defendant began recklessly driving, causing the complaining witness to fear for his safety. This led to the complaining witness and the defendant having a verbal argument, which escalated as they got home. The complaining witness told the defendant to pack his things and leave, then locked himself in the bathroom to keep them separate. The defendant kicked down the bathroom door and began striking him all across his upper torso, face, and head with both open and closed fists, yelling how the complaining witness shouldn't have told him to leave the house. The complaining witness stated the defendant's assault was putting him in fear of his safety and causing him pain, so he pushed past him and ran out of the unit. The defendant followed the complaining witness and continued to strike him across the back before biting him across the middle section of his back, causing pain. The complaining witness then ran away and called the police. The complaining witness arrived shortly after to find the defendant was gone and walked into the unit, locking the front door. The defendant kicked down the front door after a few minutes, to which police arrived, and the complaining witness had 2 knocks on the right side of his head that were actively bleeding and a fresh bite mark that did not break skin, along with defensive wounds across both hands.
Mr. Davis, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. You understand? I'm also ordering you not to be in possession of weapons. There's a protective order that's been issued in this case. I suggest you get to know it, because if you do something to violate the protective order, the state can and will file a violation of a protective order against you. It's one of the worst cases you can pick up. If you violate those conditions, I can hold you at no bond. 0 bond until this case is over with, and I will do it in a heartbeat to protect every person in Harris County. Do you understand? So this MOA has a portion that's struck out for the no contact. I'd like to put it back in though. Should we issue a new MOA? Okay, I'd like to do that, please. All right, Mr. Davis, we're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign and reset. After that, I will have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. No contact. Do you understand? Okay.
Your Honor, with regards to bond conditions, I just filed no contact.
Please, and no weapons. Yeah. Okay, come on.
All right, Judge, page 8, Gonzalez OWI, come on up.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 5th, 2024, officers were dispatched to a medical emergency involving an intoxicated driver at Barker, Cypress, and Clay Road. Upon arrival, officers observed a vehicle stationary at the light and remained stationary while the light cycled. Officers walked up to the driver's side and made contact with the driver and sole occupant, who was unconscious. The vehicle was running and his foot was on the brake. Officers then woke the defendant up, and the defendant put the vehicle in park and he exited the vehicle. Officers observed a strong odor of alcohol on the breath, red glossy eyes, and the defendant said he was on his way home from a house party. Standard field sobriety test was conducted, 6 of 6 on the HGN, 3 of 8 on the walk and turn, and 2 of 4 on the one leg stand. DIC was red, and breath was a 0.125 and a 0.129. The defendant was ID'd by his Florida driver's license.
Any prior to the eyes?
No, Your Honor, no criminal history.
Sir, I'm going to find that there's probable cause to go forward with the case. Tell me, do you live in Harris County now, or do you live in Florida?
Yeah, I'll be kind of back and forward.
What's the home base?
Here, Houston.
Okay, it's time for you to surrender your Florida license and get a Texas driver license. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, you will go to jail. We're going to reset your case to give you time to hire a lawyer. So first, I'm going to have you go to Victoria, sign a reset. You will then get with Jace for your bond conditions, and then you'll be free to go. If you like your license, get on it quick. You need to find a lawyer quick. You understand? Come on.
Johnson, come on up here. Page 10, Johnson.
This, Ms. Johnson? Good morning, Ms. Johnson. But didn't we just have Ms. Johnson here?
She came in late last time and told her to come back for the arraignment and to get back.
Oh, okay. Can we just go ahead and give her an application now? Okay, we're gonna give you an application for an appointed lawyer, ma'am. Ma'am, it's not the end of the world. Just fill it out. We'll have you talk with someone today, okay? I think we did find PC on this, all right? We found PC on this one already, didn't we? This is Johnson.
Just for this one, you didn't formally,
We did, yeah.
The note I have on it is that she appeared and he reset for Monday so that we can appoint an attorney and the bond was reinstated.
Guys ready for the next one? Ready for that? Page 10, Johnson Nicholas.
Take a seat for me in the jury box. Take a seat for me in the jury box. Who's next?
Judge, the next one is page 15. Dexter. And Asa.
My deck show. Good morning, Mr. Madexo. You're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. They can or will use against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On June 30th, 2024, officers responded to an intoxicated person call for service where the defendant was taken into custody for public intoxication. While the defendant was being transported, he became belligerent in the backseat of the marked patrol unit by screaming and kicking his feet against the partition. The defendant proceeded with erratic behavior and slammed his head against the partition, causing a laceration on his forehead. The officers removed the defendant from the backseat of the patrol unit to help prevent further self-harm, and the defendant, who was placed on the ground, proceeded to actively resist arrest by repeatedly kicking his feet and rocking his body side to side, making it difficult for officers to control. During that time, one of the officers performed a wrist lock technique in an attempt to control the defendant. The defendant continued to resist, causing injury to the right ring finger of the officer as it got trapped between the defendant and the ground. An additional assisting unit arrived and police were able to restrain the defendant.
Sir, I'm going to find that there's probable cause to go forward with your case. You know, you have a lot of priors. I wonder how many of those priors are related to just that very fact of alcohol and or dope, you know? You know, there's some people, when they get lit, they become happy like little bunnies jumping in the woods. And then there are those that turn into what? Right. You gotta be careful, man. Life's way too short. Just
2 more days, know that I would have been in rehab. I was already volunteering to go into rehab so I can have housing.
It's always a shoulda, coulda, woulda. Now is the time, though, Mr. Madexo. It's gonna happen now. No more alcohol, no more dope. Do you still want to do that?
Yes, sir. Yes, sir. It's in a court. It's in your court.
I want to see it happen. And
Yes,
we're
sir.
gonna either do it your way or we're gonna do it my way. And I promise you, you're not gonna like the way that I do it. I will give you the one opportunity to do it yourself. And I'm gonna tell you now, if it doesn't happen, we're gonna do it my way. You're not gonna like my way. You understand? I'm gonna give you a lawyer today and we will work out how we're gonna do the logistics today. No more alcohol, no more dope. You understand, sir? Now, I don't think he's on probation, right? Did he get early terminated from that probation? I'm showing he's on deferred for burglary of the building, but I think he may have.
Terminated, Judge.
Okay, it's a lucky thing.
I don't know why it stays on there like that.
The problem is that the more you get into trouble with law enforcement, the more they're gonna harass you and harangue you about it. You know what I mean? So look, I'm gonna give you a lawyer today. Let's figure out how we're gonna go from here. No more alcohol, no more dope. Okay. Don't even worry about it. Let's
All right, Judge, the next arraignment is page 20. Preaching.
Is it Prejean or Prejean? Prejean. Prejean. Mr. Prejean, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On July 6, 2024, officers conducted a traffic stop on a vehicle for defective left rear stop lamp. Upon making contact with the driver, they observed a strong odor of marijuana emanating from the car and ID'd the driver by his Texas identification card as the defendant. Officers observed a large plastic bag in the center console containing marijuana, and probable cause search discovered 3 additional bags of marijuana. The total weight was 3.95 ounces of marijuana.
Sir, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
No, sir.
You're not allowed to drive. You will be signing an affidavit with me today, Mr. Prejean. If I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license and insurance. Other than that, if you drive, you are mine. Do you understand? I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria. We'll have you sign a receipt. We'll get you out of here. When you come back, please have a lawyer.
Sir, do not outburst in this courtroom.
Stop.
Page 22 and 23, Robbins, Ashley. Page 24, Savior,
Vic,
come on up.
Victoria, who's this?
Oh, yeah. Okay, page 22, 23, Robbins.
Okay. Are you Ashley Robbins?
Yes.
Ms. Robbins, you are now charged with yet another case.
Predates the prior officer.
How many times she missed court here? Connor, come on up.
Hey, Judge.
I know she's your client, right?
Yes, on the ball holder case, yes. So,
She just missed once on June 5th.
so what happened, Judge, is there was a complaint filed recently about a case that was 2 years ago. And then on that day, we reset her to get her here, and she was unable to make it on that day. And then she forfeited, and then she got rearrested, and then we're here today.
So the possession case was from April. And then right after that one, she picks up a burglary of a motor vehicle.
The DMV is from 2022, but the complaint wasn't filed until one day, until the statute of limitations ran. Yes.
Yeah, you're right. Have we found probable cause on it? Do you know?
I don't think so, Judge.
Okay, so Ms. Robbins, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're also charged with possession of controlled substance. You're facing a year in jail and or a $4,000 fine on both of those cases. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So I guess start with the burglary case if you don't mind.
Officers conducted a follow-up investigation and found that on May 23rd, 2024, the defendant had been identified as entering the complaining witness's car without her consent. The officer spoke with the business owner, who provided a video and photos of the incident, which were then matched with the defendant's Facebook photos, which was provided by the complaining witness. The video showed the defendant entering the passenger side of the complaining witness's vehicle, removing items and getting into another car. And I apologize, Your Honor, it said the wrong date in the summary, but it's 2022.
So that is because I was. Okay. Did they get the property back?
We haven't made any meaningful contact.
Okay. Now, can we go ahead on the other case? Do you mind?
Officers conducted a traffic stop in Harris County, Texas, because the vehicle had a headlight out. The officer asked the driver for consent to search the vehicle. Consent was given. While searching the vehicle, the officer located a black purse that belonged to the defendant, who was the passenger of the vehicle. The officer asked the defendant for consent to search the purse, and the defendant gave consent. Upon searching the purse, the officer located a Rexall pill bottle that contained 2 white pills that had the imprint of M367 on it. The officer, from his training and experience, identified the pill as hydrocodone pills and detained the defendant, and the total weight was 1.3 grams.
And I'm going to find that there's probable cause to go forward with both of your cases. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication, and not to have any contact with the complaining witnesses in the burglary case. Do you understand your conditions? If you violate these conditions, if you consume alcohol or dope, I'm going to put you in jail. If you show me that you can't stop, I will put you in a rehab facility. Do you understand? So you can either do it your way. If that doesn't work, we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Just for reference, what is the name of the complainant?
It is, his name is James Whitehouse.
So Tracy, if you can do the conditions on the burglary case, please. No weapons, no alcohol, no drugs, no contact with the complaining witness. Ms. Robbins, it is your responsibility to stay in touch with Connor. He will tell you when you have court. I'm not going to put up with any flight. You take off on us, you don't show up again. You will be, I'm going to revoke your bond. You will not get any more PR bonds. You understand, man? The only thing we're asking you to do is come back and stay out of trouble and don't use anything you're not supposed to use. All right. For now, I'm going to have you go to Victoria. We'll have you sign a reset, and then you'll meet with Tracy for your bond conditions. All right. Thanks, Connor.
Page 24, Sager, come on up.
Mr. Sager. Yes. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On July 7th, 2024, at 1:25 a.m., officers responded to a minor accident call for service and met with a complaining witness who was stopped on one of the eastbound main lanes of the East Freeway. As the complaining witness was stopped, the defendant struck her from the rear on the left side of her vehicle. The complaining witness advised she saw the defendant drive and he was the sole occupant, and she saw him exit the driver's side door. Complaining witness advised that the defendant began to apologize to her, and during the conversation, he mentioned he was intoxicated. She recorded a voice memo of this. Officers observed the defendant to have a strong odor of alcohol on the breath, wet red eyes, and refused to answer any questions or participate in the standardized field sobriety test. The IC was read, blood warrant was obtained, and blood was drawn.
See if he has any prior to the eyes, please.
Yes, sir.
Sager. Great. Mr. Sager, I'm going to find that there's probable cause to go forward with your case. Do you have valid liability insurance in your name? Okay, as long as you have that and no license, you can drive. No more alcohol, no more dope. I'm going to randomly test you. If I find that you're consuming either, I will put you in jail. No more PR bonds for you. We're going to reset your case to give you time to hire a lawyer. So I'm going to first have you come up to Victoria, sign a reset. After that, you'll eventually get with Tracy for your bond conditions. And after that, you're free to go. Don't pick up any new cases. Don't drive unless you have a license and insurance. And above all else, no alcohol, no dope. You understand? Okay, come on.
All right, Judge, page 28, Wazer.
Good morning, Mr. Slater. Sir, you're charged with 2 cases. You're charged with possession of marijuana and unlawful carrying of a weapon while intoxicated. You're facing up to a year in jail on the intoxication case, and you're facing up to 6 months in jail on the weed case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 5th, 2024, officers conducted a traffic stop for an expired registration sticker. The vehicle was slow rolled until it came to a parking lot of a Shell gas station. Upon contact, officers smelled the odor of marijuana and gray smoke emit from the vehicle. The defendant was the driver. A probable cause search located a black Ruger pistol behind where the radio screen is, and the gun was loaded with a bullet in the chamber. In a small storage bin under the steering wheel was 13.37 grams of marijuana in a saran wrapped bag, and the defendant admitted to owning the pistol, but said he did not know there was marijuana because it's his girl's car.
He's driving? So you charge him with unlawful carrying of a weapon while intoxicated, but he's not charged with the DWI, and he's charged with the weed. What's the sense in that? Hey, did you see this? Look at Swayzer.
Sorry,
It's okay.
this question.
He's in a car,
Okay.
he's driving.
Okay.
They charge him possession of marijuana. They charge him with unlawful carrying of a weapon while intoxicated, but it's not a DWI. I don't understand. I mean, how do we get to the intoxication? Tell me how they find intoxication.
Let me see.
There was no standardized field sobriety test. So
Judge, we charge him with the UCW while possessing marijuana. If you look at the charging instrument, it's just straight UCW. We didn't charge him. I know it's titled that in the thing, but if you look at the charging instrument, it's just straight UCW.
Because it shows here while
Yeah,
intoxicated, so.
it's showing like that on my end, but the charging instrument itself is straight UCW. Possession of marijuana. So
I can't get anything to work. Is yours? Is Deeds down for you? Can you pull up the charging instrument? Because I can't pull it up here on Swayzer. On the intoxication. Like, you can pull up the information. Mr. Swayzer, the system's not working, and I want to make sure that we don't overcharge you. So for now, just take a seat for me at the juror box. When I get it working again, I'll pull you back out. It's okay.
There's one seat left in there, but.
Okay.
Your Honor, are you-
Yeah, I want to make sure that it's not, because I can't pull anything up. Yeah, come on. Thanks. Okay, Mr. Swayzer, coming up. Okay, so it's not while intoxicated. I'll read this to you now. It says, the defendant heretofore on or about July 5th, 2024, did then and there unlawfully, intentionally, and knowingly carry on and about the person a handgun in a motor vehicle under the control of the defendant, and the defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic, namely possession of marijuana. So that's what the charge was for. Okay, so I just wanted to make sure that it was an intoxication because they didn't give me any indication or any kind of evidence of intoxication. Otherwise, I would have found a probable cause. So being that as it is, I will find probable cause on both of your cases now. Tell me, do you have a Texas driver license, Mr. Swayzer? Then you're not allowed to drive. And I'm making that now a condition of your bond. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. I don't care what you're doing, where you're going, what you have to haul, what baby needs saving. If you don't have a license and liability insurance, do not drive. Do you understand? We're going to reset your case to give you time to hire a lawyer. So I'm going to first have you come up here, swear to us that you're not going to drive. Hold on. After that, I will get you to Victoria. We're going to have you sign a reset. When you come back, please have a lawyer, sir.
All right, Judge, page 22, Flores.
This is Betania Torres.
Yes.
Ms. Torres, you're charged with driving while intoxicated. You're facing up to a year in jail and a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On August 3rd, 2021, officers were dispatched to a single vehicle crash. The defendant stated to the officers that she was driving the vehicle at the time of the crash. Officers observed a strong odor of alcohol, slurred speech, glossy eyes, and the defendant appeared unsteady on her feet. Standard field sobriety test was conducted, 6 of 6 on the HGN, 7 of 8 on the walk and turn, and 4 of 4 on the one leg stand. POC was read and breath with a .186 and a .189.
Now, she was in another county on another DWI, right? How many DWIs does Ms. Torres have?
I have that this is her first, but
That's not right, because she had another DWI. Or was she in a PTI with this case? Is that what it was?
This case was she was a DWI PCI.
And I have that Eric Garza is representing her, is that
I
right?
sent him an email yesterday to ask if he was still representing her. I didn't get a response.
Okay, ma'am, I'm gonna find that there's probable cause to go through this case. I'm ordering you to obtain a handheld interlock device that you're gonna take with you everywhere you go to prove to me that you're not consuming alcohol. Do you understand? Yes or no? And I'm gonna tell you now, if you ever take off on me again, I'm going to triple the bond. We have tried to get you here over and over, over and over and over and over and over. That's why your bond is at 15,005. You miss court again, I will triple, if not quadruple. You understand? Take a seat. I need her to take a seat somewhere so I can find out what we're gonna do with the lawyer situation. So take a seat for me there. Do not leave, man.
All right, Judge.
Your Honor, on that case, there was an attorney that talked to me earlier, so I don't know.
Was that Fleming? Who was it? Or
I'm
no?
not sure, to be honest. But I believe she may have an attorney because he spoke to me.
Right, that's what we're waiting. Take a seat. Do not leave, man. Come back.
Hey, Judge, that's it.
Okay, John D. Hey.
Just want to talk to you about 3 cases. 2 are on the docket today. And 1 is a trial case next week. Today, we have Miss Montiara Robinson, which I don't know if you remember, but she was the one that we pulled teeth to get her on the PTI program. And last week, there was a notification that she's been kicked out of the program for non-compliance. The courts put her on the docket for today. Every contact information that I have with her is no longer. I tried to get her here. She's obviously not here, Judge. So
it's okay. I'll set it at 5,001.
Okay.
What's next?
The next one is a late appointment yesterday. Mr. Sorrell, S.O. He was in custody yesterday. We rolled him over to today, but he's out. So I guess I don't know if he's going to make it here, but
No, from what we
Did I
understand.
keep this?
Paid.
He paid it? Okay, so good deal.
You verified that he paid?
He was released and the release reason said paid fine.
Okay, so that's over.
And then lastly, Judge, the trial case that was postponed to next Tuesday, Mr. Eric Sukwu, I finally chased him down and we'll be putting out to a time serve on that. The only malfunction is I can't get him here on Monday because I'm out of county, so we got to do it Tuesday morning. I have to be, I'm trial setting down before bench. So we'll take care of that on Tuesday morning. Just want to give you a heads up on it.
Okay, thanks, John. Thank you. Thanks. Mr. Slider.
Judge, how are you? Here on Angel Jackson. Bond violation.
Ms. Jackson.
She's in the fuchsia. or
Ms.
the-
Jackson,
Page 9.
come up.
Good morning, sir.
I'm not happy with you, Ms. Jackson. You have bond violation after bond violation after bond violation. You were ordered not to consume alcohol. You were ordered to get a device and blow into the device, and you're trying to fool us. What's this look of bewilderment that you have? Just lighter?
Judge, I met with Ms. Jackson yesterday. She's acknowledged that she made a few mistakes. Wants court to give her another chance. Says she will comply with the rules of the monitoring.
Her attitude tells me something completely different.
Let her just tell you directly.
No, sir. I think what I explained to my attorney yesterday is I believe that I may have a problem and I didn't get the opportunity to like get any additional support. I acknowledge that.
So something has to change because what we're doing now is not working.
Yes, sir.
So what has to change? What are we going to do?
I need support. I need to go to some type of meetings in order to help me with my urges. Honestly, I'm a single mother. I do things. I recently just moved. I've been trying to grow in my life, and then that I've been stressed a little bit, and that's what's causing me to consume.
How many kids you got?
I have one child.
How old is that child?
He's 9.
I see that child.
Me, full custody.
What happens if you go to jail?
His father would take him. I don't think he would like that though.
Well, let me ask you this: do you get along with the father?
I do.
Do you have a custody support arrangement or
So
what?
we just co-parent.
I've advised her maybe start trying to go to AA.
No, it's not going to start. It's going to happen, and I want 90 AAs in 90 days, and I'm going to bring you back in 2 weeks, and I want to see that you've got 14 done. And if you don't have it done, guess what's going to happen?
Go to jail.
Correct. And I'm now modifying your conditions. I'm giving you 1 day, and I'm going to put an ankle monitor on you so I know that you're not consuming alcohol. I'm going to modify the conditions with a scram on her ankle so I know that she's not trying to fool us again. Ms.
She'll turn in
Jackson,
the current blow device and put the scramble.
correct.
We'll
If
pay
you
for
fool me
that.
one more time, if you try to play me for a fool, you will go to jail. I will not give you any more chances. The only way that you will remain out now is if you're doing AA classes on a daily basis to prove to me that you're trying to take a proactive approach to staying sober. But the next time, you will go to jail. I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. And I'll do it in a heartbeat. Do you understand, Ms. Jackson?
Yes, sir.
That's what you have waiting for you. And I don't care where you come up here and try to say where the alcohol came from. I don't care if it's a tequila lollipop, a buccal swab. I don't care if it's isopropyl, hair dye. I've heard it all, and I will not entertain any excuses from you. Mouthwash, I don't care. Do you understand?
Yes, sir.
So let's reset this thing 2 weeks from today. She has 1 day to get these, or she has until Monday to get this gram device on her ankle.
The court will pay for that, Judge.
Of course.
Thank you.
Thank you, Your Honor.
Can you excuse, Judge?
Sure.
Judge, real quick on waiting serious. I saw you said no driving.
No, no, just no driving and then get them out for THA.
May I approach on?
Yes, but let me just, I have to make it documentation so I don't forget my conversation with her real quick. So give me 2 shakes.
No, it's
Trinidad.
Yeah, I'm here on Timothy Madek show.
Oh, Madek, okay.
Yeah, so he's, I don't
It's
know.
too loud.
Okay, review probable cause. I think a little more context needs to be. He's at the location to turn himself in to try out. And he gets into it with them, and that's when the cops come in first. I mean, that's what you.
They arrest him for PI. He's under arrest for public intoxication, and then he lets loose on them. He starts banging in the car, banging his head on the window. And then
He doesn't have just an addiction problem. He also has some psychosis as well. So, I mean, we're at a medical facility trying to treat this man. That's what they're built for. And I think there should be a little bit more discretion on the part of the officer when they're dealing with these types of situations. Some of them binge out. Some of them get loaded. I mean, they shoot up just before they go in. I mean, This is what they deal with on a daily basis. For them to turn around because he's a individual that's more difficult to deal with, shit, that's what they get paid for. That's what they get the hazardous duty paid for. And for us to, you know, if he's seeking help for himself, he's 12 days out, he's got 14 days to turn himself. I mean, they give him 14 days to try to drive himself.
What do you want? What are you suggesting? What do you want?
I know that you want to resolve this, and I know that he's an approach.
No, I told him I want him to, he told me that he wants to go into rehab. And I said, I'm down with it. So I told him we can do it. I will give him an opportunity to do it his way. And if that don't work, he's going to do it my way. So come up, Mr. Medecio.
He's on the outside. He's with Glory
He
right
said
now.
that he had something with Senate set up.
He did.
So
he binged out 2 days before. That's why he just really rocking
now-
around when he got, he doesn't even remember the incident. So I mean, I can't even discuss it with him. He doesn't even remember it.
I'm now making it a condition of his bond that he has to go to this place and get it done. So what I'd like to do is bring him back. No.
If he's in there, what he's gonna be doing?
Trinidad. If he's in, then of course I'm gonna give it to him. But I'm not giving him a long reset now in hopes that he gets in for me to trust him. Hell no. No. First, show me what he's done. Bring paperwork showing that he's got an appointment. Once we can verify that he's in, of course I will give a long reset. I'm not gonna take him for his word. It's not reasonable. Yeah. Did you have something?
No, I couldn't hear the conversation.
I was gonna drag him in. I wasn't gonna drag him.
So Trinidad,
I can help.
let's say comes back in 2 weeks and I want to see what he's done. If he hasn't done anything, tell him to get ready to stay with me.
Okay.
Bring his whites.
If he's in custody, I'm not gonna try. I mean, if he's already in the program, he's in there, it's inpatient, I want him to get dried up.
History is any indication.
Yeah, correct.
Know what I mean?
Correct.
So I'm not taking him for his word.
Hey, man, Judas ate too, but I mean, I'm just telling you, Judas ate. He ate too. I'm gonna help him out. I'm gonna like it.
Gotta be back here with proof. For sure. Yeah, come on. Hey.
Mr. Padilla.
Did you get, do they have the cause number, Ms. Garza? You have it? Oh, it's on document. Okay.
Yes, sir. He was supposed to appear today.
Correct.
Unfortunately, he's still in immigration custody. His hearing is on the 16th, Your Honor. The exhibit on that motion should attest to the fact that he's still in
You still
immigration.
have
Yes,
He's in?
Yes, sir. So he does have a hearing on the 16th. We're hoping to get him out or at least get a bond. I leave it up to the discretion of the court, but I would request that on the 8th.
Of course, if he's in ICE custody, I'm not gonna revoke the bond. I just want to make sure that he's there.
Yes, sir.
Right. Is this the same document you gave me last time, though?
I think this is another individual, Your Honor. I may be mistaken, though. I did speak with my office to make sure it wasn't the same individual, but they make mistakes sometimes.
If it's the same document, I wanted like an updated one to make sure.
Yes, sir.
I think this is the same thing. Because you were here when was the last time you were here?
I believe I was here about 2 weeks ago, Your Honor.
This was filed on 7/2 and you were here on 7/3, so this is the
Okay.
same document.
Yes, it must be the same.
This is not the same.
Yeah, what
So-
must have happened, Your Honor, is that the immigration court must have had a hearing earlier this week, and because of the hurricane, it must have gotten canceled and moved to the 16th, Your Honor.
Can you go back to this website to just see if you can get an updated copy just to make sure that he's in? And if he's in, then I can.
Yeah, I could do that, Your Honor. The only problem I'm having right now is that my laptop's busted. Like for the hurricane, something happened with the outage. The hard drive's broken. I can't bring it up right now, but I could ask my office to file something.
Okay. Or perhaps on your cell phone, if you know what the website is,
Yes,
just
sir.
look it up or tell me what it is and I'll look it up.
Yes, sir. Thank you.
Here. Yeah, I'm not resetting it. I want to make sure that he's still in ICE custody. Okay. For sure.
Good morning, Your
How do you
Honor.
confirm me?
I have an off-docket matter, cause number 2518178. Luis.
Friends, I need to go to bed soon because I need to wake up early to try and figure out how to do all the redacting and whatnot of the witchcraft trial. I've got about, I want to say 9 hours of editing to do before 4 p.m. and a house to clean. So I'm going to let this guy go while I do a redirect. Yeah.
Salazar. It was an arraignment we did yesterday, and he had a condition for no driving because he did not have car insurance.
Okay.
Now have car insurance. I have proof on my phone.
You're an officer of the court. Have you seen it?
Yes, I've seen it.
You're able to verify that it's,
Yes, sir.
I trust you.
All right, thank you. And that's all we have today. And he is here present if you need to do any admonishments or anything.
All right.
You're good to go.
All right, thank you, Your Honor.
Thanks.
Davis, Ben,
They weren't calling your name. They said your name, but they weren't calling you.
I signed his conditions, right?
Thompson?
No,
I appreciate it.
I think everything's,
Davis, Ben?
Judge, can I approach you a second?
Come on up, sir.
give me a second, Harold. I have other people waiting in line. Josh, hey.
can't tell if RA is wrapping up, but I'm gonna portal you there. So I will see you in chat there, and then I will see you tomorrow at, what was the time again? 10 a.m. Central. Is that what it's called? I'll see you at 10 a.m. America time. You can figure out what time that is. All right, thanks for hanging out. We watched a lot of court today. 10 a.m. Eastern. That's the time. 10 a.m. Eastern. I'll see you then. Bye.